Good evening. Welcome to the monthly meeting of the Arlington Board of Zoning Appeals, which is also known as the BZA. I'm Judy Freshman, Chair of the Board. The Board's made up of 5 citizens appointed by the Circuit Court. In addition to myself, we have Charles Smith, Inta Malice, Paul Melnick, and Peter Owen. Also present is the professional staff, including Stephen Rissy, Coordinator for the BZA, Arlova Vaughn, Zoning Administrator, Simon Keynes, Administrative Technician, and Minchao Kaur, Assistant County Attorney. We thank you for being here and extend a warm welcome. To avoid disruptions, we ask that you please turn your cell phones or pagers off or put them in silent mode. On the front table, you'll find copies of the staff report for each case before us this evening. I recommend that if you've not yet seen the report for your case, that you get a copy and review it before your case is called. The Board's powers are prescribed in the Code of Virginia and are set out in further detail in the county zoning ordinance adopted by the County Board. The Board of Zoning Appeals does not have the power to rezone property or to amend the regulations set forth in the ordinance. That authority rests with the County Board. This Board does have the authority to do 3 things. We can approve use permits that allow modifications of placement requirements for structures on 1- and 2-family lots where there is no option in the zoning ordinance to allow such modifications. We can grant variances from the specific requirements of the zoning ordinance, and we can decide appeals of decisions of the zoning administrator. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary in the public interest, including limiting the duration of the use permit. In order to approve a use permit, the law requires that the Board find that the proposal meet conditions and that the use permit will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not be in conflict with the purposes of the master plans and land use and zoning related policies of the county. To do this, the BZA shall consider whether the modifications will promote compatibility of development with the surrounding neighborhood because the structure's overall footprint, size, and placement are similar to the structures on the properties surrounding the lot in question, and whether the modification will help preserve natural landform, historic features, and/or significant trees and foliage. When granting variances, the burden of proof is on the applicant to prove by a preponderance of the evidence that it meets the following criteria. The strict application of the terms of the ordinance would unreasonably restrict the utilization of the property, or granting the variance would alleviate a hardship due to a physical condition relating to the property or improvements thereon, and the property for which the variance is being requested was acquired in good faith and any hardship was not created by the applicant. That the variance granted will not be of substantial detriment to adjacent property and nearby properties in the proximity of the geographic area. That the condition or situation of the property concerned is not of so general or recurring a nature as to make reasonably practicable the adoption of an amendment to the ordinance. That granting the variance will not result in a use that is not otherwise permitted on the property or change the zoning classification of the property. That the relief or remedy obtained through the variance is not available through a special exception process as provided for under the zoning and/or subdivision ordinance. When deciding appeals of the zoning administrator, the Board must use its judgment to determine if the administrator was correct. This evening, cases will be called and a brief staff report and recommendation will be given. Following that, Board members will ask any questions of the staff they may have. Next, applicants or their representative will be given an opportunity to make comments to support the application or appeal. If they choose to make a comment, they must come forward to the podium so their comments can be recorded for the record. Next, all speakers for the item will be called. Speakers must fill out a speaker slip, which is available on the table in the front of the room. After we hear from speakers for and against the proposal, the Board may permit the applicant a brief opportunity to clarify any points. The Board may ask questions of any speakers, but does not permit and will not condone any cross-examination or direct questioning by others. We've deemed the following time limits for speakers to be sufficient. 20 minutes for appellants in appeals, 5 minutes for applicants for use permits and variances. We've deemed 3 minutes for representatives of organizations and 2 minutes for individuals as sufficient. And as an aside, I would say this is a very full agenda, so we will strictly adhere to the time limits. After the board has gathered all the information they need and discussed the case, it will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. After your case of interest is heard, you're welcome to stay for the balance of the session or leave at your convenience. Again, thank you for being here this evening. Please call the first case.
Yes, case number V-11329-17-APP-1 is an appeal by Verizon Virginia, LLC of the zoning administrator's determination dated August 24, 2017, that the property containing 62,556 square feet of gross floor area houses a use most like manufacturing, processing assembly, storage, warehousing, and or wholesale, and therefore requires a minimum of 63 parking spaces, and that this minimum required parking cannot be reduced through a use permit amendment, in the R6 zoning district premise known as 6700 Lee Highway. Staff recommends that the Board of Zoning Appeals make the findings in the attached resolution and affirm the zoning administrator's determination that the use of the subject property is a use most like manufacturing, processing assembly, storage, warehousing, and or wholesale, and therefore requires a minimum of 63 parking spaces for the 62,556 square foot building, which cannot be reduced through a use permit amendment.
Questions for the staff?
Madam Speaker, or Madam Chair.
Mr. Owen.
My first question is procedural. Does this action require, does this action require notice to abutting neighbors?
Yes, and it was done.
And it was done?
Yes.
Okay, great. Is CPHD currently considering recommending any zoning ordinance changes that would affect this property?
No.
Okay. And the reason I ask that is because there's an allegation that there was planning done to this sector, and oftentimes it takes a few years for zoning changes to be implemented, but there's nothing in the works.
No.
I think that is... I have other questions, but I'll withhold them for later.
Madam Chair, I just had a few points I wanted to make that might
Please.
be helpful. First, just wanted to clarify that the appeal has two components, is with regard to the determination of the parking requirement for the telephone switching station, and that the required parking cannot be modified by use permit amendment. For background, the property received a use permit for a telephone switching station in 1972. Originally, it was amended in 1985 to allow an expansion of the number of employees. And at that time, the county board granted the use permit amendment, requiring actually more parking than what the ordinance required. Earlier this year, the appellants asked for a determination regarding their ability to lower the parking requirement, given that the business and how it operates has changed since 1985, and there are significantly fewer on-site employees. Based on the documents and materials submitted, conversations with the appellant, and a site visit to the property, I determined the most similar use type for the telephone switching station is consistent with how it's been viewed in the past, and that's the type described as uses consisting of manufacture, processing, assembly, storage, warehousing, wholesale. Article 14 of the zoning ordinance contains a list of use types with associated parking requirements, and this use type requires one parking space per every 1,000 square feet of floor area, or one space for every 2 employees, whichever is greater. For the subject building, which is approximately 62,556 square feet, the minimum requirement is 63 spaces. With regard to the use permit amendment question, longstanding interpretation is that the site plan process allows the greatest flexibility for modifying use regulations and parking requirements. This is supported in ordinance language, both in the parking article, Article 14, and in individual articles describing site plan uses in general. Further, the zoning ordinance explicitly indicates where the use permit process may be utilized to modify parking in Article 14.3.7c and elsewhere in the ordinance explicitly for URDs and UCMUDs. While the county board does have broad legislative authority in land use matters, the board has adopted the zoning ordinance to define how, when, and in what manner it will exercise its power. And with regard to use permits, this power has been narrowly articulated. As a result, I've found that the use permit process does not permit modifications of required parking in this instance.
Ms. Miles.
Does the zoning for this site permit a site plan?
I believe this is R6. I can't remember. There may be some, in the R districts, there are some that allow either townhouses or office uses in residential buildings. It's very limited, if at all, but I can tell you in a minute.
If that were the case, then the site would need to be rezoned in order to
Yes,
have a site plan.
exactly.
Madam Chair,
Mr. Owen.
is this parcel eligible for any rezoning, or must it stay R6?
I believe the GLUP is also low residential, so it depends on what district it would probably require a GLUP amendment as well. Depending on what use is sought and what district they're trying to rezone to, I think the GLUP says low density residential.
But R6 is not the only low-density residential category.
Right.
So they might potentially
Go to a different,
different R district,
Right.
for example. Okay.
Ms. Vaughn, can I also ask if you, given that you raised two issues just now, I'm just looking ahead to the draft of the resolution, which really only addresses the minimum parking requirement. So does that mean that when we get to that point, that might need to be expanded?
we have if need be, we have prepared a revised draft resolution, so
Excellent. Thank you.
distribute it.
Madam Chair,
Mr. Owen.
the two issues you described are, one is which row of the parking calculation should be used, and the other is the extent of the county board's use permit powers. Would you agree that our determination on the interpretation of the county board's use permit powers is a question of law and not of fact?
Yes, but I'll defer to the county attorney if you have further inquiry on that.
Okay,
Yes,
yes,
we
you
would
agree
agree.
it's of law enough. And what about the determination of which category, which row should be used in the table? Is that a question of fact or law?
I believe that's a question of fact.
Question of fact. Okay. And are you asking the BZA to make any subsidiary factual determinations, or can you identify what evidence we should take into consideration during the course of this hearing to arrive at that factual determination?
I think we have sufficient evidence in the application packet that was submitted and also the zoning administrator's site visit. She gathered some facts about the use. As far as whether you think findings need to be made, if you're asking whether they need to be made in the form of a resolution, we have prepared a revised resolution for that purpose. I don't know that it is absolutely necessary. There's at least one case from Fairfax that said that in the absence of such findings in an actual resolution, the court will simply look at the record and determine what are the questions of fact and what are law. But it would be very helpful if you would make factual findings, and we have prepared some very simple and I think non-controversial ones.
Okay. Part of the reason I asked that question is that there was a case that in the last 2 years where we adjudicated a zoning appeal, and then when it got to circuit court, there appeared to be ambiguity in the circuit court's eyes as to whether or not we had made a factual determination or not. So it seems to me sometimes it can be helpful to be clear.
Yes.
Thank you.
Are we good?
I just wanted to respond to, the only site plan option that appears in the R6 is for transitional uses of office spaces in existing one family detached dwelling, so it's very narrow.
Thank you. We hear from the applicant, please, Mr. Lawson.
Thank you, Madam Chairman. For the record, I'm William B. Lawson, Jr., and I represent property owner of this property, which is Verizon. At the beginning, I want to tell you how much I respect the zoning administrator. I truly do, but I have to zealously represent my client, and so I'll be doing so. The first thing I want to do is share that I object to the staff report saying what our position is. I would respectfully say that we have our own position, and we'd like to state our position rather than the staff stating our position for us. There are two grounds of this appeal. One is we believe the clear language of the ordinance allows the county board to modify the required parking by use permit, and we also think the most similar use is storage and not manufacturing. The first thing I want to do is discuss the language in the ordinance. The language in the ordinance says, except as may be allowed by site plan or use permit approval, said requirements shall be deemed to be minimum requirements. And that's the requirements that come after this section of the zoning ordinance. I consulted with a former assistant county attorney of Arlington, and his opinion was that did give the county board the authority to lower the parking. The position that the zoning administrator is currently taking is that unless there's something that specifically says the county board can modify this, and that includes parking, then the county board cannot modify that. I would respectfully suggest that that's not always been the case, and I would like to give you all a copy of a determination we got from the prior zoning administrator, who said the opposite, 180 degrees opposite, since there is no specific language prohibiting the modification of the structural clear height. It is a determination of the acting zoning administrator that pursuant to the above, the county board may modify through the use permit process. And then it goes on and describes what the county board can modify. As to the specifics of the use, when I was trustee at Westover Baptist Church, Swanson desired to use our parking lot, and that generated an ordinance amendment that allowed off-site parking for certain kinds of uses. We've done it for the swim club over in Dominion Hills. We've done it Mount Olivet Church did it. It was done at Westover Baptist. And the point that I think I need to make about the ordinance is that these are for off-site. And, normally it has to be on the same site. However, the county board, by use permit in those specific instances, can reduce that parking and allow you to park at the swim club or at the church across the street or wherever. I think our situation is very different, and I think what you need to do is look at what's going on inside of the building. The most similar use is probably data processing, and that would be the most like a switching station. However, that's not in our ordinance, and so then we've got to look at what is the most similar. The zoning administrator has hung her hat on, so to speak, the fact that the storage has to be open to the public. And that's part of the definition, but that's not the use. And the use is what's going on inside there. And, you know, decades ago when this use permit was approved, you had the situation like Lily Tomlin, where she was the operator, and so this building was full of people. And you had people coming and going, you had day shifts, night shifts. And through the years, that's all gone away. None of that is happening any longer. What you have now is that the equipment just sits there and automatically does what it does. You have batteries that are there in case there's a power failure. You have the actual switching. You have the FiOS. And you may have 2 people there. You may have 3 people there. Occasionally, somebody will come by to fix something. Just like in self-storage, occasionally somebody comes by to get something or deliver something. I've done 3, I think, self-storage facilities, and even with that minor, that very minor amount of parking being required, 1 per 3,000 square feet, even that's not hardly ever used. There are 3 switching stations in all of Arlington County. There's one in Crystal City, Pentagon City. That's under a site plan, and that has a requirement by the county board of 8 spaces. The Clarendon facility will go under the site plan at some point in the future because of the way the Clarendon plan is set up, and the fact that probably what will happen is that there'll be a transfer of density from that switching station elsewhere in the Clarendon area. So the only property that's going to be impacted by whatever we decide tonight is this one property, this East Falls Church switching station. There's no other switching stations in the county, and so your decision will only impact this one property. This property was replanned recently with the East Falls Church plan. Now I'm going to hand out what it provides for this property. I was involved in that replanning process on behalf of Verizon, and we had other people that got the grand tour like you did and got to see all the batteries and everything. And one of those people was a gentleman by the name of Mike Nardalilli, who was president then of the East Falls Church Citizens Association. And I'll go ahead and hand this out at this time. And where it describes Verizon is here on the right. And here's our switching station, this gray building. And then you can see townhouses on what is now the parking lot. And the Verizon, here's what it says. The Verizon building is anticipated to remain in use for the foreseeable future. There is millions and millions of dollars of equipment in these switching stations, and you just can't move them. However, the rear portion of the lot, which is a largely unused parking lot, has potential for redevelopment. And then it talks about townhouse or low-rise multifamily development. And so as you can see, the goal is to have townhouses there, but we can't do that unless we can free this up from the requirement of providing the 63 spaces to a switching station that never will ever need 63 spaces. There's just nothing that goes on inside of it. And it's just not logical, in my opinion, to require 63 spaces for a use that only requires at most ever 8 spaces. So for these reasons, we would respectfully request that you all overrule the zoning administrator. Thank you.
Questions for Mr. Lawson?
Madam Chair?
Ms. Malice?
Several questions. If we were to overrule, and this may be for Mr. Lawson or staff, if we were to overrule the zoning administrator, what what would change?
Oh, we would go get a use, we would file for Verizon would probably sell the parking lot to a developer, and at the same time, we would file for a use permit to reduce the required parking of our Verizon facility. We've had some meetings with the planning staff, and they indicated that they might require us to do some things like having a pedestrian cut-through, which is okay with us, maybe redoing the streetscape along Lee Highway. But what we would like to do is sell the parking lot to a developer, let them file for a site plan, and then we file for a use permit to reduce the required parking to free up our parking lot.
So, but the main thing is that if we were to overrule the zoning administrator, you would be free to ask for a use permit.
Yes, ma'am, and to reduce the parking via that use permit.
Power? Do we have that power to, I mean...
To say yes or no that she's right or wrong, that's the power we have.
Because okay.
But I think you could say that...
Now, let me ask another question. So right now, you have been prevented from filing a use permit? Have you attempted to file a use permit?
No, ma'am, we have not. We wanted to get the determination first before we sell the property.
And the question of staff is, if Mr. Lawson filed for a use permit, would you reject that?
Right now we would, because the position is that it can't be amended by use permit. I suppose if this board were to overturn the zoning administrator's determination and determine that it could be modified through use permit, it would go to the board, and at that point, the board can decide whether it's allowed to hear it by use permit.
The board would decide whether they had the power.
Well, I mean, neither the zoning administrator or the Board of Zoning Appeals can compel the board to hear a use permit.
All right.
We'd be punting.
And my next question is, in regard to the parking requirement, staff has stated their position, and you have stated an alternative in terms of most similar use. If we were to make a finding of fact, I would think we'd want to look at all the choices to determine if we think that there's a third or fourth or fifth alternative that is superior to either yours or the staff's opinion. I'm not sure that we have the material in front of us to make that decision at this time. I would be uncomfortable with just choosing between A and B, not knowing that there might be C, D, and E that, in our view, would be more appropriate.
Other questions?
Madam Chair.
Mr. Owen?
Do you agree, Mr. Lawson, that we have one finding of fact and one finding of law tonight?
I think the first one about whether or not the county board can hear it is a question of law. Mm-hmm. I think the other is a combination of both. I think it's fact and also law. I mean, you're doing both. You're saying, okay, factually, if you go my way, factually, we think this is most like storage, but then you're also interpreting the ordinance in order to get there.
Do you have any proposed, on what evidentiary basis do you think we should arrive at our findings of fact? What's the evidence that you think we should consider in reaching findings of fact favorable to you?
Well, I think what you would look at is, what's going on inside of the building. If you're doing manufacturing, what's going on inside of the...
How do we know what's going on inside we haven't been to the building. So
right.
What's the
you
evidence?
Haven't been to ours.
Right. So what's the evidence we should consider in making that evaluation?
Well, what do you commonly think happens in a place where you manufacture, assemble, wholesale, versus what's happening in a switching station versus what's happening in a self-storage?
Do you have any testimony or written evidence that we should consider that describes what goes on in those facilities?
No, but you all are welcome to make a site visit.
Thank you.
It's very interesting.
Another question, Mr. Lawson. The code has been revised substantially since the last use permit was issued for this site. And I'm curious if you have a view as to whether or not before the reorganization of the code, do you feel this was a clearer question under any previous drafts of the code?
No, because switching station has never had its own parking requirement.
What about the question of the board's power to modify parking under use permit? Was that clearer under the old organization?
I think it's the same under both.
Okay. I have additional questions, but I'll pause for now.
Madam Chair,
Mr. Smith.
kind of following up a little bit on what Mr. Owen was saying, I'm always uncomfortable making findings of fact in appeals of zoning administrator determinations for, I think, basically the reason that that was inside of Mr. Owen's question. What evidence is there? We don't really have any. And there was a statement I heard earlier that the zoning administrator, I think it's in the materials too, went to the facility, but there's no affidavit from the zoning administrator here. There's a report, but it's not evidence. So I'm always uncomfortable making findings of fact, or attempting to, or being asked to adopt those that have been allegedly made by others. But I'm always comfortable making a determination, voting as to whether I believe that the zoning administrator was right or wrong, whether I agree with the decision that the ZA made. Now, I kind of been following up on, you said that it is more like a storage facility, like public storage or U-Haul facilities. And I look closely at the language because I don't think it fits as it's not manufacturing, it's not processing as processes described in, say, in patent trademark law. It is a difference, an evolutionary difference in terms of technology and government and laws not keeping pace with changes that really make government laws obsolete or less or minimizing. Because this is a pure case. But I have to imagine, and I'll wrap it up with this, that out in either Loudoun or Fairfax with those big facilities that are, but they're probably all in commercial zoning districts, and so they probably all went through site plans. And the odd thing here is that we have a commercial facility in an R6 district, and we're so constrained. I mean, Ms. Malice put forth the real limitations that are available through site plan in R6. This is a commercial facility that doesn't require a lot of people, doesn't require the Lily Tomlin's pulling plugs.
Right, that's all gone.
And manually switching. And so a handful of folk are there basically making sure everything's cool and running and calling for backup, for help when things fail. That's the extent really of that operation. And that can even be sensed from afar, from thousands of miles away, actually. There's so few people needed now to monitor. So I guess I'd like to find that, and I have respect for the zoning administrator and the county attorney's staff too, that they're wrong, that she was wrong, and that it is more akin to a storage facility, and thus I would say, no, you're wrong, ZA, and then give the person who Verizon sells the land to the opportunity to try to get something done on that at the county board level. That's where I am.
Ms. Malice.
I'd like to clarify the storage point because I believe what I'm reading in the staff report, it's manufacturing, process assembly, storage, warehousing, and or wholesale. So you have already said that in your determination you feel that it is part of the storage problem picture, and that it's different than public storage. But you have said that this does in fact comport with storage.
Yes.
Okay.
Mr. Melnick.
So, yeah, I was comparing, the manufacturing, processing, assembly, storage, warehousing requirements versus storage. And I was just trying to think about what is most pertinent, and it seems to me that a lot of it could be like, the people involved with it and the traffic generation of it. And so I'm leaning more toward the storage analysis too, that it's more like that, just because, when you get into the warehousing, manufacture, there's a lot of activity, there's people working with it. With storage, typically those places are pretty lonely. There's an occasional person that comes in. So as far as I'm leaning toward the finding of fact angle of the whole thing, just aiming toward it being more like a storage facility. So, and I don't know if it sounds like that's what you're saying too.
Yes, sir. And I think it's borne out by the fact that at the height of the activity, the county board actually upped the parking.
Other questions?
Madam Chair?
Mr. Holland?
Section 14.3.5 of the ordinance, in the required off-street parking and standing space, Part B, computation, final sentence says, if there is any uncertainty with respect to the amount of parking space required by the provisions of this zoning ordinance as a result of any indefiniteness as to the proposed use of a building or of land, the maximum requirement for the general type of use that is involved shall govern. Do you think that sentence has any relevance to our determination?
No, I think that's when you don't know what the building's going to be used for. Like it's a contractor with the government, and they don't want to disclose. I think that's what that sentence is addressing.
Over time, the number of employees needed for this facility has gone both up and down. Is there any particular reason we should think that if Verizon owns this building at this site for another 100 years, that there would never be a circumstance where more employees would be needed on the site?
Yeah, unfortunately, as society progresses, it seems like there's less and less need for employees. If we were to go to the county board, we would be happy to put a condition that if there's a significant change, then we would revisit the parking requirement. I'd be happy to commit to that tonight or do it at the county board.
That seems sort of logical to me, but the actual history of this site is that even though technology was also advancing in the 70s and 80s, even though automation was increasing in the 70s and the 80s, somehow the result of that was, for a time, there were more employees and not fewer.
No, I think there was always a lot of employees. They were parking in the neighborhoods, and so they amended it to add more parking in the parking lot. That's what I think happened. I don't know that for sure, but that's my understanding.
I'm not sure I agree that that's what the record says, but thank you for responding to those questions. Another question I have is that the R6 zone also has some language that directly addresses parking. So there's 5.6.5 says, the site development standards of Article 13 and 14 shall apply to all development except as otherwise specified below, and then it has a restriction on medical offices.
Right.
Do you think that provision is in any way relevant to the interpretation you're trying to seek?
Yeah, I think that was done for an elementary school that got converted to doctor's offices, and it was on Old Dominion Drive as you head towards the intersection with Glebe from Lee Highway. And my belief is that was done to say the county board cannot reduce the parking any more than 10%. I think that's a limitation on the amount the county board can reduce the parking.
You in your main statement addressed the sections of Article 14 that specifically address use permit. And I think your argument was that those are limited to off-site situations.
But they're combined with off-site situations. They're not solely limited because we did Lion Park Community Center, and the zoning administrator determined we didn't have to add any parking at all. And so it's not solely limited to off-site, but it allows the county board to modify it on the subject site as well as lowering it on the subject site if there's off-site parking. It allows both.
I guess what I'm wondering is, if we agree with your interpretation of the county board's power, do those sections have any relevance to implementing the code? I mean, if the county board has the power to modify parking, what's the need for those other sections because the county board
It allows
already
it
has
to modify it based on off-site parking. Otherwise, you can't park off-site. You have to park on your site.
So you would say that the county board has the authority to modify parking through use permit, but not so much as to allow off-site parking,
Correct.
unless it's pursuant to those other sections?
Correct. And examples are the elementary school that parked at the swim club, Swanson parking at Westover Baptist, and Mount Olivet is providing parking to Marymount.
Do you think that 14.3.1C, the section that you're mainly arguing about, do you think that that allows the county board to modify parking when a use permit is otherwise available? Or do you think that that allows the county board so much power that it could issue a use permit for the purposes of parking modification, even if the zoning category didn't otherwise allow?
No, I think you have to come in with a use permit for something else. Like, see, and it says minimum requirements, so I think this gives the board the authority to up it and lower it. Board can go up or down.
But you're not claiming that that section,
No, I can't file a use permit just to reduce parking, no.
it's just that when a use permit's already in play, you think
Correct.
that section allows a modification of parking up or down,
Yeah,
but not off-site?
yes.
Okay, thank you.
Mr. Lawson, I'm a little concerned about your proposal, your suggestion of selling off the parking lot for development. And in such a case, how much parking would you retain for this use? And would that, even if that were geared toward the storage use, would it preclude a different use in that property if at some point Verizon decided that it didn't want that property, and would you have limited what could be on this site because of?
No, I didn't bring the proposals that purchasers, possible purchasers have submitted. If we go with the storage, we would have to provide around, I think, 21 spaces, and that's doable. We can do that. We would just have to adjust the line, further away from our switching station. If we were given, the county board could do it by use permit, we would probably request 8 or 10. Because we've had years of experience in Crystal City, and 8, we don't even need 8 spaces.
But that's with this current use. I'm just thinking about what might be on that site.
There would be a subdivision done, and so the townhouses or apartments would stand on their own and provide all of their required parking.
Right, but whatever you limited the parking for the Verizon building itself, that portion would possibly limit future uses because there wouldn't be the ability to adjust the parking.
No, but I think once we went to that step, I think it would be, whatever we decided to do, it would be that way for many years into the future.
All right, thank you.
Madam Chair?
Ms. Malice.
So staff, question for staff. If your ruling stands, what happens? Is there any remedy here? Is it a zoning change? Is it kind of what would be the next steps? Here's my issue. I think that for the current use, there probably is too much parking. But as Ms. Freshman points out, parking goes with other factors than the current use as well. So how do we tackle this if your ruling stands? Is it just it's over? Or does the applicant have other options?
The only options that would allow reduction of less than 63, so the simplest option is a use permit to reduce what now is a requirement above and beyond what the zoning ordinance says to the minimum requirement, which is 63 spaces. The other option, which frankly, for the redevelopment of the townhouse portion is going to have to happen anyway, is a change to the GLUP and a change to the zoning and a site plan.
So the
So-
townhouses would require that regardless?
Yes,
So this whole site could go into site plan?
could. And you
And
could
then
do
the-
both at the same time.
And then the two parcels could be co-determined?
Exactly.
You know, I don't think we need a GLUP amendment, and I apologize, it's been a long time since I've looked at it, but I think this whole area is planned for townhouses and apartments.
Particular parcel, I looked at the plan today.
Oh, did
And
you?
for whatever reason, it looks kind of strange because this one section is still colored, or at least it was the pale yellow compared to the neighbors on either side.
Okay.
So, Madam Chair, I am uncomfortable finding, I mean, I'd like this to be further investigated. I'm uncomfortable making a finding that this particular parking requirement, it should be this particular requirement or this particular requirement. I'm also a little uncomfortable saying that, it's stating, I guess, our belief that, this can go to use permit, in other words, overruling use. But if there's options to go forward, with the applicant, with your ruling standing, I would be comfortable with that.
Madam Chair.
Commissioner Warren.
Mr. Lawson, do you agree that in this proceeding, we have to presume that the zoning administrator is correct unless you produce evidence that she's not?
I think the state code conflicts with itself. There's one statement, and it says the BZA shall decide whether the person making the determination is right or not. And then there's another sentence, and it says the determination shall be presumed to be correct. So I think it could go either way.
What's the zoning administrator and county's view on that question?
I don't think there is a conflict. We do think that there is a presumption of correctness for the zoning administrator. I think that's pretty clearly laid out in 15.22309. And this was a recent change to the code in 2015. It says the decision on such appeals of the zoning administrator's determination shall be based on the board's judgment of whether the administrative officer was correct. The determination of the administrative officer shall be presumed to be correct. So I think those two statements read together don't conflict. You're still determining whether she was correct, but she has a presumption of correctness. And that is actually just a codification of existing case law. There are Supreme Court cases out there that says that when an administrative officer is consistently applying an ordinance, she is entitled to a presumption of correctness. And I have copies of those cases if you'd like to look at them.
Mr. Lawson is claiming that there has not been a consistent interpretation, I suppose.
No, I think there has been. We did some research on what the prior versions of the ordinance says, and I believe until 1993, the zoning ordinance says that parking can only be modified through site plan. There's no mention at all of use permits. Use permits were added when the specific references to the use permits and how the board can amend it, for example, restaurants and retail within 1,000 feet of a metro, and also for daycare and school uses. That's when that language was added in. And we actually also have a staff report from when the board adopted the provision allowing for schools and daycares to have more flexibility in parking. And that staff report explicitly says that, we're asking for this because there is no flexibility in the current zoning ordinance to allow for use permit amendment of parking. But I can certainly pass it up.
I could have, I'm sorry for not checking this before I got into the meeting, but in section 414, in Article 14, where there's the specific references to use permit parking, do those include providing parking for medical offices? Is that one of the categories? And here's why I ask, because we talked a moment ago about the R6 reference to parking, right? And the R6 reference says 13 and 14 shall apply generally. And then there's a specific limitation, it looks like, on parking requirements for medical offices.
I think that's because in R6, you can get a site plan for medical offices and residential buildings.
But it doesn't say site plan. It says, in considering use permit applications under 14.5, the required parking for medical offices may be reduced to a maximum of up to 10%. So let's see, 14.5. And 14.5, by the way, is a cross-reference to aircraft landing approach area. So that appears to be just a raw error. But it seems to me that unless medical offices appear elsewhere in Article 14, that reference in R6 would tend to support Mr. Lawson's argument that there's more to the use permit power than is described in Article 14. So I guess I'll study that while we're answering other questions. I guess I would say that where I'm leaning is maybe the opposite of where Ms. Malice is that I think that there is no evidence. I don't think the applicant has met its burden of production to change the factual determination about which category it should go under. I think you may find, by the way, Ms. Malice, that the other categories are not ones that the applicant would want because they all have even tighter parking requirements, or they're just inapplicable. But I feel like there's not a burden of production. If there had been a burden of production, I would have other questions about how we should evaluate. Are we limited to talking about the parking needs? Is that our only criteria? Or should we also look at the rest of the language of the ordinance, which I think that the zoning administrator did? She discussed it's really specific, the storage use. It goes into detail about 90% of the total floor area available to the general public for storage of items, et cetera. It's like really inapplicable on that basis. And so the question that I might have is, are we just talking about parking and we ignore all that other language, or do we take that into consideration? But I can't even get that far because I don't think that the applicant has made that. The flip side is that I actually do think that I'm inclined to support the appellant's view on the county board's use permit power. I think that it does seem to me that the overall structure of the ordinance suggests that when use permits are in play, you can't do a use permit where you couldn't otherwise just because of this section, but where you have a use permit, site plan is just a form of use permit. And so I don't think it's foreign to Arlington County policymaking for the county board in the context of a use permit application to consider a parking adjustment. So my own personal leaning right now is uphold the zoning administrator on the category determination, but reverse the zoning administrator on the county board power determination. But that leads me to sort of another question, which is, if we were to do that, and then presumably the county would be aggrieved, I guess, or the zoning administrator would be aggrieved, who appeals? Like, usually the county attorney's office defends our rulings if we uphold the zoning administrator, but who are the attorneys on each side if we rule for the appellant here?
Before, so we would defend your position upholding the zoning administrator's factual finding, I suppose, that this was the category, and then we would appeal. The county board is the party.
Right.
Your determination or your finding that use permit could be used.
But only Verizon would argue that we were right on that. Is that right?
So
it would be up to Verizon?
It would be a cross appeal where I would argue you're right on one count and wrong on the other.
Well, I'm not talking about the split counts, just to clarify the issue. Let's say we ruled completely against the zoning administrator. I'm just wondering which party is on which side of the case on appeal. Would it be totally up to Verizon to support our ruling, and you guys would be with the zoning administrator?
Yes. So the BZA is not a party
Right.
at all. So they're supporting your ruling, but they're actually supporting their property interests in that
Right.
instance. And we would be representing the zoning administrator, but we're also representing the county board because they'd be a necessary party.
Okay. Thank you.
Other comments, questions? Mr. Mulner?
So, Mr. Lawson, so you've heard the statements, about the presumption and overcoming the presumption. So how would you respond to that about, the facts necessary, evidence necessary to overcome the presumption? That the statement of justification, is sufficient. But, I just want to hear your response to that, the presumption and how that's been overcome.
Well, of course, if I could have predicted the conversation, I could have had Mr. Huka, who is the property manager for Verizon for this part of the country, to have been here. And he could have explained everything that goes on inside of there. And then I could have also gotten somebody like maybe Tom Schultz to describe self-storage and how that works. If you all would be inclined to let it go by use permit, the only thing I would say is that all you're doing is giving it into the good hands of the county board and their professional planning staff, and they're certainly not going to make a mistake and not have sufficient parking.
Okay.
Ms. Freshman, I don't know that you're agreeing with that 100%.
No, I was trying to bring some closure
Sure.
to the conversation. Mr. Owen?
The county attorney said that they had proposed factual findings for us, and I'm wondering if we could see them at this point. Has the appellant seen this? All right, so we should probably share it with the appellant as well. And does the zoning administrator or the county attorney want to explain these proposed alterations?
So what we've basically done, and I only proposed factual findings for if you would affirm the zoning administrator's determination. I kind of left the other ones blank because I wasn't sure what the basis for those would be. But we've added that the BZA find, as a matter of fact, that the proposed use does not offer up at least 90% of its proposed floor area available to the general public for storage of items. That's directly from the language in the use table. And that the BZA finds, as a matter of fact, that the items stored as part of the proposed use is associated with the office, retail, industrial, or other business activity conducted on the premises. That's again from the definition, and I believe that's also been admitted by the appellant both in their oral statements today and also in their written application, that what's stored on site are batteries used for Verizon's business purposes and also equipment used for the business purposes. And the third finding is that the BZA finds, as a matter of fact, that the proposed use is most similar to uses consisting of manufacturing, processing, assembly, storage, warehousing, or wholesale, and not most similar to the public storage use. And finally, that the BZA finds, as a matter of law, that the Arlington County zoning ordinance does not permit minimum required parking for a use to be modified through the use permit process.
Madam Chair,
Mr. Owen?
I don't want to delay anyone else from making a motion, but I'm right now going to prepare a motion to do what I said was my view. So
Okay.
if anyone beats me to it, they're welcome.
Anyone
to go ahead.
else?
I don't think that Mr. Noah and I are in disagreement on the first point as to the parking requirement.
Is it the use permit?
It's the question of use permit. I don't know what can of worms we open up when we start to litigate what the board's powers are.
Would you eliminate that whereas?
I would, well, this whereas supports the county, the administrator, the zoning administrator. So I would not, I would support this motion as it's written.
Not throwing it to the board.
And not throwing it to the board in this way.
Okay.
But I think I'm at the extreme, probably, of my colleagues.
Maybe not. Other comments? Mr. Owen, where are you?
I'm nearly done.
It's 8 o'clock.
Okay. So I'm going to work from the, oops.
I'm going to work from the resolution that was just handed to us, the one on top. And so I will start by taking the first 4 paragraphs intact. And then for the 5th whereas clause, I would modify that to say the reverse of what it says now, which is, whereas the BZA finds as a matter of law that the Arlington County zoning ordinance does permit minimum required parking for a use to be modified through the use permit process on this site. For this use. And then the next whereas would be substantially modified after the period or before the period to say, as to its determination, as to her determination, her determination of the table in Article 14.3.7, but incorrect in as to the determination of law that the Arlington County zoning ordinance does not permit minimum required parking for a use to be modified through the use permit process. Now be it therefore resolved, this is the next paragraph, that the BZA hereby affirms and upholds in part the zoning administrator's determination to Verizon Virginia LLC regarding the minimum required parking requirement for telecommunications switching station at 6700 Lee Highway, and reverses the zoning administrator in part as to her determination of the county board's use permit power. That's my motion.
Chair?
Ms. Malice.
I'm not clear on what your statement is regarding the parking requirement. Is it, are you keeping all these whereases in, or did you eliminate all these whereases?
I'm keeping all the whereases because I support the zoning administrator's determination of how to interpret the table. And the table is a factual question that relates to these factual findings, which we can presume are correct because we're allowed to presume that they're correct unless it's rebutted.
Okay, so we would say that we agree that the use is 90%, not 90% floor area. Okay. So when we have one motion with 2 thoughts in it, and some of it we agree with and some of it we disagree with, do we bifurcate the motion, or do we just do the whole motion up or down?
We don't have to do it any particular way. One way that I think might be clarifying is just to see if I get a second and if I get a majority, and then if no one can buy into the whole thing, then we have to go do it more piecemeal.
I'm good with that.
So once again, I move the resolution as stated.
I'll second. With a small edit in the 4th whereas, as noted.
What?
Manufacturing.
I'd ask unanimous consent to adjust that to say manufacturing rather than manufacturer.
Yes. We just asked Minchow if it's, are we creating more confusion than if we did two different resolutions, or I'm not sure. It's clear to me what's been proposed, but I didn't know if that.
Well, I guess we'll get from Mr. Owen the edits, but whether that's the final will depend on how you guys vote. Because I've heard the second, but I'm not sure if this is what's passing or not.
Sure what?
I'm not sure if this entire motion is passing or not. If it is, it's pretty clear, but if not, then I'll be taking more notes on
Okay.
bifurcating.
Okay. Shall we call for a vote just to see where we are? Okay. It's moved and seconded as edited. Affirming part of the zoning administrator's determination and reversing part of the zoning administrator's interpretation. All those in favor?
Aye.
Aye. Opposed?
No.
3-2. Thank you. Next case, please.
Case number V-11271-17-VA-5 is a variance request by Sirkin Kurskin owners to permit the construction of a new home on a lot that does not meet the width and area requirements in the R6 zoning district on the premise known as 2105 North Emerson Street. Staff recommends that the board adopt the attached resolution approving the variance. And please note that there is a supplemental letter from the Civic Association that's actually filed in your supplemental package under the next item.
Thank you. Questions for the staff? Applicant, please. Mr. Owen,
Before we begin, I do have a question for the staff.
go ahead.
Is this a reconsideration of something that we did before, or is this a fresh application?
We are considering this to be fresh.
Okay, so there's basically a
Same application that was heard before, but because the withdrawal was accepted, this is fresh
got it.
material.
Okay, thanks.
Thank you. Yes, sir.
I'm just a representative of the owner. I'm here to answer any questions you may have. We don't really have much to add, other than we agree on all the findings of the board, the last hearing.
Questions for the applicant? No? Okay. We have speakers. Would you take a seat, sir, for now? Alia Sarak. Talha Sarak? That's you. Oh. It's a different name on the staff report. Got it. That's what I thought. Okay, so we got you.
Sure.
Mr. Owen.
Oh, was that it for the speakers?
Sorry?
Any more speakers?
Yes.
Oh, I'm sorry.
Sean Martin.
Hello, I'm Sean Martin. I live on the property adjacent north side of the 2105 North Emerson Street. So my concerns are that the ownership has changed recently, but the variance seems to be in the same name as the variance granted in May that expired in November. The length of the process, we've had a work stoppage order from July 2013, so we've been looking at that since then. The property's been vacant since the fall of 2010. My third concern is tree protection, and fourth is road and activity without proper abatement. The requests I have are the trees are properly protected. If they have to come out, I'm reasonable, but don't just cut it halfway so it's full on my side and cut 90 degrees up on their side. continue communication with the neighbors. I've recently seen some folks on the property, and they've been very polite and helpful, and we want to continue that and keep that very neighborly. Like to see improved road and abatement. And if it's mentioned this is a fresh request, I do find favor in reducing the setback, or pardon me, increasing the setback from 5.6 feet even greater on my side of the property. It's currently 4 inches from my property line. But if it would meet the requirements as set, that to increase it larger than 5.6 feet, that's my preference.
Thank you. Questions for the speaker? Thank you. Next speaker.
Sorry.
Willie Jackson Baker.
Good evening. Thank you for the opportunity. I live at 2106 North Emerson, across from the property, and the neighbors in the community have a history with this property. For the past 4 years, we've lived with the property as you see it today. It's unsafe, there are rodents, there's overgrown shrub, there's encroachment on the adjacent properties. On several occasions, we've come to the BZA and we've met with the property owner to come up with something that's safe and agreeable to all. And I'm here too representing some of my other neighbors. So we as the neighbors, we just want to know what's going on with the property. In June, neighbors received a letter saying that the property was going to be demolished and new construction would begin. 6 months ago, the owner was issued a variance that recently expired. So again, we do just want to understand what's going on. And now we hear that the property has changed hands and the new owners are seeking a variance. But that is listed in the name of the previous owner. So we're confused as to who's seeking the variance to, the new owner or the previous owner. Or again, is this, we've seen some deception, so we just want to make sure it's not that deception that we're seeing. Again, we all would love to see something built on a property that's safe, conforming, and complementary to the neighborhood. So we would like to ask that you defer this until a presentation can be given to the neighbors and the community so that we can understand exactly what's going on. Thank you.
Thank you. Patrick Thompson.
Good evening. My name is Patrick Thompson. I am a delegate to the John M. Langston Citizens Association. I'm here as a proxy for our president, Alexandra Boshin. I would associate myself with the comments from Ms. Baker earlier. As an executive board member of the association, this property has caused much consternation at many meetings over the last 2 years. It is clearly an eyesore and perhaps even an attractive nuisance with regards to children to and from school. I think the community would love to see something built there and built there quickly. And what I would like to say is that we haven't seen any proposals for the variance at the executive board level or for the full community. And we would invite the property owner to present that. And our next executive board meeting is January 17th. The next full body meeting is January 24th. And that's what I have. Happy to answer any questions.
Thank you.
Thank you, ma'am.
Madam Chair, one quick question. You question whether this is an attractive nuisance. Are you aware of have children been observed inside of this after construction hours?
No, sir.
Madam Chair?
Mr. Moon.
We approved a use permit. This is a question for staff. We approved a use permit application for this property May or whenever it was we did. Has that use permit lapsed or vested?
It is vested.
Okay, so there's a building permit.
Correct.
And so that's never going to expire. It's vested. They don't have to come back for their use permit again under normal circumstances. Is that right?
Correct.
So to me, all right, So that was my main question. So I think to the neighbors, I think the issue here is not really a live policy question. We had intentionally used a much shorter period than we usually do for the use permit for vesting, in part to encourage quick movement on this site. And so, in fact, with perhaps hours remaining, a building permit was approved within this shorter 6-month period as opposed to the 1-year period we would normally do. I think a use permit normally couldn't issue without the variance underlying it. And in my mind, at least, there was a lot of confusion at the last meeting about whether or not there was already a variance in place or whether or not we needed a new one. And basically, my view is that we made a technical error in not just approving the variance at that previous time. And so, to me, what's before us now is there's a vested use permit that theoretically should not be there unless you also had an underlying variance, which we basically intended to give in May and only didn't because there was this confusion about whether or not there was already one in place. So while I would be ordinarily, if there was no vesting of the use permit, if there hadn't been the building permit issued, my view would on this would be, okay, now we need to put an even tighter leash on it. But the fact is that they made it to the deadline that we had set, and they got their ducks in a row, and presumably things should move faster now than they had been before, in part because of the shorter timetable that the BZA set. Now, I guess I do want to re-raise the question with staff that the citizens have raised, which is, what's the significance of the difference in the owner's name?
We weren't aware that the ownership had changed.
Yep.
So I couldn't tell you. I mean, obviously, there would be some clarification on our end of making sure that the owner is who it says, but...
Or at least if they provide consent.
Yeah, so I guess there's maybe some ambiguity as to whether or not we have the owner's consent for this application. And we're not treating it as a reconsideration of the previous variance. We're treating it as a fresh application, and that requires fresh consent from the owner. Okay.
Okay, any further comments, questions?
Just very briefly, because
Mr. Smith.
To the question of who owns this property, we have a disclosure statement that is dated April 12th, 2017, and that lists Serkan Keskin as the owner. Is that person not the owner now?
You want to come back up, please?
Clarify. So, Mr. Keskin was the owner, previous owner, and we bought the property from him with Ideal Development, but he is also a partner in Ideal Development. So technically, it changed ownership, but we just received this notice of hearing, so we didn't want to ignore it. We just showed up. So he's, how do I say it? He's involved either way.
Who is the current owner? Who do you represent?
Ideal Development is the current owner.
Is it an LLC?
It's an LLC.
And he's a member?
He's a member, yes.
You're the manager?
I am the managing member, yes. And
how many, are there other members?
We have another member that's sitting with me, so we're 3 of us.
Oh, okay.
And just, if I may add, we did just get the building permit a few weeks back, and we got the LDA permit, and we actually started construction. We met with the LDA inspector, did the pre-construction meeting, which was approved. We put the silt fence up, waiting for Washington Gas to disconnect the pipe at the street, which is any day now. Then we're going to start with the demolition. So
But you are not MAS Homes.
that's Mr. Keskin's other company. We bought the property from the other company.
Does this seem right to you?
It's certainly complicated. It's a complication we were unaware of.
I mean, applications require a property owner disclosure form, right? So if this isn't right, we shouldn't be proceeding.
But he's testified to what it should say on the record. So we can get a new form.
Madam Chair,
Mr. Smith.
I don't disagree really with either of you, Ms. Vaughn or Mr. Owen. I think it is form over function, and he is involved. However, I think we have some testimony from folk who want a fuller explanation of really what's going on, and they were asking for a deferral so that they could meet in January. Now, this company to discuss what's going on, and the neighbor next door wants some clarification as to how they're going to handle the trees that abut the property. So I think it could be cleaned up in terms of a new disclosure submitted, and that we could accomplish the answering of the questions by the neighbors via their community association meeting in January by virtue of having a deferral until February.
I have a question.
Mr. Malnick.
So in this kind of case where there is a transfer of the property, is that all that's needed so that everything can continue on, but you just need new paperwork in the ongoing case? Just the disclosure form. So there's nothing more as far as that. It's just like an assignment of the case, and you have the new paperwork. Okay.
So, Madam Chair.
Mr. Owen.
I mean, I feel for the neighbors because the situation that's you're faced with for these last couple of years has been unreasonable, and I know that it's frustrating to have this churning of the property owners over and over and over again, and the repeated applications. And I think if I were one of the neighbors, I would be super exhausted and upset about all this as well. The problem is that the particular thing that we are facing right now is not really the right tool to solve the problems that you have. It's a technical matter. It's a technical mistake. The BZA has repeatedly granted this variance, and that was even before there was a vested use permit on the site. And so we really are following paperwork up in this case that just got screwed up. So I agree that there should be a deferral to make sure, I mean, since the whole point of this is to do it right, so it doesn't have to be revisited again, I would support a deferral to do it right. But I do want to assure the applicant that, in my mind, for my vote at least, there's no question about this, right? It's been decided. We actually decided it in May. We just said it the wrong way. And so, I don't think there's any mystery about whether or not, to me, about whether or not you're going to get the variance. I don't even think imposing additional conditions on the variance, in my own personal mind, is appropriate. And I love giving neighbor-friendly conditions, but here, the horse is out of the barn.
Does this mean that the work has to stop since they indicated that they're moving ahead?
They have a pending application to cure whatever problems they have. So ordinarily, you wouldn't enforce under those circumstances, right? Would you give a stop work order for lack of a variance?
I would think.
Could we?
No, I don't. I frankly have never been in this situation before, so it's hard to say what I would do.
I don't think the
but-
neighbors would want a stop work order. They want a work faster order.
Yeah.
Mr.
We
Malnick.
want a mitigation of the issues that they have with respect to securing the site and bringing it into
Proceeding does that.
eliminating the vermin and whatnot.
Mr. Malnick.
What I'm wondering about, just because it's saying, and I'm very glad to hear it. It's, going forward, it sounds like at a good pace. What I'm wondering is if we couldn't approve this and make one of the conditions that they submit the proper paperwork, expressly condition it.
And meet
on
with the
that.
community.
And that way, we're allowing them to proceed and not creating delay. And if they can just get a notarized statement in the next few days, it seems like that, if that's possible, ask you all. But that might be a good idea too, just conditioning it.
I'd agree.
Madam Chair?
Ms. Malice?
So there's an approved use permit that describes the project. It has plans and it has every detail on it. And is that what you're going to build?
Yes, we actually mailed this out to both adjoining property owners. So they have our tree sheet plan that shows which trees are going to be cut. They have the copy of the approved set from Arlington County. So that's not changing. We actually started construction.
So what is going to be built right now is known. It's not a mystery.
Absolutely, single family.
It is known by the county.
Yeah, let's do
known
it.
by the board.
Keep
And
moving.
it's knowable by all the residents that
The adjoining
live
property
in the
owners.
that
Yes.
live in the neighborhood.
Yeah, I'd like to see it move ahead, but I do think you still should meet with the community in January,
Absolutely, sure.
I won't craft the motion, but I will support.
just to make sure that they are clear about what it is you're doing and that you're moving ahead to try to cure some of the defects that they've suffered with.
Sure.
Do I hear a motion? Mr. Melnick?
Make a motion. Okay. All right, so my motion is in case V11271-17VA4 that we grant the resolution approving the variance with the express condition, however, that a new disclosure statement and let's see, is that, just a question, is that the only document that needs to be replaced, or does there need to be some kind of amendment to the actual application?
It's probably better to say an updated application, which includes the disclosure statement, so that all of the information is updated.
So and that would be expressly conditioned on an updated application being submitted with the owner of record listed, and properly executed by a representative of the owner of record.
Any other conditions? Community meeting?
Yeah, I would add that.
To meet with the community in January? Adding a condition to meet with the community in January as they've requested?
It seems like, from what I've heard, is it's kind of a moot point at this point. It just, we've granted a variance, and now it's, for me, the only issue is getting the paperwork reflecting the owner.
Well, he's agreed to it, and I think that whether it's not as conditioned, you should do it.
Okay, just so you know, we have a project manager that's managing this project. He's actually in contact with adjoining property owners, and I'm always CC'd in the emails, so we are in contact with them already.
Okay, but we're talking about the meeting of the community association, which is in January.
Sure.
We have a specific time for that.
Absolutely, yeah.
Okay. Okay, is there a second?
Second.
Moved by Mr. Melnick, seconded by Mr. Owen, for approval with the added condition of requiring an updated application with the owner of record. All those in favor?
Aye.
Aye. Thank you.
Thank you. So, I'm sorry, where would I get the paperwork that we need to?
Come see me.
All right, now?
Not right now.
We're a little busy now.
Tomorrow.
Tomorrow. Next case, please.
Yes. Case number V-11099-16-VA-3 is a variance request by Elena Keith, the owner, to permit construction of a single-family dwelling on a non-conforming lot in the RA18 zoning district and to permit a left side setback of 4.5 feet to the wall of the building, 2.9 feet to the building eave from the adjacent property instead of 10 feet to the wall, 6 feet to the building eave as required, and to permit a left side setback of 4.2 feet to the porch, 3.7 feet to the porch eave from the adjacent property instead of 10 feet to the porch, 6 feet to the porch eave as required, and to permit a left side setback of 4 feet to the window wells instead of 6 feet as required, and to permit an aggregate side setback of 12.3 feet instead of 18 feet as required regarding a new 3-story single-family dwelling in the RA18 zoning district on the premise known as 2116 North Culpeper Street. Staff recommends that the board adopt the attached proposed resolution granting the subject variance permit with conditions. And please note that there is considerable supplemental material for this case that came in after the application packet was assembled and printed, including an updated disclosure statement as well as letters both in support and against the application.
Questions for staff? Mr. Owen.
There's a revised disclosure statement, but unfortunately, it seems to me like it's still incomplete. What I look for when I look at these disclosure statements is at least one natural person, like a human being. I know some people think corporations are people, and for this purpose, they can be. But the application, the disclosure specifically says, list the names, addresses, and nature of interest of all persons having an equitable ownership of the real estate to be affected, including, in the case of corporate ownership, the names of stockholders, officers, and directors, and all parties of interest. And the only thing that we have listed here are 2 LLCs, looks like. One. Yeah. But no natural persons, no stockholders, no officers, no directors, and no other parties of interest. So I'll just note that it appears to me that this form appears to be incorrect, but I'm wondering if staff has a view about the sufficiency of this form.
I don't think that we necessarily disagree with your assessment that there should be someone listed. We've asked for revisions from the applicant, and this is what we've received.
Mr. Lawson, are you representing the applicant? Okay, we'll start with you. I have a speaker slip for the applicant, but I don't want to have, we also have a lot of speakers, so I'd prefer that only one of you speak.
Thank you, Madam Chairman. For the record, I'm William B. Lawson, Jr. I represent the applicant. This has been a very unique and difficult case, and it's been a very strange case. You know, I have an applicant that wants to build a single-family house on a single-family house lot. She has requested a variance to build on an undersized lot due to the zoning category. She's also asked for a variance to encroach 6 feet towards the neighboring parking lot and apartment building. And yet we've had opposition from neighbors that live in townhouses, neighbors that live in apartment buildings, and a neighbor that owns a significant commercial building. And there's been a lot of personal animosity by the neighbors towards Ms. Keith. I've tried to bridge that. I've tried to work with the community, and unfortunately, I've been unsuccessful in that endeavor. You know, she didn't do this on purpose. This has cost her many thousands of dollars, all of this delay, and it's been a really long time. Let me talk about the side yard variance. I would submit that you all have granted dozens, if not hundreds, of similar requests. The only difference is those forms say at the top use permit, and this one says variance. 3 years ago, we would have filed for a use permit because at that time, the zoning ordinance said that we were allowed all uses as allowed and regulated in the R districts. Well, that got taken out in the redoing of the ordinance. So now it's a variance that we filed because use permits are only allowed in the R districts. However, under the tests of the state code, this should be granted. We do have a significant hardship, and that is that Ms. Keith would like to utilize the current foundation. It's going to save her a lot of money if she can do that. And I would suggest that, you know, the prior house was on that foundation, and so for her to rebuild on that foundation really is not that much different. It's not self-imposed. We have a letter from her contractor, and it says that the front wall of the home was rotten, so I removed it, intending to replace it. I did not realize by removing the wall, the nonconforming status would be lost. I'll hand that out in just a minute. Is this due to the physical characteristics of the lot? And it is. It's a very small lot, and we have the whole rear yard taken up by an easement. The ordinance, the state code requires substantial detriment to neighboring property. I would submit there's very little, if any, impact on neighboring property. And is this best addressed by amending the law? And I would respectfully say no. I want to approach you and share with you a board that I put together because it is very hard to understand what's going on with the engineer that's drawn three footprints on top of each other. So what I did is I created an original house. The first variance that you all approved that was lost when that front wall got removed, and what she's asking for now. And I'll let you all pass that out. You'll see there's very little increase in area. This house is by no means a McMansion. For another case, we did an analysis of every new home constructed in Arlington County during 2015 and 2016, and we came up with the average of all those homes, and then I compared it to hers. She is much smaller than the average home being built currently in Arlington County. And then you all had asked for what would the by right look like. And I'll let you all look at this also. But what we did is we showed the front of the house with the variance, front of the house without the variance, the back with the variance, and the back without the variance. And I think there's very little difference there. The final thing that I would say is that this has been going on a really long time. I don't think it's to anybody's interest to let the property keep sitting there. And if you all don't believe a side yard variance is appropriate, I would beg you to grant a variance and let her build what you can with the by right option.
Thank you. Questions for Mr. Lawson?
Yes. Mr. Lawson,
Ms. Lawson?
when you say let her build the by right option, is that what is being passed around?
Mm-hmm. What it is we just, instead of getting the variance for the side yard, we're following the property line at the 8 or 10 feet. I forget which it is.
Was that by right option shared with the community at the meeting?
In a way, it was. What I shared with the community is I took the plans and I drew lines showing where the by right would be if we didn't get the variance. And I can hand out to you what was handed out to the community, if that would be helpful.
We have communication from the community saying that they had wished that they could see the by right option.
I'm sorry?
We have communication from the Civic Association saying that they wish they could have seen the by right option.
Well, it's not, as you can see from when that gets to you, I mean, the difference is very minor between by right and with the variance. All we're doing is just squeezing it.
Okay. My other question has to do with the disclosure statement. Do you know why it's insufficient?
No, I don't. It's been on file for, I guess, ever since Ms. Keith originally filed the case.
Let's just, sorry, I've got a lot on my paper.
Ms. Mouse?
This was signed
Ms. Mouse?
April 2000.
Oh, I'm sorry. Go ahead.
This was signed in April of 2017, so it's fairly
Out
recent.
there for a while.
But not, so you did not represent her at that time?
Well, I may have, but I didn't do the affidavit. I wish I had.
So can you list who the owners are?
It's just, it's only you, right? It's only Miss Keith.
Other questions, Mr. Lawson? Thank you. I'm going to call the other speakers. Norman Pardo, to be followed by Jim Derrick.
Good evening. My name is Norman Pardo, and I'm the contractor for Mrs. Kate. And I'm just here to confirm whatever I said, that when we were rebuilding that unit, we found out that most of the sill plates, which is around the peripheral walls, they were all rotten, as well as the studs and plywood. So whatever we have decided is to replace that without the intention that having Mrs. Kate not be in a conforming status.
Okay. Thank you. Jim Derrick, to be followed by Joe Glanzer.
Good evening, ladies and gentlemen. Thank you for your time. I've appeared in front of this board several times. I am not an adjacent neighbor, but every time I walk through my front door, turn left, 50 yards, I see this every single morning, every single evening when I come in. In October 2016, my neighbors and I made several calls to the gas company and the police in regards to activity and gas smells at this work site, under which there was a work stop order at the time. We observed a man digging under the house with a wheelbarrow and shovel transporting dirt. We even alerted the county of this activity, in that it not only presented a significant safety issue, but was in violation of the responsibilities under misutility and a violation under her variance not to dig out her basement. We were told there was nothing to see here and no action was taken. On January 29th, 2017, the black tarps that had encased the house for months were taken down, the house was razed to the foundation, and the dugout basement and new foundation were exposed, as we had suspected and are noted in my wife's pictures, which were already submitted. All while the owner stood there and directed the workers in direct violation of her variance. Not only did she have them take the house down, but she also had them construct the new walls that same weekend, much higher than the original structure, and again, outside her approved variance. Her actions against her variance were intentional and calculated. The basement was dug out and new cinder block was laid. She directed her contractor to tear down the porch and all the walls and not to have them stop, nor did she call the building department then on or on Monday to report the error. The plywood was pre-ordered and had non-compliant walls and subfloors built to hide what had been done. The walls were constructed on her first floor that are non-compliant and would have required another variance, again, trying to skirt the rules. The blatant disregard for the community and the safety is obvious, as evidenced by her past actions and even today in the condition of the property. There is no trust. We understand that according to Virginia law, there's a buy right option. That's the only thing that our association has approved.
Thank you.
Thank you.
Joe Glanzer, to be followed by Stephanie Derrick.
Thank you. Excuse me, I had an accident. My S's might bother you. I've lived in this neighborhood for 22 years, and I have never seen anything like this build. I've already submitted a letter to you before, but Mr. Derrick and his wife and my neighbors have been very articulate and very eloquent and very factual about what has gone on with this property over the past couple of years. I take exception with Mr. Lawson's statement that this is personal. In fact, Elena and I had ran into each other and had a very cordial conversation the other night, very respectful. In fact, she almost got hit by a car. I kept her from getting hit by a car. This is not personal. This is an eyesore. This is a dangerous work site. The hardship is due to the applicant's own history of non-compliance. But I'm here, my other neighbors will speak to you about these issues. I'm here to talk to you about the fact that as a legal matter, the LLC does not exist. It expired in July. She was notified twice, if you read my letter to you, and there are documents attached that I updated as of about 4:30 this afternoon. You can go online right now to the Corporation Commission. You will find out that this LLC does not exist. Years ago, when the property was purchased in 2014, the LLC did not exist. And yet, in our Recorder of Deeds records, Heidelberg AG LLC is shown as the owner of the property. Didn't exist then. Okay. Now you have a chance. We were told that the board couldn't go back. We couldn't appeal. We had missed the appeal deadline. So that issue didn't matter. But now it does, because there is no variance, there is no work order, and there is no corporation.
Thank you. Stephanie Derrick, to be followed by Tracy Grenier.
Thank you. There's much I could say, but honestly, I teeter between complete anger and exhaustion at this situation, which has gone on for way too long in our community. It's very hard and time-consuming to care this much. It's been asserted by Mr. Lawson that I shouldn't care, that I don't see the property, and I'm not an adjacent neighbor. For one, I can see it, and two, I do care about my community and actively participate, volunteer, and in this case, fight for what is right. I am also the closest owner-occupied home to the property. We all agree there has to be a resolution to this, and as a person who has witnessed all the activities with this property and has been involved from the start, I must ask again that you deny this variance request. I have been consistent and will again reiterate the need for a complete sidewalk at the property which will address a safety concern. As well as the determinant of negative impact, the need for a front setback of 25 feet for infrastructure needs can be met with a clean by right option. Of note in the plans, there was never an existing patio, and I please ask you to look at the pictures. And again, this is the applicant's attempt to encroach significantly on the front setback with an underground basement, which was illegally against her variance to dig out in the first place. That portion of the house should be demolished for a clean setback. Tonight you'll go home and you can end this for you, but for us, this eyesore and constant, diligent observation of its unsafe and unappealing appearance is a blight which detracts from our community. I ask again that you please deny this request. Thank you for your time.
Thank you. Tracy Grenier, to be followed by... Okay.
Good to see you guys again.
Robbins, something? Okay.
Mr. Lawson and Elena Keith have started on a tirade of slandering my name and claiming I don't represent the neighbors. In my packet, I've included endorsements from the owner of my property, 2117 North Cameron Street, and 2110, 2114 North Culpeper Street, Ann Tonks, who is here this evening, that I do have a right to speak on their behalf. Mr. Lawson claims that, has twisted my words from the Civic Association when I was representing 2110 North Culpeper Street, claiming I'm saying this impacts my property. I never said it impacts 2117 North Cameron Street. Elena Keith on Monday took to next door to slander Carla Butcher, Heidelberg Bakery owner, me, Stephanie Derrig, saying we have created these issues. On January 4th, 2017, she applied for a variance modification where it clearly states she intends to remove the first floor walls and rebuild them. She is the property owner, and whether or not she had no clue, she takes responsibility for what her contractor did. She's not suing her contractor for the loss of money of it all this time. And the neighbors, what they are asking for is a by right build. They're not asking that nothing be built there like Mr. Lawson claims in his letter. And then I have issues with the whole application. There's still contradictions. There's a letter from the engineering company that has what appears to be a cut and pasted head logo on it, and it is unsigned by anyone at that company. If you say it's going to cost $60,000, why aren't you standing behind your deductions? Thank you.
Thank you. I'm sorry, I'm having trouble reading this. It looks like Robbins Bauer? Okay, that's good. Close enough. To be followed by Patrick Thompson.
I'm here for Sherry Young, who's a directly impacted neighbor. As she's out of state, and I have a letter in her handwriting for you all, and I was asked to read her words, if that's all right. Dear Mr. and Mrs., dear members of the Board of Zoning Appeals, I request the Board of Zoning Appeals grant Ms. Keith an approval that will allow her to build a house on her property. Over 433 signatures of support for the project have been collected from the neighbors. We have endured this construction site long enough. Whatever mistakes have been made were made in the past. We must all be very forgiving and move forward. Who has not made mistakes? I believe Ms. Keith should be allowed to proceed with the construction of her home. Many neighbors are tired of seeing a hole in the ground. Let's support her plans so she can move forward with approved plans by zoning committee. Ms. Young, I want to note, Sherry lives at 2014 North Culpeper Street, and this house is at 2116 North Culpeper. You do have a copy of this, and I've been a friend of Sherry's for 16 years.
Thank you. Patrick Thompson.
Good evening again.
Again.
Patrick Thompson, delegate to the John M. Langston Citizens Association, here as a proxy for President Alexandra Boshin. In reviewing the packet, a few things came to mind. First of which, despite their noting that there are a multitude of support letters, I noticed many of the addresses appear to not be of the neighborhood, which I think would be reducing their impact on people's concern. Secondly, as you see through the paper trail of letters from the association, there were a few meetings throughout the fall on this property. Much like the Emerson Street property, this property has been the source of concern at many, many, many meetings. We had someone from zoning address us last year as to what the community could do to compel activity when we've got these eyesores that are not making any progress. With regards to the recent activity, I wanted to note that looking through the packet, this is the first time that I've actually seen a front and rear elevation within the setbacks as a by right proposal. Mr. Barnes and Ms. Keith presented the original plans with a vertical line indicating a portion would be lopped off if they were to build by right. And I see I'm running a little short on time here, but I think it's salient to note that it's not just a few people that are opposing this. This has been unanimous concern at meetings for months. In fact, on November 29th, the attendees at the full-body meeting voted unanimously to that it is not in support of the plans as submitted or what the community understands the proposal to be. The community does not support the request to encroach into the property line setbacks and may in future support a by right proposal subject to clear plans and further review and analysis.
Thank you.
Any questions?
Now, thank you. Okay, now I have, Ms. Keith has submitted a slip. However, in the interest of time, I'd really like this to keep moving. So we've already had the agent speak. Very briefly, please.
Thank you so much. Madam Chairman and members of the Board of Zoning Appeals, I really, first of all, appreciate you being here, and I know it's a long hearing ahead of you with all the cases, so I'll be as brief as I could. And there were, just let me bring up quickly, there were lots of mistakes made on this project, and this was my first project, and I've realized that there was mismanagement, there was so many things I did not oversee, I didn't know, but again, it doesn't excuse me from doing something that was mismanaged. So moving forward with this, we are having the builder who is licensed and insured, Builder A, who's going to take care of the project, and I'm not going to be managing any part of it. So it has to be handled by professionals moving forward. And I've spoken with this about this with the neighbors. And secondly, if we don't grant the side yard, let's go ahead with whatever we could build, because I think all the community members were coming to me and speaking and saying that this has to move somewhere because no one wants to see the hole in the ground at this point. I'm the only member of the LLC, and I guess I never paid attention that my name has to be listed, but I swear I'm the only member. There is no one else on this application. and I purchased the property. So I think everyone in the community would like to go ahead with that somehow. So let's just resolve it and let me know what else I could do. That's why I just thank you so much again. I really would like to work with everyone at this point.
Thank you.
Thank you.
Questions? Mr. Roll.
I have a question for Mr. Lawson. Mr. Lawson, you've argued in the alternative tonight, if we don't grant the variance as requested, that we should at least grant a variance to make this a buildable lot. Do we have before us plans?
Yes, sir, they were on the board that you got. We don't have the interior layout, but we have all 4 elevations if this were to be constructed by right.
But the only format that we've been presented with plans is on that board and not otherwise. Is that right?
Sir, you have the elevations. The inside would have to be redesigned, but that doesn't impact anybody.
Okay. I just posed the same question to staff. Let's say that we were in a universe where we wanted to make this a buildable lot and no more. Does staff have what it needs to be able to execute that variance? Or would you need more materials than you have now?
I haven't even seen what's on the board. I guess we'd have a...
What's on the board you don't, right? Agreed?
Yes.
If you don't see the board, you don't have enough.
I would agree with that.
Okay.
Go ahead, Ms. Malice.
Is that the case, that we can't describe what a buildable lot is without reference to plans?
I guess I'm thinking about how these things are usually done, and they're usually done referring to a set of drawings. That said, I don't know that there's anything that requires you to do that. It's just generally how we've gone about this. So because I'll leave it at that.
We have to make certain determinations, even if we agree that there's a hardship or an unreasonableness of the ordinance. That's not the end of our inquiry. We have to make other determinations about it's not compatibility with the neighborhood, but there's something along the lines of that it wouldn't hurt other property owners, I think. And so it's hard to know that without being able to study something. So,
Mr. Smith.
If I might, Mr. Owen, the variance request is for the applicant to be able to build a single-family dwelling on a non-conforming lot in the RA 8-18 zoning district. I think that's really all that we could say, granted, that we've got a plat, we know what the lot looks like. We're just saying it's buildable. We're not, and then they can do by right whatever they want with it. Or they can come back to us with a...
That's where I'm going, right? That's where I'm leaning. I think perhaps there's many of us that are in that posture. And the question is that something appropriate to do tonight with the record we have before us? Or is it better for us to state our clear intention and then have the right paperwork put in front of us?
I would suggest that that the first thing is to give them the right to build a single-family dwelling in that district, on that non-conforming lot.
Yeah.
And then they want to, and this is what it would look like. Just skip that. And then they have a variance that grants them the right to build on that lot.
The reason I would be disinclined to do that is that there's other variances requests that we get to do a buildable lot that don't have any other, they're not asking for anything else. They're not asking for encroachments on the exterior boundaries or anything. And we normally do require the plans.
Oh, I'm saying no encroachment. We're not granting anything with respect to side yards or anything.
I understand, but I'm saying if this were a fresh application, and we had never heard of this parcel before, we wouldn't ordinarily process a variance request that was simply, we're not giving you any plans. We're just asking to declare this a buildable lot.
Well, we've denied it though, because I can remember a structure on 8th Road that one of these nonprofit corporation wanted to build, and it was a real small V that they wanted to build, and it was just that, to deem this lot buildable, and we said no. And then there was a house on Lee Highway that we did have plans for that, but then he took the plans away and said, just make this, grant me the, make this a buildable lot, because it too was small. I think we said no on that also, but.
See, my concern,
They were really small lots.
my concern is that it with an imaginative architect, it's not out of my imagination that someone could build a spite house here, that they could construct the house in a way that shines lights in a certain direction, or who knows what, right? By right. Yeah. And so I would feel more comfortable seeing plans that then we can say, as we normally do with a variance, build according to the plans. You've proposed a normal house. You can build the normal house, in this normal spot.
Madam Chair, if I might, most builders come in to the permits office. They already have a buildable lot, and they just come in with plans, and want those plans approved. So all we're doing is giving someone the right to go in with plans if we were to say the lot's buildable.
Without any exceptions all the way around.
I beg your pardon?
Without any setback exceptions.
No, with just that, just saying that this non-conforming lot is buildable.
Mr. Law.
I want to get I want the citizens, whether it's 300 or 100, I know they want something in that spot. I know they want something built. I can assume they want it done as quickly as possible. Ms. Keith seems to be willing to do that, even going back to just what she could do by right. So.
Well, I agree in principle, but perhaps not in practice.
Mr. Lawson.
Madam Chair.
Yeah, I was just going to say, you have the 4 elevations. The only thing you don't have is the interior floor plan. We're perfectly willing to construct in accordance with those drawings on that board.
With the understanding that none of the setbacks are relieved.
Yes, ma'am.
Ms. Malice.
Well, now I'm processing that. My goal is to eliminate the eyesore and move on. I think a by right option would do that. I think granting a variance, making this a buildable lot, would do that. I am of two minds, though, on the question of whether we see the plans or not. Yes, we can declare it a buildable lot, but on the other hand, it's not unreasonable, since we are granting a variance. We're doing something special to request those plans. So it's not, to Mr. Owen's point, completely unreasonable to say that in order to grant this special exception that we take one more step. I'm open, Mr. Lawson has now said that he's willing to incorporate these plans into the ruling. That
I am.
is tipping me a little bit.
Okay.
But I want to make sure that these plans that we have on a board are sufficient for you to be able to enforce.
Well, first, I just want to clarify. I think in recent memory, the variance requests like this that I can recall were always accompanied by a use permit request. So there were drawings that had to be created for the use permit that often were just submitted as part of the variance. And so I think that's part of how the typical way we process things has become memorialized. But I would agree that it's not necessarily required just to create a buildable lot. So I just want to say that. I think as long as we have something that outlines the footprint, and I mean, they are full elevations that show, fenestration and that sort of thing. That's something that can be easily evaluated as part of the building permit process.
Do you feel like what was on the poster is sufficient?
I mean,
Sure.
No lot line shown, so it's hard to.
No lot lines are shown?
It's not required. I mean.
No. So I can't say where the eve is.
Mr. Smith.
Madam Chair, I move that the Board of Zoning Appeals grant a variance making in V-11099-16-VA-3 grant a variance to permit construction of a single-family dwelling on a non-conforming lot in the RA 8-18 zoning district.
Second.
Madam Chair,
Mr. Owen.
I would like to offer an amendment to the main motion to add 4 conditions, namely the conditions listed on page 6 of the staff report, except in condition number 1 where it says dated December 15th, 2017, substituting presented to the Board of Zoning Appeals on December 20th, 2017.
I agree.
Agreed.
I ask unanimous consent to add those conditions.
Agreed.
I further, just for the sake of clarity, would make an additional amendment offered for unanimous consent, that an additional sentence at the end of the motion, the BZA hereby denies the other relief requested.
I agree.
Agreed. Moved and seconded as amended.
One other amendment to strike the whereas clause, saying the BZA finds the strict application of the terms of the zoning ordinance would unreasonably restrict the utilization of the property, leaving the other criterion for variance.
That's fine.
Okay. Does everybody understand what they're voting? Thank you.
Leave the undue hardship.
Okay. Mr.
Could you
Melman.
could you repeat about the use of the plans submitted tonight?
So the condition number 1, which would be mostly the same language as what's in the staff report, would read, the applicant agrees that the structure shall be constructed in accordance with the footprint shown on the survey and architectural drawings attached to the staff report. I'm sorry. Oh, I should amend that further. Architectural drawings presented to the Board of Zoning Appeals on December 20th, 2017, and that no enlargement of the structure addition may be made in any dimension shown on the plat or architectural drawings.
Okay. Are we clear? All those in favor?
Aye.
Oh, Mr. Lawson.
I just wanted to point out that the side elevations are in the staff report. It's only the front and rear that are altered.
Got it.
What? What was that?
It's only the front and rear that are altered because the encroachment asked for is only to the side. So they would use the same side elevations because there's no encroachment requested for them.
Because that's already by right.
Got it. Okay.
Chair?
Mr. Owen.
Based on Mr. Lawson's additional statement, I would ask unanimous consent to insert an additional parenthetical phrase after 2017 in the first condition to say, or contained in the staff report as applicable.
That's fine.
Okay.
Madam Chair, I move that we incorporate that last clause in the earlier adopted resolution granting the applicant permission to build in V-11099-16-VA3.
Madam Chair?
Mr. Owen.
I just want to ask the zoning administrator and staff, do you have absolute clarity on what the motion is that we're doing, or do you want clarification?
I think we'll need to get it from you. I just want to be clear, the only materials that are being added are what's on this board, because this board only has elevations, it doesn't actually have.
You can use any applicable material in the staff report to supplement that.
Okay, and in the event they aren't consistent?
The poster would control.
Okay.
Are we good?
Yeah, that's fine.
So we've already voted, actually, but we need to revote.
Yeah, I need a clarification. Okay, this footprint on the survey.
Yes.
So that contains, if we're talking about the footprint of what's being requested, that basically has the footprint of the building that they wanted to begin with.
No, the by right, he submitted on that board a by right structure
This is the problem. What's on the board are only elevations. They
Okay.
don't show distances to the property lines.
He can't go outside of what
There's another board.
what the law allows, because we're not granting any side yard or rear or
No
front
relief
yard
of any
setback.
sort.
Got it.
We're only making this non-conforming lot.
Okay, because
If they want anything other than what they can get by right, they have to come with a special use permit then.
on the motion, I didn't hear specifying the survey that designates the by right use.
There may be none.
Right.
I just want to avoid giving them the leeway to build a spite house. So I want them to build something that's compatible with the drawings that they did submit, and they have to worry about scooching it into a by right spot on the property.
But the footprint is definitely, if we're going to mention
That's
a.
not applicable.
That's not, that doesn't count.
The zoning administrator would have to ignore that page.
I know, but if we're mentioning a footprint of a survey, we got to say what survey.
Where are we mentioning a survey?
They'd be removed.
Well,
Oh, I see what he's saying. Number one, he's absolutely correct.
all right.
Yeah, maybe strike the language of a survey.
Shown survey.
It would simply be, the applicant agrees that the structure shall be constructed in accordance with applicable law. That limits them.
Yeah, I'd be good with that.
Forget
language.
architectural drawings, et cetera, et cetera, et cetera. I mean, I understand Mr. Owen's desire to try to prevent something from happening, but when you say you've got a buildable lot, it goes without saying, but I'll say it, you have to build by right. If you want to do something other than what you're entitled to do by right, then you have to come back to us. And I don't think that
They're not
the Civic
doing it.
Association or any of the other hundreds of other people who have weighed in on this over the years want to hear it.
Wow.
So it's really just making it buildable. They're going to build what they can by right. If they have to not utilize some of the foundation or eliminate some of the foundation, that's on them entirely. And it's in terms of side yards, footprints, what exists, all that becomes moot, from my point of view.
Mr. Smith,
And that was the intent of my motion.
your motion. Because
Yeah, I made the
what,
motion.
could the motion that Mr. Owen made,
No, he added
I asked
multiple
for unanimous
amendments.
consent for changes to the main motion.
Mr. Owen made that refers to staff report, the drawings already, that was accepted. So we're getting a little confused in our motion.
Well, let me ask that, let me move that we,
But we've voted on this motion.
Revisit.
yeah, let's revisit that motion so that I make it clean. I move that we revisit,
Reconsider.
and reconsider V-1109-16-VA3.
Second.
Second. All those in favor?
Aye.
Fine.
Madam Chair, I move
Mr.
that
Smith.
we grant the applicant in V-1109-16-VA3, we grant them permission to construct a single-family dwelling on a non-conforming lot in the R8-18 zoning district known as 2116 North Culpeper Street. Period.
Second. Yes, Mr. Owen.
I move that we add a condition that the applicant shall obtain a building permit to construct the structures permitted herein by December 20th, 2018, or the variance shall be null and void.
Well, let me not, okay, and with the condition, I don't have a problem with that condition, because I think state law governs that. If it's not shorter than a year, then it's automatically a year. But I don't want to go down the road of brick by brick adding back to get back to the point that where it collapsed. This is the leaning tower of Heidelberg that we don't want to fall over.
Minutes or so.
So that's what I don't have a problem with saying that they have to build or vest their.
Well, I just want to be orderly, right? Because I have the sense that staff and perhaps the applicant and the community are now quite confused about what we're actually doing. So I don't want to, another alternative I considered was making some kind of substitute motion that has all sorts of other things, but I want to work from what I think is the least controversial to the most controversial so that it's clear what we have agreement on and what we don't. So that's my strategy here.
And what we're moving is that it is a buildable lot with no relief. So they have to follow the regulations to the letter, even including maybe not using the existing foundation or whatever.
Why don't we just take a vote on the motion? If the staff understands the motion as you made it with no modifications, I'm going to vote no because I don't think it has enough protections. But maybe I'll just be outvoted and I don't need to prolong the meeting.
Could we restate the motion? Because what I think the chair said is different than what Mr. Smith said.
Madam Chair, in the case of V-11099-16-VA3, I move that we grant the variance request by Elena Keith to permit construction of a single-family dwelling on a non-conforming lot in the RA 8-18 zoning district, and that such variance must vest within a year.
Second. Is that clear?
Was that a yes?
Okay. All those in favor? Aye. Opposed? No. 4-1. Thank you. Bye. Happy New Year.
I think there was an abstention
Oh,
here.
okay. 3-1-1. Sorry.
What was the other?
She abstained.
Next case, after which we will take a brief break.
Case number V-11238-17-VA-1 is a variance request by Douglas Marshall, the owner, to permit a main building footprint of 35.7% and total lot coverage of 47.9% regarding a new two-story addition with attached garage in the R8 zoning district, premise known as 6100 31st Street North. Staff recommends that the board adopt the attached resolution denying the variance. An alternative resolution has been provided should the BZA wish to grant the variance with conditions.
Questions for staff? Mr. Lawson, you're up again.
Yes, ma'am, and I apologize for you're seeing so much of me today. They just all ended up tonight. I apologize.
An embarrassment of riches.
Well, for the record, I am William B. Lawson, Jr., represent the applicant. The request is to construct a caretaker suite, and that is so that his mom can move into the home and the family can provide daycare to his mother. Unfortunately, if you have to hire help to look after someone, it's like $25 an hour, and this family just simply cannot afford it. The main building footprint will be high if this is granted, and that's because we're adding the garage into the house, which is to allow the handicapped access, and we're also filling in the area in between. Because of the configuration of the lot in the house, we have done a redesign, and it's the best that we can do. The problems that we had in addressing the coverage was the location of the current pole, which we can't move without great expense. And also, we need a certain garage height in order to be able to accommodate the handicapped person. And then you can see the topography. We can't go but so far down. So those are the situations we're dealing with. Years ago, I did a sign case for Silver Diner and for Metro 29 Diner. We had astronomical figures for the signs. That's because the neon band was measured. We kind of have the same thing here, and that is that it looks like an astronomical request, but when you look at it, it's really not that much. We're adding 252 square feet of coverage, or 0.8% coverage. We can even remove a second driveway on the other side of the home, which will lower it even more. But the hardship that we have and the problem that we have is, as you read the state code in the beginning of the meeting, Chairman Freshman, you talked about the current status of the property, and that's the problem that we have here. Mr. Marshall's house is already spread out, and so there's nothing he can do about that. He has a detached garage, and he has to fill in the area in between. He has a pagoda, which is counted towards coverage, that was not counted towards coverage years ago. The ADA, we have another gentleman who's going to address that, so I won't get into that. I will say, though, that I've always been trained, you don't care about the people, you only care about the property, but that's no longer true with the ADA having been passed. We also have a use permit. There are two use permits requests. One is for the setback, and the other is to, I don't know what exactly it is, to modify the prior variance approval. And in the memo that I submitted, under Virginia law, once a variance is granted and implemented, then for all purposes under all ordinances, it's supposed to be considered in compliance. So I don't believe that that's even necessary that it been done. The final thing I wanted to share is Martha Moore wanted to come tonight, but she could not. So she gave me a statement she'd like for you all to read and consider. And one of the points that I'd like to highlight of Martha Moore's is that she's talking about, we get bonuses in coverage for a front porch, and we get a bonus in coverage for a garage. But we don't get a bonus in coverage for aging in place or providing improvements that will make a handicapped person's life better. And, that's in my opinion, not accommodating a person who has that need. I'll hand this out and then be happy to answer questions.
Questions from Mr. Lawson?
Madam Chair?
Ms. Malice?
So what is the hardship that we're evaluating?
Well, I think the hardship is the fact that, let me look up the. They're talking about notwithstanding any other provision of law, variance shall be granted if evidence shows strict application of the terms of the ordinance would unreasonably restrict the utilization of the property, or that the granting of the variance would alleviate a hardship due to a physical condition relating to the property or improvements thereon. And so the reason we need the variance is because of the improvements thereon. We already violate the coverage restrictions. And so the reasonable use that we want to implement is to provide a caretaker suite. And in order to do that, the only place we can do it is that gap in between the garage and the house, and incorporating the garage into the main house footprint, which gives us this high coverage figure. In our revisions that we did, we were able to lower the coverage to 34.1%, which was the best that we could do. And the overall coverage we lowered to 46.2%. If we take out the driveway that's there, you can barely see it. If we take that out, the overall coverage goes to 43%.
Mr. Lawson, I just had a chance to glance at Ms. Moore's letter. Would you not agree that granting a decision to grant bonus density or bonus coverage is a legislative issue?
No, it's a variance.
All the other bonuses that we use in the county and zoning are legislative.
You're talking about for the front porch and for the garage.
Exactly.
Yes, that is, you get a bonus if you design so that you have the front porch, and you get a bonus if you have a detached garage.
That's in the zoning.
And that's not in the ordinance, but if you have a hardship and need more coverage, a variance is the appropriate route.
I agree if you have a hardship, but I think what Ms. Moore is talking about is making a change to the zoning ordinance to allow that to be incorporated into what staff reviews rather than what we review.
She thinks that until such time as that is done, she would hope that you all would be granting relief.
Mr. Melnick first.
So, in reference to the hardship, something that I wanted to clarify is it's related to the real property itself, the improvements, that kind of thing, and not, we've had other cases where, the person is like looking at it from the person's standpoint that lives there, that
Right.
they have a certain issue and therefore they want a variance. But wouldn't you agree that we need to look strictly at the real estate?
Not with the ADA. And Jonathan Mook is here. He's going to speak. He's submitted a speaker slip. That used to be the case. And if you all had a chance to read the Falls Church case, the zoning administrator in Falls Church said we should have denied it. It had nothing to do with the property. But under the ADA, that's changed. You now have to look at the owner.
But doesn't that, correct me if I'm wrong, but does that stay within the variance framework, the statutory language of the variance, or is that a different, a federal law issue, the ADA, even outside of the variance statute?
Well, I think it supersedes the variance statute, and what it says is localities are required to make reasonable modifications to policies, practices, or procedures to prevent discrimination on the basis of disability. Reasonable modifications can include modifications to local laws, ordinances, and regulations that adversely impact people with disabilities. For example, it may be a reasonable modification to grant a variance for zoning requirements and setbacks, which is exactly what we're asking for.
What were you quoting from?
This is from the Albemarle Land Use Handbook, Albemarle County Land Use Handbook. It's in the material that I sent to you all.
Mr. Lawson.
Charlottesville. It's not a zoning.
Madam Chair.
Mr. Owen.
Mr. Lawson, on that point, why, that may be Albemarle's choice, right? But I don't understand the logical endpoint for why you don't just apply for a building permit. And if you don't get the building permit, you say, well, the ADA trumps the building permit law. Why us? Why not the circuit court after we deny? Why not the zoning administrator or the building permit officials?
I think you have to exhaust your administrative remedy, which is seeking a variance. And if you all should deny it, then if Mr. Marshall chooses to, I think he can go to either federal or Arlington Circuit Court. The expert is here. This time I decide I don't know enough to answer these questions. We have an expert in the ADA law who's ready to speak.
Okay. Mr. Smith.
Isn't your hardship that the law changed, that the law used to allow 56% coverage and now it doesn't?
Correct. That's part of it. Yeah. When Mr. Marshall bought it, and I keep telling him, look, the laws change, okay? Laws change. When he bought it, he had a grand plan to go to 56%. And then, of course, when the law changed, that took away that right.
Let's hear from the expert. Mr. Mook? Jonathan Mook.
Thank you. Okay, I've got 2 minutes. My name is Jonathan Mook, and I'm a partner at the law firm of DeMuro Ginsburg in Alexandria, Virginia. For almost 30 years, I've written extensively and practiced in the area of the Americans with Disabilities Act, so I trust my remarks will provide you with some important insight into why the ADA would compel the granting of a variance in Mr. Marshall's case. In this regard, I'd like to highlight 2 points about the ADA as it applies here. The first is that the ADA, a federal law, requires that local governments, under Title II of the ADA, that is the applicable statutory provision, local governments like Arlington County must make reasonable accommodations to modify zoning regulations or policies on a case-by-case basis to enable persons with disabilities to fully enjoy the use of their homes just like non-disabled individuals. So it trumps state law, it trumps Arlington County zoning regulations. The fact that Albemarle County has adopted in a zoning book the requirements of the federal law certainly is precedent for Arlington County to follow those requirements. Since it is federal law, it is not just a choice by Arlington County, by choice by Albemarle County to do so. Second, whereas here a county resident like Mr. Marshall seeks a zoning variance to reconfigure his house for one-floor living as a reasonable accommodation for him, given his back disability, and also more particularly at this point for his aging mother, the county must, one, consider the request and grant such a reasonable request, such as Mr. Marshall has made, unless the county can demonstrate that doing so would unduly burden or fundamentally alter the purpose of the zoning laws. The burden is on the county to demonstrate that granting the variance would constitute a fundamental alteration of the purpose of the zoning laws in this instance with regard to Mr. Marshall's property. I would submit that the county's report makes no showing that granting the variance in this case would demonstrate that granting the variance would fundamentally alter the nature of the zoning laws and the purpose of the zoning laws for the residential property and the neighborhood in which Mr. Marshall resides. The house as modified certainly is going to continue to conform to the residential nature of the neighborhood and the neighboring homes. Second, the variance requested will not adversely impact the neighbors. Mr. Marshall has signed, there's a petition signed by 9 of the neighbors in support of Mr. Marshall's variance. No neighbor has lodged any objection to Mr. Marshall's variance. And I think finally and significantly, just turning back to the county's report, the county staff report points to no purported purpose of the zoning laws that would be transgressed should the variance be granted. There's not even an inkling of a showing of a fundamental alteration of the zoning laws should the variance be granted in this circumstance. So accordingly, I would submit to you that federal law, the ADA, requires the granting of a variance in this instance. I know I'm out of time, but for more details about the requirements, I'd refer you to the materials that Mr. Lawson submitted in support of Mr. Marshall's zoning application. In particular, I have an April 13th, 2016 letter to Mr. Barnes about the ADA requirements as well as the requirements of the Federal Housing Act, which are a corollary to the ADA requirements, as well as I would hand up to you and submit for the record a letter that I wrote to the Office of the County Attorney this summer. It's dated July 14th, 2017, pertaining to Mr. Marshall's variance application and the legal standard by which to assess that application, which discusses in some more detail the requirements of the ADA and the burdens of proof that are required under that statute. And in short, I would submit that the letters that have been submitted, the letters that are being submitted here do support the points that I have raised here, as that this zoning variance request must be granted to be in conformity with the requirements of the ADA.
Thank you. Mr. Melnick.
Can I ask a question of the staff, please?
Sure.
Okay, just since we've been hearing, about the ADA, does the staff have any response or any analysis on the staff's part about the argument of the ADA trumping the variance, or that?
We haven't had a chance to even read all of this material. The material came in on Friday as we were stuffing the packets into the envelopes for distribution. It hasn't been thoroughly reviewed. We haven't discussed it with the county attorney, which we did on the last similar request we had like this that brought up the ADA argument. The ADA argument was never brought forth as part of the initial application. This is the first time that this has been brought to our attention, was Friday, as we were ushering the packets out of the office. So we have no comment on it, on whether or not our recommendation would change. I would think at least we would need a little more information. From the last time we had a variance request where an ADA accommodation was being sought, I believe, and again, I haven't read, it's a lot of material. I believe one of the first things we had to get was some sort of attestation of what the medical condition was and how, and so from there you determine what's a reasonable accommodation to address it and what zoning relief might be appropriate. To my knowledge, I don't even know if that's been submitted. What I briefly saw were, it looks like a court case, a proceeding from some other jurisdiction, and some general information about ADA and other things. But I'm not clear on what are we accommodating, and so from there, then we can evaluate what's reasonable, and move forward. But I guess we're not prepared to make we're not really prepared to talk about it because a lot of this came at the last minute, and we just haven't reviewed it.
Madam Chair.
Mr. Smith.
I do have a question of Mr. Moak. But first, they just turned in a letter that's addressed to both Min Chow and Christine Sanders, who do zoning, dated July 14th, that talks just about this.
It wasn't submitted to us as part of reviewing this application. So I'm not familiar with.
The county attorney does it. I mean, it's regarding Douglas Marshall, and it's dealing with a zoning ordinance issue. There was only one, so I guess I'm at a loss to understand how they wouldn't communicate or why. I find it kind of hard to fathom that this is new when we have evidence that it's not. But be that as it may, earlier, Mr. Moak, and that wasn't a question, but Mr. Moak, Mr. Owen made a suggestion that a better course maybe would be to be thwarted at the permit office, to be told, no, you can't do that, and then to either go to the circuit court or the United States District Court, versus coming here for a for a hearing, and maybe to me to kind of create some precedent, maybe break new ground. Yes, we did have a case where someone had cancer and they wanted to redo the front of their house to make it more accessible, et cetera, et cetera, et cetera, and they did bring forth medical evidence and the like. But I guess I'd want to for you to address why we should, I think, break new ground and establish a precedent for granting a variance based on compliance with the ADA.
Well, let me say,
and I guess that would be it'd be a hardship, I guess you're describing.
right, well, I guess I could answer it in two ways. One is there may be various ways that a county could comply with the ADA, and challenges may be brought with respect to county decision-making. But that certainly it is recognized in the case law, and the case law that are cited in the submissions that have been made, that a resident may request a variance to the zoning regulations as a reasonable accommodation to accommodate that resident's disability in order to reconfigure the layout of his or her home to accommodate a disability, and that seeking a request through the zoning administration procedures is an appropriate way to go. And actually, that the Board of Zoning and the Board of Zoning Appeals have an obligation to comply with the requirements of the ADA, and if the request is an appropriate, reasonable accommodation that would not fundamentally alter the nature of the zoning laws, to grant the request.
Madam Chair?
Ms. Mouse.
Just on your last point, I'm not sure that our charter has anything to do with federal law. It has to do with local law, but that's just an opinion.
That may well be the case, but federal, obviously in making zoning decisions, federal
The county
requirements
makes-
must be met, I mean, including the religious accommodation requirements of,
So one of the problems, we had a case where, we discussed it thoroughly and had a lot of different, talked about different aspects of it. And one of the fundamentals for us was that variances go with the land and not the occupant. And so we had a question as to when that property is no longer occupied by a handicapped person, do those ADA accommodations sunset and need to be removed?
well, that would then require the property owner to then, a new property owner to then reconfigure the land back to what it was before. And that seems to me not really to be feasible.
Then how do you get around the fact that the accommodation is for the occupant and not the land?
Except that the occupant is living on the land in a dwelling house such that the zoning regulations need to be, a variance needs to be granted to allow the occupant to enjoy the use of the land as somebody who is non-disabled. And once that's granted, you're asking me prospectively, can the county then sunset the provision? Frankly, I don't have an answer to that, and I have not read any legal decisions dealing with that issue at the zoning level.
At other things in the county. So anyway, just to me, it seems to me that we cannot move forward on this case tonight if staff has not had an opportunity to.
Okay. I have two things. First of all, I have another speaker. Secondly, I would like to remind you, as you deliberate, that this application has had seven deferrals. And a lot of the reason why it's as late as it is and we're only on item 4 is because we have a lot of these kinds of issues. Not as many as this sort of serial issue, but it is an ongoing issue. I just want you to keep that in mind. May I call the next speaker, please?
Bearing that in mind, I want to alert you that as soon as the speaker is finished, I'm prepared to make a motion.
Thank you. Elizabeth Wildhack.
Mom, and she has a court case tomorrow morning.
She what?
She represents
Mom? Mom? Oh, okay.
Court case in the morning.
Yes, thank you. Mr. Owen.
Madam Chair, I move that the Board of Zoning Appeals adopt the attached proposed resolution denying variance V-11238-17-VA1.
Second.
It's moved and seconded to deny the variance. Any comments, questions? All those in favor?
Aye.
Aye.
Nay.
4-1. Thank you. Next case.
Case number V-11238-17-UP1 is a use permit request by Douglas Marshall, the owner, to permit a setback of 23.2 feet to the wall from the North Ohio Street right-of-way instead of 25 feet as required, and to modify a previous variance approval for that permitted setback. That permitted a setback of 16 feet to the 31st Street right-of-way and 10.8 feet to the North Ohio Street right-of-way for a front porch, regarding a new two-story addition with attached garage and enclosed front porch in the R8 zoning district, premise known as 6100 31st Street North.
Madam Chair,
Mr. Owen.
what happened to item V-11238-17-UP-1?
That's
what we're
I'm
doing.
reading.
What's the address?
He just read.
Ohio?
That's a different.
Oh, I see. It's the use permit. I'm sorry.
It's the same.
I was hearing a different street name than was on the top of
Well,
the
it's the
caption.
corner of Ohio.
Right, sorry. Madam Chair,
Mr. Owen.
or do we have any speakers?
No, I don't think so.
Madam Chair, in the case of V-11238-17-UP1, I move that the Board of Zoning Appeals deny the application.
Second.
Moved and seconded for denial. Questions, comments? All those in favor?
Aye.
Thank you. 5-minute break, please.
Five. Okay. Yeah. I mean, pointless.
I just want to get my number.
Yeah, no. You got to win on the big one, then you just throw in the cards.
There's some snacks in the back. I need some.
You don't want to switch off or anything?
Sure.
Second half leg.
Giving Simon a little break.
Relief pitcher coming in from the set for the later innings, except you're starting early. I know, what a day, what a night. Judy wants to go. The week after.
We've got two, so we have the last. So, that was.
Somebody just added one?
Yep. Be around.
Yeah, we might have to switch off again.
Yeah, I should probably get something to eat too. I haven't really eaten dinner, so that's gonna come back. Just wondering.
I was staying 11:30 earlier. Dude. Split point.
Well, so would you go here over here department at the end?
I'm going back.
Yeah, I'm gonna take a little.
Get a plate? Yeah, it's like, almost like candy, like a Heath bar or something.
Yeah.
Not bad. Caramel, so it's not chewy.
Yeah.
Good.
I'll go back tomorrow.
I mean, I did bring some baggies. No, take leftovers home.
When they did, we said they have to come to us. You know what I mean? It's like, what are you talking about? Right? They applied for an area.
we here? No, who's here? Charles is here.
I'm just going overboard.
Where's your plate?
No,
Yeah.
I'm conserving plates. Same difference. It's amazing what you can do with an apple. But when it comes to this stuff, I know new bounds. That's the trouble.
I know. I mean, normally I would never. I bring my snack. I never eat it.
Yeah. I really appreciate you bringing it.
And it's just adding it. As opposed to one.
Oh, excuse my pants. Okay, you're right. Let me get a napkin. So I don't get chocolate.
Okay. Let's go, folks.
Approach and parse it and ask for brief.
Okay, ready to go? He's right here behind you. I sent him to get a napkin. Okay. Next case, please.
Case number V-11296-17-UP1 is a use permit request by Harry and Yulia Lehman, owners, to permit a 6-foot-high fence instead of 3 feet within the 25-foot triangle required for visual clearance on the front left corner of the property, and to permit a 6-foot-high fence parallel to the right and left side property lines instead of 4 feet as required within 25 feet from the easement for street purposes adjacent to the South Monroe Street right-of-way. Regarding a fence with associated columns in the R5 zoning district on the premise known as 1117 South Monroe Street. Staff recommends that the board adopt the attached resolution granting the use permit with conditions. An alternative resolution is provided should the board wish to deny the use permit request.
Questions for staff? Applicant, please.
Good evening. Even though I was not present during the October's meeting, but I will be doing most of the talking because Mr. Lehman just underwent the total knee replacement surgery and he's under a lot of pain and under medication. So I will be doing most of the talking. So my understanding was that during the last meeting, one of the HOA board members testified that the HOA never had a chance to review the documents pertaining to the fence installation. So I have the permit from the HOA, and you have it on file also, which was issued on June 24th, 2016. And it was issued 10 days after the Arlington County issued their permit, and they had 10 days to review it. And after they carefully reviewed everything, they granted their permit. And in September, we constructed the first brick piers, and that were set in there for approximately 5 months before the panels arrived, because those were in fabrication. And if you allow me, I have a picture over here that shows that it was done in the summer, and we still have the snow fence around it. And we never heard any complaints while the columns were sitting there without any panels. And then in late December, the first set of panels arrived, and 1 month later, still panels. And 1 month later, the rest of the panels arrived, and then the project was nearly complete. So we never heard any kind of complaints. No one raised any concerns. The woman that testified, I believe it's Miss Pacey, she lives 25 feet away from our property. We never heard anything from her. And the other HOA board member lives just the next door. A neighbor lives 10 feet away from the property. And they never raised any concerns or any issues. So now, 18 months later, after the permit was issued, they are saying that they never had a chance to review it. I don't know whether it's personal. I know that they're representing the HOA, but as you can see, it has the HOA over here that was granted to us. And besides that, we were in continuous communication with the community manager, who works as actually acts as an agent acting on behalf of the Pike HOA. And we had various telephone communications with him. We had various emails, and we have a lot of emails, and I did not bring all of them, but if you want to, I just have one of the last emails that we were corresponding with each other. So they were aware of every step of the construction. They knew everything. We were telling them where we were at and what we were doing. So, okay, well, let's move on. And so we were asked to look at this question and to come up with the solution. So we have two beads over here to lower the column, and it's a 3-foot. They want us, so I believe the HOA proposes to lower the column to a 3-foot that would be framed by a 4 and a 6-foot panel. And you have that drawing in front of you, but I would like to show you another drawing that shows, let's say, if we do that, and an adult standing over there, this is what it would look like, because this is a security fence. So if you allow me to show you this.
And that's me.
So as the security, this is what they propose, and they call it a simple fix. And when we got the bid from the contractor, this is not a simple fix. It's a very costly fix, extremely costly, because it's we have to remodify some of the panels because of the layout of the land. And we have the gap of 1.5 feet from one corner of the lot to another corner of the lot. So it's not just a simple fix where you cut everything and chop down everything. It has to be redesigned completely. So this is the first bid. And the second bid, when we looked at it, evidently they claim that someone feels uncomfortable walking around the 20 by 20 brick column with a square area of 211.
Could you sum up, please?
Okay.
No. I'm just saying your time is up. So.
Okay.
Okay. And this last one is cheaper because we already have panels that can fit there. Okay.
Okay. Questions of the applicant?
Madam Chair, you were referring to something that, is it in front of us? You said some panels that are, and then you held up something.
Oh, no.
No, these are just the bids. You have those on file. Yes, you have those on file.
That's for action fabricators and erectors.
Yes, yes.
Yep.
Okay. I do have a speaker, so why don't you just take a seat? Teresa Buchanan.
Good evening, and thank you for the opportunity to speak. My name is Teresa Buchanan. I'm president of the Pike 3400 Towns Homeowners Association, and I live on 11th Street South. We definitely are very disappointed that this has become so contentious. Our Pike 3400 Towns HOA has been committed to the health, safety, and welfare of our entire community. We all purchased our properties with full knowledge that we were subject to governing documents. Our board has granted requests to these homeowners, for instance, in closing their verandas, because we've also recognized that it is a single-family home in a community of other townhomes. But that was the site plan development, and that's what we all bought into. And we've continued to be invested in living as a community. But this variance application has not one verifiable signature from any of our HOA community. And this particular home was the last dwelling structure that was built in our community. This particular fence was approved by the developer-controlled homeowners association. We transitioned to a homeowners-controlled association in August of last year. And at that time, we were aware that a fence was, had been approved and the permit had been granted, and we were also told that we had no say in how it went forward. What we do know is that a number of our residents have encountered near collisions, whether they're pushing baby strollers or riding on a bike. It's also been difficult with times when we saw the height of the brick column on the corner when you're on 11th Street approaching South Monroe, and both of these streets see significant traffic. We offered a compromise with lowering the corner pillar, but instead, we received a letter from their attorney seeking to withdraw from our association, and that is not going to happen. We're not a gate-controlled community. We're in a wonderful transitional Arlington neighborhood, and we just want to live together as neighbors. Thank you.
Is that the last speaker?
Thank you. The last speaker. Question? Yes.
In my view, this is an unusual case for a number of reasons. One is that there have been a series of administrative missteps that very understandably place a basically innocent property owner in a very infuriating position, for which they have my sympathy. The other thing, though, is that this is, in my view, a safety issue. And so, unlike in a lot of other circumstances where I would want to encourage neighbors to compromise with each other, I don't really feel like, I agree with one of the writings, actually, that the applicant put forward that, in my view, the HOA is not the right entity to negotiate on a safety issue, because this is about public safety for everyone who uses the intersection. So my spot on this, which I know is not shared by everybody else in the BZA, is that I'm prepared to grant complete relief for the right side property line and no relief at all from the zoning ordinance on any rest of the parcel. So I'll just say that's where I am. I guess the other thing I'll note, we've had many hearings on this, but this came to the BZA out of a complaint. Someone complained about this after it was built, possibly someone from the public who was experiencing it. So this isn't something that's made up out of either bureaucratic churning or out of neighborly disrelations. This came up because someone went by it and said, this can't be right, complained to the county, said, take a look at it, and they said, yeah, it does violate a safety regulation. So that's where I stand. That hopefully will make it easier to craft whatever motions other people want to craft, because they know how I'm going to vote on them.
Mr. Owen, could you, in the subject area, can you indicate what you would approve and what you would disapprove?
In the subject area?
Or in the resolution?
Oh, there's a fence on the right side property line that abuts the townhomes, and that's higher in the first 25 feet. That's 6 feet tall, and it shouldn't be more than 4. But because it's up against a wall, it does not pose a safety issue.
I understand what you're talking about. I'm just looking for text.
Oh.
I'm looking for text as to how this would be modified.
So you're only talking about that and
Yeah.
not anything else like that?
Yeah, I don't actually have text to point to at this time, because I think I thought it would be more productive for BZA members to state what they want to get so that people can figure out where 3 votes are. And then we could work on text at that point.
Okay.
Other questions or comments?
I guess it's a question for staff. The homeowners association can't overrule what we do here. Is that correct? I mean, if we made a ruling and they were unhappy with it, have we violated some covenant that, or agreements they have?
They can use the civil process to make things tighter, but they can't make things looser than we make it because we're the government.
Thank you.
Other questions or comments?
Okay.
Mr. Malnick.
Has that been seconded?
There's no motion.
There's no motion.
Okay.
Ru-
I'm prepared to second a motion of that sort.
Second, a motion of what sort?
Of what Peter was describing, the general idea.
Okay. Could you clarify? You're talking about the two street frontages remain, and the one, there's a fence against another dwelling?
Well, so we look at what's on the screen now.
Yes.
The practical effect of my views, which are not yet a motion, is that the applicant would need to figure out a way to remove the stuff in red. And they wouldn't have to submit anything to us. They would just have to sort it out, but they can't build where the red is. On another part of the property that's not shown in this drawing, which is the part on the right side property line up against the townhouses, I would grant them relief to keep the fence that they have in that location, which does not pose a safety hazard and for which they have a permit.
Okay, I understand it. I don't agree, but I understand it. Any other comments or questions? Or motions? Essentially, the recommendation of the staff is to leave it as is. Is that correct?
Chair?
Mr. Owen.
I'm going to make a motion. And to follow along with my motion, you can look at the caption and the subject line of the staff report. So I move that the Board of Zoning Appeals grant a use permit to permit, and then you could, in your mind, strike the words a 6-foot-high fence instead of a 3-foot-high, et cetera, et cetera, et cetera, all the way until you get to the word, to the rest of that sentence. And then it would pick up a 6-foot-high fence parallel to the right side property line instead of 4 feet as required, within 25 feet of the easement for street purposes adjacent to the South Monroe Street right-of-way. Re-offense and the rest of it. So to permit a 6-foot-high fence parallel to the right side property lines instead of 4 feet as required within 25 feet, and none of the other relief. So that would be my motion.
I second it.
Discussion? I prefer to keep it as is. That's my own opinion. If there's no other discussion, let's vote on the motion. All those in favor?
Aye.
Opposed?
Aye.
No.
Or no.
3-2. Sorry.
Madam Chair, I just
Mr.
want to thank the applicants and the Civic Association, or the HOA, because I think this was a very confusing process. And in my view, the way that this played out made it hard for you guys to figure out what you were supposed to do, and that may have contributed to tensions between you, and that's regrettable. So I just say, from my perspective, I'm sorry you had to go through that, and I'm sorry that to the extent that this process contributed to your discussions being tense as neighbors, that's regrettable, and I hope that you can repair that going forward, because it wasn't entirely your fault.
Next case, please.
Case number V-11324-17-VA-1 is a variance request by George and Laura Johnson, owners, to permit a maximum main building footprint coverage with a front porch of 28.9% instead of 28% as required regarding a new rear screen porch with deck less than 4 feet above adjacent grade in the R10 zoning district on premise known as 3415 North Vermont Street. Staff recommends that the board accept the applicant's request to defer this item to the February 2018 BZA hearing, and I'll have you note that there's supplemental material, which is an email from the applicant requesting a deferral.
Okay, I'd like to make a comment. We already have several very contentious items that have been deferred to February. And February is notoriously heavy agenda because there's no January meeting. So I think if we in fact have to defer this, I would prefer that it go to March.
Madam Chair.
Applicant?
Oh, is the applicant here?
Is the applicant here?
Oh, sorry.
Okay, Mr. Applicant.
Thank you for the opportunity. Just wanted to make it quick. I know it's a full agenda, and I'm fine with going to March to alleviate any backlog.
Thank you.
I heard your last request for a legal argument. I've tried to engage some legal counsel to get that done. He's requested to meet with the architect to go over what constitutes lot coverage. They haven't had an opportunity to meet yet through the Thanksgiving and Christmas holidays, so I'm trying to get that meeting to occur. So I appreciate a deferral if it's possible.
So you're fine with March?
I am. Thank you.
Excellent.
Madam Chair.
Mr. Smith.
In the case of B-11324-17-VA1, I move that the Board of Zoning Appeals defer this matter to the March meeting of the BZA.
Second.
Moved and seconded to
Chair.
Mr. Owen.
Yes, I'd just say I'm concerned about this deferral because I actually don't think that it's likely that you will ever get a variance. And so I worry, just like we had with the last one, where we deferred for further discussions that really didn't move things forward. And so I just want to put it in the record that I think the applicant may spend less money on lawyers and spinning his wheels in unproductive directions if we just denied it. But I appreciate that we're going to defer it, but I just have a lot of skepticism about whether it's even in the applicant's interest to defer this item.
Thank you. It's been moved and seconded to defer this item to the March 2018 BZA meeting. All those in favor? Aye. Opposed? No. 4-1. Thank you. Next case, please.
Case number V-11325-17-UP1 is a use permit request by Eric M. Marion, the owner, to permit a setback of 17.6 feet to the wall, 15.4 feet to the eaves, instead of 25 feet to the wall, 21 feet to the eaves, as required from the South Hayes Street right-of-way, and to permit a structure of more than 2.5 stories within 25 feet of a street right-of-way, and to permit a setback of 12.8 feet to the porch, 11.4 feet to the porch eaves instead of 21 feet to the porch, 19.5 feet to the porch eaves as required from the South Hayes Street right-of-way regarding the renovation of a single-family dwelling including a new 3-story addition and new porch on a corner lot in the R5 zoning district on the premise known as 735 21st Street South. Staff recommends that the board adopt the proposed resolution approving the subject use permit with conditions. And I'd have you please note that there is supplemental material for this case that came in after the application packet was assembled and printed, including an additional signature provided by the applicant, as well as an updated letter from the Civic Association and a letter of opposition from one of the directly adjacent neighbors.
Thank you. Questions for staff? Applicant, please.
Good evening, Madam Chair, members of the board. I'm Eric Marion. I'm the owner. I have Chris Chu with me. He's with Moss Building and Design. I'll be speaking, but I have him just in case there are some questions about design that I'm not able to answer. This is a carryover from the November meeting. I was asked at that meeting to seek additional support from my neighbors as well as support from the Civic Association. So I'd like to go through the timeline of and the support that I received. I think that's important to have on the record. I first reached out to the Civic Association in November because I was unsure of their process, and I wanted to make sure that they had enough time to review and provide their letter. The next contact I made was with my neighbor at 731 21st Street. That was on December 2nd. As you may recall at the meeting, it was noted that his property was in the closest proximity to mine, and it was important for me to reach out to him. So he was my first contact. My second contact was on December 3rd, and that was with the neighbor at 801 21st Street. He said he fully supported the project, and he provided his signature. After that, I went to the owners of the rental properties. I had their addresses, so I mailed letters to each of the owners. And then on December 7th, I received the letter from the Civic Association saying they supported my project, a copy of which is in the record. Yesterday, I received a call from the owner at 800 20th Street South. He said he fully supported the project, and he hand-delivered his letter of support to me. I understand that there has been a letter submitted to the BZA today from my neighbor at 731. The letter requests a deferral, and for the reason that he would like some changes to the scope of the project. I've had numerous emails with this neighbor over the past week. We've discussed the scope of the project, and the changes that he's requesting would severely impact what I'm trying to do. And I'm not willing to make those changes. They're not within the setback. He's fine with that. He's concerned about the design and the scope of the house. I'm of the view that delaying the board's decision is not productive, and I would ask that you make a ruling today.
Thank you. Questions for the applicant? Thank you. I have one speaker. Jason Papakosma.
Thank you, Madam Chair. Good evening, members of the board. My name is Jason Papakosma. My wife and I have owned the property immediately adjacent to the applicant since 1998, with our daughter joining us in 2005. We've been the applicant's next-door neighbors for more than 10 years and have had an otherwise friendly relationship. It's probably on most homeowners' bottom 10 list to speak at a BZA hearing against a neighbor's proposal, but here I am. You have a more detailed letter from me, so I'll just briefly summarize our main concerns here. For this project, we recognize that the by right option could happen, and it might be even worse for us than the current proposal, but the 25-foot right-of-way setback also significantly compromises, constrains the functionality of this option for the applicant, and it's not desirable. So building the setback makes more sense for this property, but we do not support how the current design proposes to use the space available made by the special exception. It goes too far and runs afoul of the neighborhood compatibility test. The lack of direct engagement with us by our neighbor is the other major concern we have with this application. The sequence of events outlined in my letter to you suggest Mr. Marion purposely left us out of his limited engagement efforts both before and after the November BZA hearing, despite the BZA's clear direction to engage intensely with us. You'll note in the letter I sent you that we actually approached him on December 3rd, not the other way around. In terms of the path forward, our hope is that Mr. Marion takes the time now to consider an alternative design that does not so negatively impact our property. Architecturally and function-wise, there are other options besides a full 3-story addition with a 2-car garage. We request that the BZA defer their decision on this case to create space and time for direct dialogue and more thoughtful design to happen. We would prefer to get to a place where we can support a variance request. Thank you for your consideration.
Thank you. Questions? Thank you. Discussion?
Need a moment to read the letter.
Madam Chair.
Mr. Owen.
My view is that the current design is not compatible with the neighborhood and does not meet the criteria that we have to find in order to grant a use permit. So my disposition on this would be either for denial if the applicant wants an immediate action, or a lengthy deferral for a substantial redesign of the property.
Other comments?
I'm in exact agreement with Mr. Owen on this.
And from the right side?
Still reading. We get a lot of material that's handed to us as we walk in, and in all fairness, we try to read everything that's given to us before we act, and sometimes it just takes time to read. So the elements of the request are the setback and the 2.5 stories. There's also a request in this. And I think that's the massing objection that's been raised. Including a new 3-story addition.
Madam Chair.
Mr. Smith.
I think the scale is not in compatibility with the neighborhood. So I agree with my colleagues to the far left.
It's the right wing.
You're in the right wing.
So I guess in that case, Madam Chair, I would have a question for the applicant. It seems tonight there are not 3 votes to approve your use permit as submitted. So the question is, you're entitled to a final decision, to a denial, if you want, or if you think it would be productive and useful and economical for you, you could preserve your application for some future date with a different design. And so I'm wondering about, if those are the options that you have, which of those 2 would you prefer?
Do I have, is the future date settled now, or is it?
We would talk about what the future date would be. But in my view, the amount of redesign and consultation with neighbors that I would envision, it's not something that could be accomplished in 1 or 2 months. It would be not maybe not 6 months, right? But
Sure.
longer
April.
than 2, less than 6 would be where I would be.
Well, I'm curious if the issue is with the 3rd story, because if it is, then the project doesn't work for me. So I might as well just, let it go.
As for me, I'm open-minded on all of the envelope questions. It may be that what parts of the building are at different heights may matter as compared to how things are in the rest of the neighborhood. I know that what you've submitted doesn't work for me in terms of neighborhood compatibility, but I'm not an architect, and so I'm bad at thinking creatively except with something that's in front of me. I think talking with your neighbors, or maybe some of the other BZA members could give you guidance about what they would think, but unfortunately I can't give you architectural guidance.
I think I'd like a decision today.
You'd like a decision tonight?
Yes.
Okay.
Okay, so we have a motion?
Madam Chair, you don't have an alternative resolution in the packet, right? Madam Chair, I move in the Board of Zoning, that the Board of Zoning Appeals, in the case of use permit V-11325-17-UP1, deny the use permit request.
I'll second.
It's moved and seconded to deny. Moved by Mr. Rowan, seconded by Mr. Melnick. All those in favor?
Aye.
Thank you. Next case, please.
Yes. Case number V-11326-17-UP1 is a use permit request by Karina Gizero Alvarez, owner, to permit a setback of 0.4 feet to the eave of an accessory building instead of 1 foot to the eave as required from the left side adjacent property line, and to permit a setback of 1.3 feet to the eave of an accessory structure instead of 10 feet from the rear property line as required, and to permit a distance of 2.9 feet to an accessory building instead of 8 feet from the main building as required, regarding the placement of a 48 square foot accessory building on a corner lot in the R6 zoning district on the premise known as 401 South Fenwick Street. Staff recommends that the board adopt the attached proposed resolution approving the subject use permit. I'd ask that you please note that there is supplemental material for this case that is a kind of supplemental statement of justification from the applicant.
Madam Chair.
Questions? Yes, Mr. Roman.
Staff. Isn't it true that all the people who were objecting before have stopped objecting to this?
That is staff's understanding.
Now we have a project that no one is objecting to.
Correct.
Okay, so this should go quick, I hope.
Be careful what you wish for. May I hear from the applicant, please? Oh, staff question first.
This is strictly technical. In the lot area, in a couple of the cases, we have in parentheses recorded. I hadn't noticed that before. Do you know what that means? Why there's that stipulation?
I took the recorded square footage on the plat provided as opposed to the calculated. Some of the updated plats have both, and so I try to use the one that is more restrictive.
Okay, thank you. And in the, on page 2 in the section on proposed changes, the last sentence says the applicant has also installed a drainage pipe as instructed by the BZA at the November hearing. That was an instruction or
Well, it was, I think it was underway. As I recall it, it was underway. Suggested.
Perhaps suggested is better verbiage.
we don't have that power to.
Okay, we good? Applicant, please.
Good evening. My name is Karina Guerrero. I am the use permit applicant, and this is my husband, Roger Goodmold. I just would like to say that we installed the drainage pipe as suggested by the BZA at the November hearing, and DES inspected it and signed off on it. The only neighbor who previously was opposed to the shed was very happy with the drainage system, so she no longer opposes the placement of our shed.
This was the melting ice issue. Yes. I recall. Okay. Questions for the applicants?
Madam Chair.
Mr. Smith. Wait, I have a speaker.
Oh, I'm sorry.
You're the speaker? Okay, never mind. I don't have a speaker, Mr. Smith. Go ahead.
Madam Chair, in the case of V-11326-17-UP1, I move that the Board of Zoning Appeals adopt the attached resolution approving the subject use permit with the conditions that are listed in the staff resolution.
Second.
Moved by Mr. Smith, seconded by Ms. Malice for approval. All those in favor?
Aye.
Thank you.
Thank you very
Thanks
much.
for your patience.
Thank you for working with your neighbor.
Next case, please.
Yes, case number V-11327-17-VA1 is a variance request by 3845 Military Road, the owner, to permit a maximum lot coverage with front porch of 41.5% instead of 35% as required regarding a new single-family resident with front porch in the R10 zoning district on a premise known as 3841 Military Road. Staff recommends that the board adopt the proposed resolution approving the variance, and I'd please ask you to note that there is supplemental material submitted by the applicant for this item with some updated drawings.
Questions?
Madam Chair, you just said 3841. Is it 45 or 41?
Okay, so this is a bit complicated, but when it came last time, the address used was 3845. Subsequent to that meeting, the address has been changed to 3841 because 3845 is being used. However, the name of the LLC still happens to be 3845.
Gotcha.
Okay. Applicant?
Good evening. My name is Sandeep Lohia, and I represent the 3845 Military Road LLC as its single member. This property was shortened or reduced by Commonwealth of Virginia acquiring part of the parcel for highway purpose. And after purchasing it, I realized that by right I can put together a home on it which would be only 20 foot wide in the front and 80 foot long. And so I worked to design a dwelling which would be a little bit more compatible in the neighborhood, wider and less narrow. And then I've summarized everything in a PowerPoint, so if we could run it, then I could walk you through it. Okay, yeah, the next slide. So this is the aerial of the lot, and as I mentioned that the lot was reduced by 5,460 square foot, leaving 6,295 square foot available, making it a non-conforming lot. It is approximately 47 by 130 foot in dimension. Next, please. That just shows the half that's been taken out and approximately the other half that's remaining. Next one. This is a little bit of a, actually, could you go back to the previous one? Yeah. This aerial shows the proposed dwelling, 30 foot by 58 foot footprint, and it also shows the two contiguous homes and other homes in the neighborhood. This is to scale, so I hope it just gives everybody a sense for what is being proposed and how it is different from a 20 foot by 80 foot dwelling, which would be a lot longer and narrower. So the original by right dwelling would only allow a front yard setback of 25 foot and a rear yard setback of 25 foot. It'll potentially, cut off some light to the adjoining house. Next slide. This picture shows not to scale, but a slide representation of what a house over there would look like. It was requested by the neighbors, so we put it together. Next one. So I'd like to briefly talk about the process of neighbor discussions, and I have a couple of neighbors here with me. I requested, engaged everybody in the process, the people who were adjoining neighbors, and Mr. Loeb coordinated meetings with the neighbors on November 5th and subsequently December 10th. And then they provided some suggestions which were very valuable, both with respect to how to bring more compatibility, primarily with respect to the location of the dwelling in the lot, the elevation, the scale of the house, as well as some architectural aspects of, inputs. And then I went on to revise the proposal and increase the front yard, added a porch to the dwelling, reduced the height, and modified the architecture slightly. I also had to make a longer driveway, which resulted in us having to seek a variance. Next slide, please. This slide shows the initial and the modified proposal in terms of where the house is sitting on the lot. So you can see that the first one sits with only about 25 foot front yard, whereas it was increased to 45 foot in the second proposal. Next one. This shows the initial and the modified front elevations. Again, the roof was reduced a little bit, a porch was added, and some modifications were made to suit the architecture a little bit better. Next slide. These are a couple of letters of support that I received, one from Mona Stephan, who is the president of Rivercrest Civic Association, and also from Mr. John, who lives across from the property. Next slide. I think that the other thing that I wanted to mention to the BZA is that one of the things that the neighbors, okay, I guess they will cover it, but it was a point regarding possibly combining the lot with the adjoining lot, and I think I broached it with the county 6 months back and was told that it's not really possible. But other than that, tried to incorporate all the things and come up with an idea which would allow us to put a dwelling which is relatively much more compatible in the neighborhood, and seeking everybody's support on it.
Thank you. Questions for the applicant?
I just want to thank the applicant for properly filling out the disclosure statement, even though he had an LLC. So, well done.
I have two speakers. Clive Lowe.
Thank you, Madam Chair, members of the board. My name is Clive Lowe. I reside at 3833 Military Road, which is adjacent to 3839, the conforming lot with house owned by Mr. Lahire, and itself adjacent to the subject 3841. As an interested and immediate neighbour, I have been coordinating the information flow with the other interested neighbours in relation to our respective and collective response to the plans for the site. We appreciate the developer's responsiveness to our concerns, especially as they related to the prior application, which was deferred from the November meeting at Mr. Lahire's request, so that he might revise his proposal to reflect the neighbourhood concerns in relation to front setback, building height, scale, architecture, and landscaping. The revised proposal is a significant improvement, certainly in terms of front setback from the prior version, which seemed completely out of context with the streetscape of this block of Military Road. We also acknowledge that Mr. Lahire has taken steps to address some of the other concerns and has provided a work-in-progress concept for 3839, the adjacent house, that enable us to get a sense of his overall proposal for the combined site. While there remain residual concerns about the finished architectural product of both sites, it's fair to say that as a self-proclaimed novice developer, Mr. Lahire has demonstrated a willingness to consult, listen, and respond to legitimate neighbourhood concerns. It's not necessarily the development we would have preferred, but we're not the risk takers, he is. The board may be aware that there are a set of restrictive covenants that provide for the Rivercrest Association to exercise a high degree of control over development and architecture in Rivercrest. But rather than apply these, we want to continue with the reciprocation of the good faith shown by both sides, and we hope that the proposal for 3841 and that of 3839 will reflect a thoughtful degree of architectural sympathy with the Rivercrest and Old Glebe streetscape, materials, proportions, landscaping, as well as practical concerns regarding traffic.
Thank you.
Thank you.
Elliot, please tell me what your last name is.
Good evening. My name is Elliot Balilos.
Thank you.
I live across the street from the proposed development at 3922 Military Road. Mr. Lahire, I think, did a very good job at reaching out to the neighbors. There's still some unanswered questions about the overall project that we have concerns about as a group. And I wanted to express that here today as well, and in the hope that Mr. Lahire will continue to work with us to ensure that the entire project is in keeping with the neighborhood plan and in conformity with the neighborhood. The one concern that I raise right off the bat, which Mr. Lahire referenced in his presentation, is the first thought that anyone of the neighbors had in looking at the two properties that he purchased is, why not divide the two into equal lots and build two houses that together would conform with the neighborhood? And that seemed to make sense to just about anybody who was looking at the project. And Mr. Lahire suggested that he raised that as his initial inclination as well, and was told by the county staff that that was not a possibility because it would mean rendering the adjacent lot non-conforming. My question to the board is whether that is accurate, whether there is no way that with the overwhelming support of the neighbors, that splitting the two into equal or semi-equal lots would be a possibility, because looking at the overall project, that seems to be to the neighbors that would provide the greatest value to the property as a whole and enhance the property values of the neighboring.
Thank you. Questions, comments?
Madam Chair?
Mr. Owen?
Well, I think the question that was just asked by the neighbor, is the power of variance great enough to permit a non-conforming re-subdivision, or is that outside the scope of what variances can allow?
I'm going to defer to Stephen because I don't even know what's being asked here. I'm not familiar with this.
So the question, it was asserted by the last speaker that there was a consensus by the landowner and the neighbors that the ideal situation would be to re-subdivide this lot and the adjacent lot, which are currently owned by the same individual or same LLC, such that instead of having one half lot and one whole lot, one non-conforming and one conforming, that they be re-subdivided into two lots, each of which are 3/4 of a lot, non-conforming, and that would allow both lots to be developed in a way that was more compatible with the neighborhood. And so they were wondering why the neighbor who just spoke asserted that was declared impossible by whoever they spoke to. This is secondhand, right? So now asking you firsthand,
Well, if
is that
someone's
really impossible, or could a variance be granted to re-subdivide the lot down the middle of these two parcels as opposed to where it's drawn now?
I'm assuming it was impossible to, by right, grant a subdivision for a lot that doesn't meet the lot requirements. That is not possible. So if someone wanted to come back with whatever arguments they thought were compelling to create two lots, neither of which meet the minimum lot requirements, they have an opportunity to ask, certainly.
And could we potentially grant a variance to achieve that?
Sure.
Okay. Well, then, I have a question for the applicant.
Before you bring the applicant up, can I ask a follow-up question?
Of course.
Could you do a URD on these two lots?
I don't know. I haven't looked at it. I don't know any of the circumstances or characteristics of it.
I mean, that's an available tool, and
I'm not familiar enough with it to answer right off the top of my head.
Okay. A unified residential development sometimes can be used to work through some issues.
Mr. Owen, you have the applicant.
Thank you, Madam Chair. How do you feel, would you in fact prefer to re-subdivide the lot to even them out? Would that be a preferred development option for you?
Not anymore. So I'd like to add that 6 months ago, I spoke with the person who was Mr. Reese's precedent about this matter, and my first initial thought was that I should go ahead and do that if the county would permit it. But what she conferred the matter internally and pointed out to me that would create two non-conforming lots, and the staff was likely not going to be in support of that matter. I also subsequently realized that what it would immediately require me to do is to raise down the other building, and I'm not prepared to do that. It would cause substantial loss of value. I shared with the neighbors that I have not yet decided whether I would tear down the building. It's in very good shape. It may be that I just continue to rent it for some years or possibly develop it by adding a floor onto it. But they wanted to see if I was to raise it down and put a new home in its place, what would it look like? And I think that in order to alleviate their concern that I don't want to now put another home which would be incompatible with the neighborhood, I certainly was happy to share a rendering that if a new home were to come its place, then it would be in similar place where the current home is sitting. But I think that right now, given the circumstances, I would not pursue the subdivision?
Well, maybe one thing to consider is in the event that you get the variance that you're asking for tonight, either tonight or at some point, that once you have it in your pocket, maybe it would make sense to revisit with your architect what the options were, because once you have that right, then it may make even more sense to get the variance. I mean, legally, right? You might have a better case
Sure.
for getting that re-subdivision variance than you would have had with a clean slate.
Okay.
Because now you already have a buildable lot that's worse non-conforming, and you would be improving that.
Mhm.
And that would be a potential argument for you, I think, maybe, in getting another variance. So I would just point out to you that the re-subdivision may, even though you would then have building rights, it wouldn't be completely off the table in my mind to then do the re-subdivision. That, I'm just winging this, right? I'm just one BZA member. I'm not,
Okay.
a land use lawyer, and I'm not staff, right? But I'm just saying that that card isn't foreclosed just because you would get approval.
All right. Thank you.
Okay.
Madam Chair,
Yes.
I'd just like to bring up a housekeeping point, if you wouldn't mind.
Okay.
The requested coverage presented in the proposed resolution, and actually in the subject of your staff report, is the proposed coverage that came before the board last month, and not the current proposed resolution that went out and is part of this agenda. So I would just ask that if a motion were to be made, that you use the current requested coverage of 41.5% as opposed to the 39.83% that currently exists in the proposed resolution.
Okay.
Repeat that number, please.
41.5%.
Okay, thanks.
Segueing nicely into a motion.
Madam Chair,
Mr. Smith.
I'd like to make a motion that we, in the case of V-11327-17-V8-1, adopt the resolution approving this variance request and make it subject to the conditions that are listed in the staff report.
With the change, this change.
With the change that the coverage is 41.5%, not 39.83 as shown in the staff report.
Is there a second?
I'll second.
Moved by Mr. Smith, seconded by Mr. Melnick for approval. All those in favor? Aye.
Aye.
Thank you.
Thank you very much.
Next.
Next is case number V-11327-17-UP-1, which is a use permit request by 3845 Military Road LLC, owners to permit a left side setback of 6 feet to the wall of the building, 5 feet to the eave, instead of 10 feet to the wall, 6 feet to the eave as required, and to permit a left side setback of 9.17 feet to the porch instead of 10 feet to the porch as required, and to permit an aggregate side yard of 14.2 feet instead of 24 feet as required regarding the new construction of a single-family dwelling in the R10 zoning district on the premise known as 3841 Military Road. Staff recommends that the board adopt the proposed resolution approving the use permit request.
Questions, comments?
Madam Chair, I see a lot coverage calculation in the staff report. I assume that it should be updated
Correct.
to the number that was in the variance?
Correct.
It's not in the draft
the motion.
recommendation.
Yes, it's just
Okay.
in the staff report.
Okay. Nope.
Madam Chair,
Mr. Smith.
given that we've discussed this case at length during the discussion of the variance, I move that in the case of V-11327-17-UP1, that we adopt the attached resolution approving the use permit with the conditions that are stated in the staff report and the editing of the the lot coverage area.
I'll second that too.
Moved by Mr. Smith and seconded by Mr. Melnick for approval of the use permit. All those in favor?
Aye.
Aye. Thank you. Thank you. Next case, please.
Case number V-11330-17-VA-1 is a variance request by John Quirk and Gina Quirk, owners, to permit an addition to a non-conforming structure in an R27 zoning district regarding the third-story rear addition to a non-conforming semi-detached dwelling in the R27 zoning district on premise known as 3027 20th Road North. Staff recommends that the board adopt the attached resolution approving the variance request.
Questions?
Madam Chair.
Mr. Owen?
Question for staff. You've provided a rationale for approving the variance on this particular parcel. Would the same exact argument apply to the other 39 parcels on this block?
Staff's response is possibly. The rationale would extend to any similarly zoned both non-conforming parcel where the non-conforming element is a physical property of the land or improvements that was established before the zoning standards were enabled.
All right. So you haven't done the research, but presuming that all of these houses were built in the same year and that they all have the same lot size and are otherwise similarly situated to this lot, then we would have 39 other occasions where this rationale would apply.
Well, not the lot size, but the placement of the structure.
The placement of the structure on the
Correct.
lot. Right. Okay. Does staff have an estimate as to the number of our 2.7 parcels in the county that are currently developed as non-conforming?
Staff does not. Staff only receives plats when applications are made, so it would be very difficult to get a hard number on the number of non-conforming properties in the R27.
I'll just say that I've seen numbers of non-conforming properties in other, I've seen numbers like that being produced in other policymaking contexts in Arlington County.
By planning.
Yeah. I've seen numbers like that there's however many thousand non-conforming lots in the county and whatever, so.
I just don't know that they're broken down by.
I asked you on Sunday and it's only Wednesday, so maybe it takes weeks to get those numbers in not hours, right? So I'm not blaming you, but I don't think it's necessarily totally impossible to get the number up. All right, and then my other questions I can hold off until we hear from other people.
Okay. We hear from the applicant, please.
Madam Chair, members of the board, we have a 4-year-old son and a 2-year-old daughter. The current dwelling is 2 bedrooms. We'd like to make it into a 3-bedroom. Our design was intended to be minimal, and we tried to not go beyond either the vertical or horizontal apex of the current dwelling. We coordinated with every neighbor on the lot. We got their approval and consent, even the historically cantankerous one. And so we hope to seek your approval.
Thank you. Any questions for the applicant? I have 2 speakers. Gerard?
Good evening. Just here as the contractor. How you doing, Mr. Smith? Just here to entertain any questions if anybody has any questions about the project. So just here for that.
Okay, good. Stand by. Benjamin Keeney?
Thank you. Benjamin Keeney, local architect, actually the architect for the applicant, put together the plans a month or 2 ago after I mentioned that I was thinking about doing something similar. We talked and it makes sense for some of these older buildings to have a little bit of that extra verticality or, usable space. Right now, I'm looking at what these houses could be in the future. And, in terms of like looking forward, in a historic perspective, my biggest kind of fear with a structure like this is that you have this charming old thing, and if you can't make it work, for the new people that are living in the area, then it's hard to keep it. So we're talking about, like how to make it work in a modest sense. And this is basically the proposal we came up with, was not stepping out of the footprint, not going up vertically. It's basically just literally a shed dormer, but obviously kind of a nicer, more residential application of such. And with that said, I'm happy to answer any questions. Thank you.
Thank you. Ms. Mellis.
So this is opening a door to redevelopment up and down the street through your neighborhood, this variance. You like the way this one is done. There may be others that come, ask for a variance, that may have a different treatment.
Certainly.
Would you be comfortable with that?
That's a great question, because there's a couple blocks away you can see there's similar duplexes built around the same time, and a lot of the additions actually came out of the front of the building, sides of the building. There's some kind of unusual stuff, like in the North Roslyn neighborhoods specifically. But they're not, they're not bad. And I think that, from a land use perspective, why I moved into the house that's, just to the right of the applicant's dwelling, and is because I just love, the feel and the warmth and the sunlight. And I think that if somebody, wanted to put metal panel or something different up there, or do something different in the back, I don't necessarily think about it as like it really would compromise the overall value. I mean, some of our other neighbors are 11 and taller story buildings, and I think that having these smaller 2-3 story structures with the 35-foot building height is kind of unique, and I think that in and of itself, from a land use perspective, in my opinion, is valuable, and it's kind of it's special in a way. But talking through I'm also the vice president of the Civic Association, and talking to the 3 out of 5 board members about the project, all 3 were very positive about the idea, and we actually have letters included, and I think 3 of the letters are from board members on the Civic Association board. So I think, to answer your question, and I know it's a loaded one, I think within reason, there's it's not like we have a housing association or anything like that. I mean, it's these things are unique. I love the way my windows are different than the guy next door. It's got an appeal.
Thank you.
Other questions for the applicant or their representatives? Oh, thank you. Mr. Melvin.
I have a comment. So we've run into quite a bit of these, in similar zoning districts, and I'm having a hard time seeing how this falls into either unreasonably restrict or hardship, because it is, it's a regular sized house. It is what it is, and the ordinance, the zoning law is what it is. It just doesn't look like there's any unreasonable restrictions on this. So that's my thought. I'm just having a hard time placing it in either hardship or unreasonably restrict. So I'm not. It's looking like I wouldn't be able to support it.
Other comments?
Madam Chair.
Mr. Allen.
I have a question for staff. Why did the county board not include the R2.7 district among the zones to be granted relief from Arlington County zoning 16.2.5, which would allow a use permit as opposed to a variance in this situation?
All right, I have done some research into this, and it looks like the changes that were made to 16.2.5 that allowed for the different zoning districts as well as the one family clause were all put in at the same time that the bulk coverage and placement modifications were made to Chapter 3, and those modifications were specific to both one-family dwellings and certain zoning districts. The R27 zoning district and the two-family dwellings were not part of those changes, and so I am concluding here that the modifications to 16.2.5 did not include those these parcels because they were not included in the modifications restricting the parcels included in Chapter 3's modifications at the time.
It's an extremely illuminating answer. Thank you. And my last question for staff is, if the BZA adopts the staff's rationale that the current zoning ordinance is unreasonable as to all non-conforming 2.7 parcels, how would staff recommend that the BZA evaluate the size and scale of proposed variances that would be approved versus denied?
All right, I have two answers to this. First, staff is not suggesting that all non-conforming properties should be qualified for a variance. We are saying specifically here that in this case, because the improvements to the property were made before the zoning district was put in place, that is what qualifies this property. The second part to your question is staff has a pretty good track record of recommending disapproval for variance requests where requests are made for variances to allow additions that are more than 50% of the building that existed in 1950. So I think staff would continue to be inclined to not recommend approval for those type of requests. So if you're looking for a limiting size factor, I would say that would drive staff's position.
That 50% limitation is actually found in the zoning ordinance,
Correct.
right? So you would apply the existing zoning ordinance, but anything up to 50%, there would be no other limiting factor that you can think of at this time.
Not at this time.
Thank you.
Mr. Smith.
A question of the applicant. The attic area, that's an attic right now. It's not usable, is it?
Correct. So the current setup, the only way we can access the attic is through a panel in our closet, and so we don't even have a pull-down ladder, and so part of it is...
Not even storage, I got you.
It's totally inefficient from our perspective, and so if we can turn it into a usable room...
And, I mean, Jahar does a lot of these dormers, has done them, and has worked really effectively at expanding area without footprint. And that's what I see you doing, which this discussion was about, the prior discussion was about areas where we see, especially that 50% rule, we see these R2s where, especially on the south side, where they are bumping back. But often those are flat roofs, so they're difficult to do anything above because they just don't have an attic at all. I think this is a really wonderful attempt to gain more space without increasing the footprint. And if you don't allow such expansions in these, I was looking for a historic designation. It's not a historically designated neighborhood, but if you don't do this kind of, if we don't grant these kinds of variances, then we're faced with variances where they want to expand the footprint. And this would, I think this gives developers, builders a real good model of how you can gain more with less. And I think to not do so, we'd be unreasonably restricting the utilization of the property. It's not utilized at all, the attic. And if we don't allow this non-visible, supported by the neighbors, expansion slightly of a dormer, we're restricting the utilization of that property. I think that
I agree.
Satisfies the first prong. So that's why I am excited to see this and would support it.
Quick question for staff. On the 50% rule, can you clarify what that rule is?
Substandard lot size. You can't go over 50%.
Is it 50% of floor space of usable area? How does that 50% that you're applying?
That's a substandard lots in that R2 district. If you want to build you can't build an addition that's greater than 50% of the
footprint or area or
of the footprint.
Footprint.
You can't expand the size of the structure by more than 50% in terms of its footprint.
With the footprint, there's no change in the footprint in this.
Exactly.
Oh, right.
But is that what the rule says? It's 50% of footprint?
Do you have a code citation?
Yes, 16.2.5B states that a building or structure which does not comply with the height or lot area requirements shall not be added to or expanded in any manner unless such addition or expansion conforms to all the regulations of the district in which it is located, provided that the total aggregate floor area included in all such separate additions and expansions does not exceed 50% of the floor area contained in the existing building or structure as of July 15th, 1950.
Floor area. So this, in that 50% rule, this could be bigger. You could have gone both sides, right?
Taller.
Could have gone
Both sides still would not increase the footprint, so...
attached, though.
It's
Or-
a floor area.
Yes.
Floor area is different than footprint.
Yes. It would
So this could be, as long as it's within
A third story.
third story limit, it could be bigger than what has been proposed. That's the rule that you would apply.
Yes.
Okay. Thank you.
Sure.
Mr. Hall.
So I agree with Mr. Smith, and I disagree with Mr. Melnick about the reasonableness prong. But where I'm hung up is on another criteria that we have to find for variance, which is the condition or situation of the property not so general or recurring as to make it reasonably practical to formulate a regulation which can be adopted as an amendment to the ordinance. And to me, it's hard to imagine a better example of where that would apply than here. I mean, literally on this block, there's 39 other properties, not to mention what are probably hundreds, if not thousands of other 2.7 properties where we have already seen, and even tonight there's another one on the agenda, whoever you are, this is the same issue. And I am very concerned that we will be not doing what the state legislator told us to do if suddenly we become the spot where, hundreds of our 2.7 homeowners come to figure out what their new build-out is. So I appreciate that there was no deliberate, contrary to what both the staff report says and my suspicion, the staff did not really deliberately leave 2.7 out of this kind of relief. They didn't have this in mind. They weren't deliberately leaving it out either way. But nonetheless, that's the right relief. So I apologize to the applicants because I think what you're asking for is substantively reasonable, but there's a problem with using the variance mechanism to get it. And you're not the first, and you're probably not the last who's going to try and go down this path, but I just think this is a perfect example from my perspective of what we cannot by law do.
So I'm in agreement with that point too. That because then we have to, with all of this deluge of possible cases, then we'd start having to have some rule about, well, it can only be dormers. Mm-hmm. And then it's just like way out of our jurisdiction. So that's a very good point.
Well, I'm much less troubled than my colleagues. I like it. And there's nothing worse in my view than the monotony or the tyranny of zoning, or whatever you want to call it, that makes all of the semi-detached units look exactly the same. I'd much rather see a dormer here and a front extension there and a little bit of variety. And I'd like to sustain this kind of relatively, for Arlington, affordable housing.
Madam Chair, if I may.
Sure.
I would just, to Mr. Melnick's point, I would say that one could see your point. One could also argue the hypothetical in the other direction. You may not see other cases on this block and in other areas. Our intent is to be simple here. It is our desire to be long-lasting members of this community and neighborhood. And if we are not allowed to proceed, we may be forced to move out of the neighborhood, and that is not our intent. So I see your point. I think the hypothetical could be argued in the other direction.
Okay, other comments?
Madam Chair,
Mr. Owen.
I note that the staff report has only one resolution listed, and it is styled as the alternative resolution for approval. So lacking a printed resolution, I would move that in the case of V-11330-17-VA-1, that the Board of Zoning Appeals deny the variance request.
I'd second that.
It's moved by Mr. Owen, seconded by Mr. Melnick for denial. All those in favor?
Aye.
Opposed? No.
Madam Chair,
Mr. Owen.
I would just say to the applicants that I think that the Arlington County zoning ordinance is broken. That's just my personal opinion in the R2.7 district. And I hope that you consider going to the county government body that can help you, which is the county board, by amending the zoning ordinance to allow your very reasonable addition. And I recognize that that's a longer, more arduous process that you as an individual homeowner may or may not want to do, but there's hundreds like you, and so maybe it could be a worthwhile community project for you to be a poster child for that effort, because if the county board amends the zoning ordinance, then it could wind up being a lot easier to do reasonable things like what you're proposing.
Next case.
Case number V-11330-17-UP1 is a use permit request by John Quirk and Gina Quirk, owners, to permit a right side setback of 5.1 feet to the wall, same as existing, instead of 11 feet as required, and to permit a right side setback of 5 feet to the eaves instead of 7 feet as required, regarding a new third-story rear addition to a non-conforming semi-detached dwelling in the R27 zoning district on the premise known as 2037 20th Road North. Staff recommends the board adopt the attached proposed resolution approving the use permit request.
Are you sticking with that recommendation now that there's no variance?
Well, it was the recommendation that was presented to the board at the time the packets were compiled.
But you couldn't do anything with the use permit now that there's no variance, right?
It is moved.
Couldn't enforce it.
The action still needs to be taken for this case, though.
Okay.
I guess we just have to have.
Mr. Melnick,
I'd like to make a motion.
please.
Okay, in case V-1133017-UP1, I make a motion that the Board of Zoning Appeals deny the use permit request.
Second.
Moved by Mr. Melnick, seconded by Ms. Mouse for denial. All those in favor?
Aye.
I'm abstaining.
I abstain as well.
May I address the board? Just questions. Being that the variance has been denied, what's the course of action here? Is to go for the board of the county board?
You can't file an application with the county board,
Okay.
right? So, but what you could do, along with your architect neighbor and anybody else who's interested in solving this general problem, is go meet with county board members, write them letters or emails, give them calls, and say, could you work on this? And then they would decide if they want to direct the manager to propose zoning amendments that would allow greater flexibility in this zone. And that would be up to them as the legislature.
Right. Well, to follow, just piggyback on what Mr. Melnick was saying about the hardship and not seeing a hardship in this. This is a two-bedroom house without having that attic expansion. If you have a family of two, you're limited of not having any room to put your kids in here. So that's the purpose of this addition.
It wasn't hardship. It was the prong that talks about whether this is unique.
Mm-hmm.
And what Mr. Owen went into the beginning, these duplexes are, he said essentially it's that these are all over, and so this problem reoccurs, and the code suggests that you can only act in granting a variance in cases where it's kind of unique, that it doesn't reoccur, that it's kind of a, to repeat repeat myself, that it's unique. And so it wasn't the hardship or the unreasonably restriction. It wasn't compatibility. It was whether it's unique. That was the element that I believe it failed on.
Right. But what's the purpose of seeking a variance if that cannot be granted, being that will open up the door for what you were saying, 100 or 1,000 cases? That's why we're seeking case by case. Isn't that how this is handled? Or?
But that's the point, is that if it's not considered unique, then there should be a legislative remedy, like something in the zoning ordinance that would allow this kind of an expansion, because there are many dwellings in Arlington that are similar to that. So it isn't that it's a hardship because your family's growing too big. It's got to be a hardship that is unique to the property, and for geography or some other, topography or some other reason. So unfortunately, the remedy is probably, it's not unique enough for it to be considered for variance. I didn't agree with that, but that's the interpretation. So if you go to the board, if you talk to board members, there may be a legislative remedy if they are sympathetic. They can direct the manager and the staff to actually do something.
Okay. Thank you for the explanation.
Madam Chair, there are other builders and designers in this room right now who do a lot of work with duplexes. And I would encourage you to talk with them so that that you all can join forces, because you do have to move for legislative change.
Right.
And that means lobbying the county board and saying exactly what you want and holding them accountable to do just that.
Right.
And this problem, these structures are all over, and there are a number of builders who do a lot of work with them. You should identify each other and coalesce and work together.
Yeah, we've had this duplex that it was an R5 district, so that was granted as a single, as an exception to the case. All right, so I won't take more of your time. Thank you very much. Happy holidays.
Next case, please.
Case number V-11331-17-VA-1 is a variance request by Sylvester Goldalaja and Elda owners to allow a main building footprint of 3,212 square feet instead of 2,520 square feet as required, regarding the new front and side addition and new second story over existing first story walls on a lot with 3 right-of-way frontages in the R6 zoning district, premise known as 1 North Fenwick. Staff recommends that the board adopt the attached resolution denying the variance request. An alternative resolution has provided should the board decide to grant the variance.
Madam Chair?
Mr. Hahn.
Question for staff. Can this parcel be rezoned to R10? Is it eligible for rezoning to R10?
The parcel meets the minimum dimensional requirements of R10 zoning district.
And would R10 be contrary to the GLUP in this location? Isn't it yet another low-density residential category?
I believe that it is another low-density residential category, but if you ask your follow-up question, I may have another answer for you.
Just go ahead and tell me what you need. Tell me what you know.
The current proposal would not be allowed under the R10 zoning district because it would run afoul of the 25% R10 lot coverage requirement without a porch. The current porch shown does not qualify. If the porch were to be amended and it rezoned, it is possible then that could be approved. But the current application could not be approved on this zoning district nor R10.
So this particular application is too big even for R10.
Correct.
But if they were able to rezone to R10, which we're not entirely sure of, that they would get more, just not quite as much as they're actually asking for.
Well, their main building footprint number would go up, but the percentage goes down.
Oh, right. Mm-hmm. Okay. Thank you.
Okay. Questions? Other questions for staff? Applicants?
Good evening. My name is Elda Godolia. We bought this house in July, and I wanted to remodel the house to make new shape because it's like narrow, to make new shape and to build the second floor over the existing footprint. and to make it comparable with the other new houses in the neighborhood. The reason that we're going over limit of the footprint is because of the garage. The lot is very big for R6, and we don't have possibility to build a garage on it because it's three ways off the street, and in any of the corner we cannot build a garage. So we thought, we went back and forth with architect and the county, and the only option is to attach it, because detached garage, we don't have possibility to do it, even the lot is big. So that's why, since we meet the coverage, 27%, we ask you to get the permission for the cap. Architect can go
Hello, good
more
evening.
details.
Hello, good evening. So she bought the property in order to build her dream house, and she expected like, oh, my lot is about 10,000 square feet, so I can build as much as I wanted. While we were doing the design, we figured out, even though it's 10,000 square feet, 11,700, she couldn't fit the code requirements because it's R6, so she can only fit some lot coverage and that. So when we submit the plans, it got rejected, and we spoke with the zoning review, and he told us you have a high possibility to go to a variance and get that variance and approve to build what you want on the lot. So that's about it.
So what is your name?
Danitza.
Okay. Questions? I have a speaker. Pena?
Yeah, that's me.
That's you? Okay. Okay. Questions of either of these ladies?
I want to add something that I forgot. And our lot is between two streets. One street is one-way parking, which is close to the apartment building there. So we rarely find a way to park there. And the Fenwick is very busy street because so many cars, because it's without pay, so many cars come and park there. So having the house there with big lot and don't find a way to park it is hard situation. And the neighbors, I got the signage from 3 neighbors, and they were okay with the building. And the neighbors that is right behind me, he doesn't have garage in his house, and he was telling me the good idea to have is a really good idea to have a garage because we'll resolve your problem on parking.
Madam Chair.
So,
Mr. Smith.
Can I ask staff, what can they do by right? How many square feet can they add by right, roughly?
By right, I think there's a possibility of doing an addition that is between 500 and 600 square feet that can be attached to the main building. The kind of complicating factor to this is if a garage were to be proposed somewhere else on site that is not connected to the building, it wouldn't be counted towards the main building footprint, and so that could also be built. Though I will say I've talked with the applicant about this possibility, and there are severe limitations because of the 3 rights-of-way surrounding this property.
I just know that this is a highly constrained site. It's in an unusual location. It abuts an arterial that is the largest arterial we have in Arlington that isn't a limited access highway. And it abuts a zoning boundary for considerably higher density. So to me, unlike the one we were just talking about, this is a very unique site that isn't capable of a lot of repetition. I feel like I would want to explore more what the rezoning to R10 can do, because if they have a right to go to the county board, rezone to R10, and then get almost everything that they're asking for that way, to me, that would be the preferred route to getting a variance. And I'm not totally convinced on every last aspect of this, but I also think that there's a public interest here that's also unique. I mean, this abuts public land in the form of Route 50 and the bike trail and the trees that are there. And I think for the most part, what you've proposed appears to me to do a good job preserving all of that. And so I'm really attracted to this project, but I feel like it's not fully baked in terms of its policy justification. Staff's recommending denial. I would ask, is there a version of this that without being specific, but do you feel like that you're in the realm where there would be a version of this that you might recommend approval of a variance on? Or do you feel like no variance is really justified on this site at all?
Oh, I think there's certainly a version out there that staff could support a variance for this site. And again, I've talked with the applicant, and I think that staff in other scenarios could also support use permits to allow for modification to setbacks. I do not think this current proposal meets those criteria.
I mean, I also think, as I argued strenuously on the Army-Navy Country Club case, that having a big lot is not a hardship. Yeah, and now this time you guys agree with me, so I'm glad you're on the right side of history here. But so that's where I am.
So, Madam Chair, can I ask the applicant if they're willing to defer this to look at an option that could get them closer to approval? Number one, to look at the possibility of rezoning.
Yeah.
And because the staff report says even if they rezone, they need a variance for what they're proposing now. Obviously, if they rezone to R10, they could look at other options as well and never have to come back to us if they understood the constraints. So our tendency is, rather than to deny, is to defer, to give you an opportunity to look at the question of rezoning to R10, which then gives you a bigger footprint.
Yes, but still I cannot, I am over the coverage.
Right.
Even I go R10, I will not get one.
Right.
R6. In R6, I am okay with the coverage, but I don't have footprint. With R10, I will have footprint, but I don't have coverage. So in both
coverage?
Yes.
No, because you have to do the
I have
calculation.
27.
No, we have to do the calculation.
Would change.
Yeah,
The
it
coverage
changed.
would go up to 30.
I talked with Stephen, and Stephen told me you cannot do it in R10 either. Yeah. Am I right?
Correct. The main building footprint goes up when you go to R10, but the percentage allowed goes down to 25%. And that's, with the current version of drawings, what they would run into.
Right.
So I am in
So,
the same
what we're saying is that you may have to talk to staff and reconsider your drawings to see if there's a way that you can make this work.
I mean, how does the zoning work? Because last time that I spoke to the county, they told me that the zoning takes a long time to get that process done.
It does. I mean, what's a long time? An application?
First of all, let me just clarify. When you say rezoning, are you asking just does the GLUP support an R10? Because we certainly can't make any guarantees or statements about whether or not, number one, county comprehensive planning staff would support it, or if the county board would support a rezoning. So is it possible for them to ask for a rezoning? Is that what you're asking?
Well, I'm asking you, now you're raising, so we don't know whether the current GLUP supports R10?
I don't know personally. I haven't looked at it.
Okay, so that, yes, we'd have, obviously.
That's the
have to-
only question we can answer. I can't answer any questions about whether or not that's actually possible in terms of getting approved, because there's several processes that have to take place that are beyond our control. So we can look at the GLUP map and say, sure, it's designated for something that would allow these 3 or 4 districts, but there's a whole other process involved with planning, the Planning Commission, and the county board that is going to take some time.
Okay, that's the process. I remember that process now. Thank you.
Okay. It appears there are a lot of loose ends here.
Well, Madam Chair.
Mr. Smith.
Unlike the case before the duplex, I have a hard time with this one. What was that point made about the having too big a lot is not a hardship?
Mm-hmm.
Right. That's kind of it's good for playing soccer, though.
Madam Chair.
Mr. Melnick.
So I'd like to make a motion.
Please.
Okay, so I'll move that in case D11331 17VA1, that the Board of Zoning Appeal deny the variance request using the alternative resolution provided with the conditions stated.
Second.
Moved by Mr. Melnick and seconded by Mr. Smith for denial. All those in favor? Aye.
No.
Opposed?
Whoa.
Just a second. The alternative resolution is for approval.
As advertised.
Oh, I'm sorry. Okay, so then it would be the regular resolution.
Okay.
I make a
The
correction on
recommended. Okay.
Okay.
Clear to everyone?
So, Madam Chair, I move unanimous consent that we rescind the previous vote and reconsider the motion as restated by Mr. Melnick.
All right.
Oh, I can't do that because I voted no. I'm not eligible to move reconsideration.
I guess I could move it?
Yes.
Okay. Move reconsideration and replacing the resolution instead of the alternative resolution in my motion.
Okay.
Resolution to deny.
Yes, resolution to deny.
To deny.
I second that.
Okay. So we've reconsidered that. We're now,
You have to take a vote on that. You could do it as a combined motion. Consider it a combined.
okay. Let's do that. Proposed resolution denying the use permit request. Moved by Mr. Melnick, seconded by Mr. Smith. All those in favor? Aye. Opposed? No. 4-1. Thank you. Next one.
Case number V-11331-17-UP1 is a use permit request by Sylvester and Elda. The owners permit a setback of 8.5 feet to the wall of a sunroom addition instead of 10 feet as required, and to permit a setback of 5.84 feet to the eaves of a new second-story addition instead of 6 feet as required regarding the new front and side addition, a new proposed second story over existing first-story walls on a lot with 3 right-of-way frontages in the R6 zoning district, premise known as 1 North Fenwick Street. Staff recommends the board adopt the attached resolution denying the use permit request.
Madam Chair.
Mr. Owen.
I have a question for staff. Staff's recommendation is based on the specific plans that were submitted that also needed a variance, right?
Correct.
So if the applicants submitted if there were to be a deferral and the applicant submitted other plans that did not require a variance but only required a use permit, they might be able to use this as a vehicle for such a request. Is that right?
I would say possibly. Staff's position on this really came from the specific plans and specifically to them the size of the footprint that was proposed. If that were to change, staff's position via the use permit request may also change.
Right.
But Madam Chair, if I might, but this use request permit is asking for would essentially change the footprint.
Yes.
So if they went up, then it wouldn't be a footprint issue. But going out, change the footprint. Be an area, a floor area issue going up, but it's not a substandard size lot, so.
Well, right, but what I'm saying is that maybe there's one dimension in which they might want to extend closer to the property line than they would otherwise be able to do without a use permit.
Where they wouldn't need a use permit to go, or.
I think there's scenarios where they would need a use permit but not a variance, if they only go in one direction and don't make it too much coverage. And so because I'm very sympathetic to the general idea of having more on this lot, I don't see a reason to deny this if they are going to consider any redesigns that would not require a variance. So I guess I'll be interested when we call on the applicant about their views about whether they would like a deferral or a denial on this.
Let's do that. Applicants? Back, please. Okay, Mr. Owen.
First, I would say you have the right to speak. Do you have anything you would like to say?
No, really.
So the question is, you've paid for a use permit application as well as a variance, right? And it's on our docket. And so it appears that the BZA is not willing to grant a variance to you. But if you want to build a bigger house, there might be other things that you might want to ask as a use permit, mostly moving towards the edges of your property in one or two directions. So the overall house size would need to be smaller because you need a variance for that. But the placement of the house, you could still have flexibility if you had a use permit pending. And so my question is do you feel like you want to give up at this point and maybe not redevelop the house, or redevelop only by right, or sell it to somebody else? Or are you still interested in going back to your architect and redesigning and seeing what you can do within the existing coverage requirements?
We're thinking of redesigning everything, going what we can do, like as a right now.
And how many months do you think it would likely take you to confer with your architect and come up with whether you would have another possible plan?
Probably 1 to 2 months.
1 to 2 months? Okay. To me, that's a little optimistic, but thank you.
Yeah.
You want to do March?
At least.
April? Okay. Madam Chair, I move that we defer V-11331-17-UP1 to the April BZA meeting.
Second.
Moved by Mr. Owen, seconded by Ms. Malice, to defer this use permit application to the April 2018 BZA meeting. All those in favor?
Aye.
Thank you.
So this way you have some rights that are preserved in case you decide to use them. And if you decide that you don't need to use them, you can just tell staff that you're ready to withdraw it. So that way you have a choice either way.
Okay, thank you.
Next case, please.
Case number V-11332-17-UP1 is a use permit request by Brad and Jamie Mason, owners, to permit a setback of 14.7 feet to the building, 13.9 feet to the building eve from the 6th Street North right-of-way instead of 25 feet to the building, 21 feet to the building eve as required, and to permit a setback of 14.7 feet to the front porch, 13.9 feet to the porch eve from the 6th Street North right-of-way instead of 21 feet to the porch, 19.5 feet to the porch eve as required, and to permit a setback of 14.9 feet to the rear deck from the 6th Street North right-of-way instead of 21 feet as required, and to permit a right side setback of 6 feet to the building from the adjacent property instead of 8 feet to the building as required, and to permit a right side setback of 6.1 feet to the screen porch instead of 8 feet as required, and to permit a rear setback of 5.2 feet to an attached planter box instead of 6 feet as required regarding a new single-family dwelling with front porch, rear deck, and screen porch and detached garage on a corner lot in the R6 zoning district, premise known as 600 North Jefferson Street. Staff recommends that the board adopt the attached proposed resolution approving the subject use permit.
Questions for staff? Applicants?
Hi, Madam Chair and members of the board, thank you for having us tonight. I'll make this brief. My wife and I have moved into the neighborhood or lived in the neighborhood for almost 6 years. We identified this property as an opportunity for us to build the home that we and our children can live in for a very long period of time. And in doing that, we hired Stanley Martin Homes to come up with what we think is a product that fits within the fabric of the neighborhood, is reasonable, and we went out of our way to really engage with the neighbors to make sure that everyone was really buying into what the product that we wanted to do. So,
hello everyone. I'm Michael Schnitzer, President, Stanley Martin Custom Homes, and I'll try to make this very brief. First, as Brad pointed out, if you look at the existing property, specifically pages 25 through 27, you'll see the current property is pretty much an eyesore, house in disrepair, litter and debris throughout the yard. There was a rodent problem on the property, which was since been corrected. Certainly, this is a non-conforming lot, and as non-conforming lots go, this lot would yield a 17-foot wide home. 17-foot wide home would be 59% less wide than a prototypical R6 interior lot. The new home, just a couple points here, the new home is 36% further from Lot 2, which is the right neighbor, so we're now 6 feet versus 4.4. We're practically the same distance from 6th Street, 14.7 versus 14.8. The new detached garage will be further from both neighbors and in conformance with the code. And it's also worth noting that the new home is actually less wide by half a foot than the existing home. From a neighborhood perspective and conformance with the neighborhood, what I did was I went on the GIS map and did a bunch of measurements, and you can find the information, basically the map and my computations on pages 13 through 14. What I found is I targeted 25 properties and found that 29% further from the front property line than those targeted 25 properties. I also calculated that the average front setback of those 25 targeted properties was 11.3 feet from the front setback line versus ours, which is 14.7. So I think that from a conformance perspective, we're certainly well in conformance with the neighborhood, perhaps exceeding many homes that are much closer to the front property line. Most importantly, we've reached out to many, many neighbors. We have 25 neighbors in support of the property. We did receive, and both adjacent properties are in support, which is obviously huge. One of the neighbors finally reached back out to Jamie and Brad. We have it for the record.
What was the address on that?
That was lot 4, which the address is...
It's a 6th Street address.
Let me type for 1 sec. That is 5615 6th Street. Her last name is Corey. And then last but not least, we always reach out to the Civic Association, and notoriously the Civic Associations don't like to opine on special use permits, although I will read something from Rich Gibson. He said, I can tell you unofficially as a neighbor, not speaking as a representative of the board or civic association, no one has brought up any objections to this project or civic association in any of the meetings since I shared the news of your plans at the October meeting, nor have I seen mentioned in any correspondence to the civic association leadership, which I'm usually a part of. So we respectfully hope that you would approve the special use permit.
Thank you. 25, extraordinary. Any questions of applicants or their representative?
Madam Chair.
Mr. Hall.
Are you planning to cut down all of the trees? Which are, in this photo that's up right now, the big tall tree that's closest to the center, is that one staying?
There is a certified arborist report. by a gentleman by
It
the
was
name
hard to make out which tree was which on that report in our packet because we got sort of a black and white photocopy.
So the trees, so this would be on page 40, I believe, is that correct?
Right.
Right, so if a tree has an X, that means it's to be removed. Right, so there's no trees being saved, and if you read the narrative, there really weren't very many healthy specimen trees.
Yeah, so for example, the tree that we see in the foreground of this particular photo is one of the all trees that's being cut down for this project. Is that right?
Correct.
It doesn't look healthy anyway.
Thank you.
This is another copy.
One last thing I would point out, if you look at the intersection, you know, it's kind of like bulbous at the intersection between, so certainly from a relativeness, the house appears further from the street. Go to the GIS map, I measured it from the front setback line, that it appeared to me to be another 16 feet from the front property line. So I don't know if at one time maybe the street was less wide and they widened it and took some of the front property.
Okay. Sorry. Mr. Smith,
I'm prepared to make a motion.
please.
Madam Chair, I'd move that the Board of Zoning Appeals adopt the attached resolution granting the subject use permit in case V-11332-17-UP1, subject to the conditions that are listed in the staff report.
Second.
Mr. Owen.
So it's almost midnight and we have a long meeting and we have many more cases to go. And one of the things that I had planned to discuss tonight is a novel interpretation of the use permit conditions that relate to significant trees and foliage, which was rolled out for this meeting tonight, that basically seems to say that so long as you don't chop down a registered tree, that it's all good. So 17 trees, including several large caliper trees that include trees that are providing shade to the public at the sidewalk and so forth, doesn't matter as long as it's not a registered tree. I think that's an extreme interpretation. I disagree with it. I was preparing to make a stand on this particular application, but you lucked out. It's too late to do that. We've talked about too many other policy issues, so you get a pass. And I'm going to vote for your project, but I want everybody else here to know that it doesn't mean I agree with what staff said, and I'm going to fight it another day.
Okay. We do have a motion, right?
I did make a motion, and I think Ms. Malice seconded.
That's what I thought. Okay, Mr. Smith moved, Ms. Malice seconded, and a motion to approve. All those in favor?
Aye.
Thank you.
Thank you very much.
Next case, please.
Case number V-11333-17-UP-1 is a use permit by Mark and Catherine Bontrager, owners, to permit a front setback of 20.7 feet to a front porch instead of 21 feet as required, regarding a new front porch on a single-family residence in the R6 zoning district, premise known as 2772 Fort Scott Drive. Staff recommends that the board adopt the attached resolution approving the subject use permit with conditions. And I'd like to please note that there is supplemental material for this case in your supplemental package. It is a letter from the owner detailing some of the outreach to his neighbors.
Thank you. Questions?
Madam Chair.
Mr. Owen.
Is it true that if the applicant's porch were 4 inches farther from the street, that none of this would be required?
Yes.
Okay.
Thank you. Mr. Isaac?
Yes, ma'am.
You're representing the applicant?
Yes, ma'am, I'm representing the applicant. And a clarification to what you said, there was a compressed time limit between the time I got this assignment to design the porch and the deadline for submission. Since there is no January hearing, we rushed to get it in for this. I was working at the time off of about a 60-year-old survey was what I had to go from. And by the time I got my surveyor to do all the surveying I needed, and I was designing the porch independently of that and feeding it back to him. Also, I must have misinterpreted the overhang used to be, to my knowledge, a part of the setback. It was what I was going from also, and it wasn't until I got the final report I realized we were only asking for 4 inches. If I had known that 2 months ago, I probably just shortened the porch for 4 inches and been done with it. But it was, I was saying, that compressed time frame, and knowing that it has that curve on it, I knew it was cutting into something we were going to do. I didn't know it was only 4 inches though. And that's really it.
Any questions for Mr. Isaac?
Madam Chair.
Mr. Hall?
When did you first learn that we were hoping that you would talk to your neighbors?
When did you first learn?
So you know that, you now know
Yes.
that we like it when you talk to your neighbors about this stuff. How long ago did you first discover that we want you to talk to your neighbors?
I've always known they wanted to talk to the neighbors. The owner didn't understand the best solution was to bring in something in writing.
Okay.
I say we were almost 2 ships passing in the night, and the message didn't quite get delivered properly.
How long ago did that get sorted out so that the owner knew that we prefer something in writing?
I think within the last week or the last day, because he called me about it yesterday. I said, I thought you submitted these letters. He said, no, I just talked to the people.
Okay. Thank you very much.
Okay.
Madam Chair, I'm prepared to make a motion. I move that in the case of V-11333-17-UP-1, that the Board of Zoning Appeals adopt the attached resolution approving the use permit, subject to the conditions listed.
Moved by Mr. Owens, seconded by Mr. Smith for approval. All those in favor?
Aye.
Thank you.
Thank you.
Next case, please.
Case number V-11334-17-UP1 is a use permit request by Samuel and Allison Corman, owners, to permit a front setback of 17.3 feet to the wall of an addition, 17 feet to the eaves, instead of 25 feet as required to the walls of an addition, 21 feet to the eaves as required, regarding a new front porch, new side porch, new second-story addition to a single-family dwelling, two-story addition to a single-family dwelling on a corner lot in the R6 zoning district premise known as 200 North Park Drive. Staff recommends that the board adopt the attached proposed resolution denying the subject use permit.
Questions for staff?
Madam Chair.
Mr.
Is my understanding that the relief that they're requesting to only encroach on a portion of the lot line and not all on the proposed addition?
That is correct.
Okay, thank you.
Applicant, please.
Hello. Good evening. Thank you. First of all, thank you so much, members of the board, Madam Chairman, Madam Chairperson, staff. You guys are incredibly patient and detailed. It has really been impressive to watch everybody stick with this process tonight. We moved into our house in 2009, 2010 during Snowmageddon. Our house is at a crossroads. If you look at the map, walking down to the Lubber Run Park and the Lubber Run Amphitheater, as we would learn later after the snow melted, pretty much every neighbor in the neighborhood will pass by our house on any given day when community events are happening. As we've made improvements over the years and as our family has grown, we've had everything from the kids across the street, from the families that are at the bus stop across the street to the people going to the shows, thank us for the improvements that we made to the house, because when we got there, it was a rusty chain link fence. It had been really left to dilapidate over time. And so we very much take seriously our responsibility of being in this crossroads, and our hope is that with these improvements, we will improve our ability to be in this crossroads and be part of the community.
Thank you. As my husband said, so just to elaborate a little further, we, as Shai said, really understand our commitment to the community, and we take it very seriously. Having a front porch has been something that's long been a dream of mine, and in fact, it's kind of a neighborhood joke that people come by and watch me reading on the front stoop, and they kind of say, "Oh, well, maybe someday you'll be able to sit in an actual chair in your front yard." So that's what we're here asking for. We want to continue to contribute to the neighborhood and engage with our neighbors, and I think that front porch allows us that opportunity to keep that conversation going with our neighbors and to make them feel welcome in our space always. We've spoken to all of our neighbors in the adjacent housing across the street, Kitty Corner, pretty much up and down the street, and have garnered support from each and every one of them. We've heard no objections from any of our neighbors about the proposed plans. In fact, most of them have just indicated they're really, really excited to watch the progress of our addition. And we noted in the report from staff that there was no concerns for the health or welfare of the community as proposed by this change, simply just that it was a bit unprecedented, but certainly not out of the realm of reasonable what we were asking. So we really appreciate your consideration of these proposed changes, and thank you. We're happy to answer any of your questions.
Madam Chair.
Mr. Hall.
In the interest of moving things along, I'll say that this is an unusually shaped lot. The encroachment is less in reality than the numbers would suggest. There has been outstanding neighborhood outreach, as far as I can tell. Oh, there's a speaker. So guess what I'll say after the speaker speaks.
Okay.
Good evening, members of the
Sarah.
board. Yes, Sarah. I'm the architect on the project, and I'm here to answer your questions. I know from a zoning standpoint, the concern is the encroachment of the addition above the porch, as well as the porch, but hoping that there is some leniency in the fact that the house does sit at an angle to the front setback. A lot of the design intent is to maintain backyard for this family, so hoping that you can see the intention of building to the right side and sort of keeping it moderately in size with the neighborhood.
Thank you. Mr. Owen.
So as I was saying, I think that this is compatible with the neighborhood and does meet the criteria that we need to see for a use permit request, and therefore I move that the Board of Zoning Appeals adopt the attached alternative resolution approving the use permit V-11334-17-UP1.
Second.
Moved by Mr. Owen, seconded by Ms. Malice for the alternative resolution for approval. All those in favor? Aye. Thank you. Thank you. Next case, please.
Case number V-11335-17-UP1 is a use permit request by Thomas Walker Wood and Sarah Beth Wood, owners, to permit a front setback of 23.3 feet to the wall of an addition instead of 25 feet as required, and to permit a rear setback of 20.5 feet to the wall, 20 feet to the eave instead of 25 feet to the wall, 21 feet to the eave as required, and to permit a rear setback of 10.3 feet to the rear deck instead of 21 feet as required regarding a new two-story addition over basement and rear deck in the R6 zoning district, premise known as 1024 North Larimore Street. Staff recommends that the board adopt the attached resolution granting the use permit request.
Questions for staff?
Have you received any comments since this was published?
I believe the applicant can...
Okay. Can we hear from the applicant, please?
Thank you for your time tonight and considering our request. We moved in this neighborhood in middle of 2017. Love the neighborhood and envision expanding here. Part of this is the addition we're proposing, two-story to the right of the building. We've communicated with the neighbors verbally in conversation, and they're fully supportive over the last couple of months, and brought with me tonight the packet of support letters. So with that, again, I appreciate your consideration and time tonight, and I'm happy to answer any questions.
Madam Chair.
Mr. Owen.
When did you first learn that we were hoping for written evidence of support from your neighbors?
I'd say a month or a month and a half back, and we had conversations with a lot of the neighbors to make sure they were aware of the project, ran them through it, and made sure to get the written form in order before the meeting. Just not in time to submit it in the packet.
Thank you, it's very helpful.
Yes.
Other questions? Mr. Smith.
If there are no more questions or comments, I'd be happy to make a motion.
Please.
And it would be to adopt the attached resolution of granting the use permit in V-11335-17-UP1 and have that granting subject to the conditions that are listed in the staff report.
Moved by Mr. Smith and seconded by Ms. Malice for approval. All those in favor?
Aye.
Aye. Thank you. Next case, please.
Case number V-11336-17-UP1 is a use permit request by Khalil and Fern Andros. Owners permit a setback of 8 feet to the wall of the building, 6.5 feet to the building eaves from the Bluemont Drive right-of-way instead of 25 feet to the wall of the building, 21 feet to the building eaves as required, and to permit a setback of 8.9 feet to the partially screened porch, 7.8 feet to the porch eaves from the Bluemont Drive right-of-way instead of 21 feet to the porch, 19.5 feet to the porch eaves as required, and to permit a setback of 5 feet to a storm planter boxes from the Bluemont Drive right-of-way instead of 21 feet as required, and to permit a setback of 5.7 feet to the eaves of a detached garage instead of 10 feet as required, and to permit a separation of 5 feet from the wall of the garage to the wall of the main building instead of 8 feet as required, and to permit a separation of 3 feet instead of 4 feet between the garage eave and the main building eave as required, regarding a new single-family dwelling with front porch, side deck, detached garage, and planter boxes on a corner lot in the R6 zoning district premise known as 642 North Florida Street. Staff recommends that the board adopt the attached proposed resolution approving the subject use permit.
Questions for staff? Applicant?
Board, my name is James McMullen. I'm the owner of the property, and joining me is Khalil, and he is the contract purchaser of the lot. And briefly, I recognize for use permits, shape of the lot is not your governing issue, but as you can see, the lot is pie-shaped and challenging. And furthermore, I'll submit to the casual observer, I think for most of us, it doesn't appear to be a corner lot.
Where's the corner?
Yeah. But we understand the zoning administrator's designation as a corner lot. What we're asking for, wouldn't it be necessary, we wouldn't be here this evening if it were considered an interior lot. But because it is considered a corner lot, we've engaged in a lot of neighborhood dialogue and indeed movement, shrinkage, changing the detached garage, removing a deck and changing it to a patio, pushing back the front corner of the house so that what is there is a porch. We've tried to do a number of changes to respect the fact that it is a corner lot and in consideration of neighborhood concerns.
I'd just like to further add that we've lived in the neighborhood for 6 years. We live 2 blocks away from this property. I have a wife and 3 children, so we're looking forward to hopefully being able to stay in the school district that my youngest daughter would attend starting next year. And so to James's point, we've spent easily over 100 hours in dialogue with neighbors. We've taken a lot of feedback into consideration. They've resulted in some additional variances, so we can go through those as well too. But it's been our intent to really build a property that's in conforming with the neighborhood. And, again, our intention is to stay in the neighborhood that we've come to love.
Staff earlier had 10 signatures, and we just submitted an additional 7 that we were able to get. indeed from neighbors that are on adjoining or that very street.
I'm
Okay.
confused about that. Okay.
Okay, other questions of the applicant?
Are there any speakers after this?
Those?
Two? I'll wait until after the speakers.
Okay, thank you. James Reed?
Good evening. I live directly behind the house in question at 635 North Greenbrier Street. It's the sort of a large house at the end there, also adjacent to the bike trail. There are a number of items which have been requested in variance, and there's been a lot of negotiation by the potential owner about this with the neighbors, which we appreciate. I want to speak in favor of the ones that he did in terms of the garage and the setback between the garage and the house in order to meet the needs of and the requests of the neighbors in the neighborhood. I thought it was very generous of him to try to work with us in that area. The main area that I was concerned about was then the setback from the street there and the concern of how far that is in terms of the current house and et cetera. There's two aspects of it. One was the front porch, and then there's a corner of the house. The front porch, which is about, I think we requested 8 feet back, I have no problem with. It's a single story. Being a porch, I think it would be a fine addition. The only thing I was thinking about and had negotiations with them on was the corner of the house, which was about 8 feet back. And the question, and I agree that 25 feet per the standard would have made that lot pretty much unusable. So we're trying to come up with some agreement. We haven't come to a final agreement, but considering the efforts that he has put into coming up with a solution so far on the other aspects of it, I do not wish to hold up this approval process. I believe that he will still continue to talk to us about whatever he can have as a proper setback. If he can do anything more than the 8 foot, it would be acceptable to me. And if it has to be 8 foot, sorry. So thank you for your time.
Sir,
Thank you.
what is your address?
I'm 635 North Greenbrier. If you look at the map, I'm the last house on the next street over.
Got the map in front of me, but you had not submitted a written approval. Okay.
Thank you. Scott McBride?
I'm at 641 North Greenbrier, right next to Jim, right immediately behind. I want to emphatically support the fact, basically everything, with the one exception, the 8 foot corner, which Jim just talked about, everything else that's here. Khalil spent a lot of time with us, negotiating, talking with us. We're we think that they listened to us, and we came to a place where we're all very happy around the whole area of the neighborhood, so that's good. The one concern that is outstanding is that corner. It's a 2-story corner that's 8 feet they want from the running path. We've heard a lot of our neighbors be very concerned about that because there aren't any other close by houses that are that close to the running path, and people are afraid it's taking away from the beauty and the just the usage generally of the path. That being said, I understand Khalil has been in negotiations and discussions with Jim, and I do have faith that the two of them could come to something where there's an agreement that the neighbors would be happy with. So hopefully, I'm supportive of everything here, although I'm hoping with the 8, maybe that could be modified a little to just say the negotiations are ongoing and they'll come to something that everyone's pleased with. All right, thank you.
Thank you. Comments, questions?
Question for staff. The running path is Arlington County property?
It's a Bluemont?
That's the W&O&D, right? Or is that
Right, when
is
we-
this
It's a Bluemont.
W-O-N-D or is this Custis?
This is Bluemont.
Actually, it's the Bluemont.
Bluemont.
It's a Bluemont connector trail down to the W&O.
Is that Arlington County?
Yeah.
Yes.
Well,
The connector trail is Arlington County, or is it a part of the?
I think it's part of that Northern Virginia Parks. I don't know.
Whenever we have discussions about the trail. And they are the ones in charge.
Oh, okay.
So my question was, were they aware of this development and had they provided input into this project? given the concern I just heard about the proximity to the trail.
They have not provided input as a part of this process. It is possible that they have received the same notice that the other applicants received. I mean, the standard is that it goes to the property owner. I'm not sure who in this case that received the letter for that parcel.
Is this a parcel? I mean, is this a numbered parcel that has a tax map ID?
Know that it is.
I bet it's been dedicated, probably a dedication of private property that's now public property.
Yeah, so.
But it doesn't have a parcel.
I believe that's true because that probably feeds the determination of being a corner lot.
Yeah, so to me, there's a open question about compliance with
on this one?
the notification. I'm sorry, am I out of turn?
What?
Okay, we have another speaker.
Oh, we'll wait.
Mr. Stanford.
Thank you. I kind of had to fight to get here, but my name is Brad Stanford. I've been in Arlington for about 28 years, and I had the honor of appearing before this board last year when I was doing a renovation at 720 North Frederick Street, which is along catty corner across Bluemont from this property. And all I wanted to say was I recognize that you folks do a very good job and a very thorough job of looking at every aspect of lots, and particularly those that are corners like mine was. So I just wanted to say that that he came to me, that the owner came to me and talked to me. I'm perfectly willing to recommend what he is doing. I think that you recognize all of the setbacks that you have would make this inoperable. So I would just encourage you to grant as many of the setbacks as you can. I think that making this property useful and available for a house that is of similar value to the houses around it would increase all of our property values. Thank you very much.
Madam Chair.
Thank you, Mr. Ong.
So resuming what I was talking about before, we've had discussions before about whether or not under use permits notification is legally required or not. It's certainly our custom. And with many right-of-ways, there isn't a fee owner. You know, the center of the street is the center of the literal property lines, and there's just an easement. But here, I don't know whether there's just an easement or whether or not there's an actual parcel or fee owner, public fee owner. But one thing to investigate in the long run, which we've talked about before at our work sessions, is what do we do when there's significant public property abutting a site, and how should we handle notices in that case? So I guess that still remains an open question, and this is another good example of why, a particularly good example of how the Department of Parks and Recreation might have, or whoever, whatever government agency is in charge of this, might have wanted to weigh in. My next question is, in the view that we have of this site, this is a question for the applicant, I guess. There's a particularly tall-looking tree that is right on the boundary line, right above the boundary line between the Bluemont Trail and the sort of close to the middle of the diagonal line. So if you're starting from the cul-de-sac and going back along the Bluemont Trail, you go 2/3 of the way, and then there's a big tall tree going up. Is that tree staying?
We haven't done the full grading plan, and I know DES will get involved in tree removal. I think that one should be okay because it's, as you noted, it appears to be on the property line.
It looks like it's in your property.
Or close to the property line.
Right.
So, it's certainly in our favor. We try to preserve everything we can because everything we take down, we have to.
Right.
place.
So thank you. And you heard on a previous one that I'm upset about a novel staff interpretation of the tree preservation thing, and I gave them a pass, and I'm going to give you a pass too. But I think it is outrageous to say that we shouldn't care about that gigantic tree right next to parkland because it hasn't been on a registry. I think that that is not a reasonable interpretation of the zoning ordinance. So I hope you do preserve it. But fortunately, since you're after midnight, you get a pass. And if you saw it down, it's on your soul and not ours this time. But on a future occasion, I'm going to make a big deal out of it, and you can watch it on video or something.
Duly noted.
Thank you. I have a motion.
Madam Chair.
Mr. Smith.
In the case of V-11336-17-UP1, I move that the Board of Zoning Appeals adopt the attached resolution approving the subject use permit with the conditions that are listed in the staff report.
Moved by Mr. Smith, second by Ms. Miles for approval. All those in favor?
Aye.
Thank you. Thank you. Next case, please.
Case number V-11337-17-VA-1 is a variance request by Eva Hochman, the owner, to permit an addition to a non-conforming structure in an R27 zoning district regarding a new one-story rear addition to non-conforming semi-detached dwelling in the R2 zoning district premise known as 3717 6th Road North. Staff recommends that the board adopt the resolution approving the variance request.
Thank you. Questions? Applicant?
Hi, everyone. I'm a little confused as to how to proceed based on the last hearing for a duplex. I mean, I can tell you all my unique circumstances. I am a single mother. My son's father lives in North Arlington. I have a single income. I cannot afford to live anywhere else in Arlington without creating hardship for myself. I was going to add the addition to this property, which is very similar to other additions in the area, for my mom to come down and help me. This is creating a space issue for me that I assume is going to be fine. I have here, my party wall neighbor was here to support my appeal, but they were out of town, so I have an updated signature from them stating that this is what we did, as well as the folks on the other end of the driveway also that I share a driveway with supported the addition. My neighbors across the street, both of those homes are vacant. There's a lot of renters in the area, so it's a little difficult trying to track down who the property owners were, and people are constantly changing around there, but I figured since I had those two people to support it, I can sit here and try to come up with some 12-15 argument for why I think I'm unique, if you'd like. Or, I mean, basically right now it feels to me like the cart is sort of going a little bit before the horse, and I would really appreciate Mr. Melnick and Mr. Owen's help in contacting members of the county, because I've expended a significant amount of money for getting this variance and use permit hearing going, as well as architect, as well as, you know, getting all of this moving, and it's not disposable income for me. I think that in my mind, the way that we read the code and the way that I went and sat with Stephen multiple times trying to figure out how to proceed with this, it would have been just easier if I was told to just stand down until this was changed. And it seems like now I'm, you know, $8,000 in the hole because of it. So 16.25 defines my dwelling as non-conforming as it stands right now. In the variance request, there was number 3 saying that the condition and situation of the property is not so general reoccurring to make it reasonably practical. To formulate a regulation, that's the way it is currently defined. I understand that, you know, the board thinks that that definition should be changed. Is it my responsibility now as a homeowner who's, you know, expended all of this and is depending on it to make that change? Maybe you'll tell me. I hope that you will help me make that change. But in my attempt to convince you otherwise that I am so unique, I can tell you that as I wrote in the justification, the physical characteristic of my property, so not all non-conforming R27s have the same lot coverage. So in section 593B, it says that R27s are supposed to have 3,500
I'm
square
sorry,
foot.
could you slow down just a moment and restate which section you're referring to?
I think I found it in 593B. It says that R27 property lot size have a minimum of 3,500 square foot lot size. And my lot size is 2,483 square feet, which is approximately 30% smaller than a normal non-conforming R27 lot, which makes my situation unique to all other R27 lots because I know we mentioned some of the South Arlington houses, and I know that those lots are significantly bigger than what my lot is. Additionally, non-conforming R27 properties have a lot width of 28 feet. My lot width is 24.83, making it 11% smaller than a normal conforming R27 lot, which additionally makes it more unique and is justification in my mind for why I should be granted the variance and why my situation is unique.
Thank you. Questions, comments?
Yeah, I have a question for staff. Staff did their usual table of what else is going on in the neighborhood. And the last item on the table, maybe it's not staff. I guess it's the applicant. Maybe you were the one that presented this, but you said that 3723 North 6th Road has a 2-story rear addition that's by right. Is that on your block?
That is on the block. If you look at the picture that the staff attached to it, you can see where my house is. Do you want me to show you?
So you have to show everyone. So you can maybe refer to the thing that's on the screen, maybe?
So if you see up there, there's a red, it looks like an addition that's at the end of the corner, on the far side of the corner, so it's around the block.
Mm-hmm.
So that's a 2-story addition back there. And that was by right, I guess it was because it was on the corner.
Looks like a bigger lot.
No, it's an attached house. It's the same, but I don't know why they didn't need a variance, but that's the way it's listed in your reports.
It just looks like on the right side of that, there's more area.
But it's still R27.
But next to it is what you're proposing to add, that 1-story, similar to that.
The one I was looking at most particularly was the one that is 3 doors down on this photo to the left.
Correct. They have a 1-story, pretty much exactly what I'm proposing
All right,
to do.
and so I'm surprised that that was by right.
There was a lot of back and forth between Stephen and myself and the other staffers about whether I needed a variance at all or whether I just needed a use permit. So I'm assuming that that sort of back and forth was included at different times during different hearings, and some people had to get them and some people did not.
So thank you, that's very helpful. Can staff fill me in a little bit about how such a large addition was able to be done by right on that parcel?
I can't give you the specifics of how it was allowed by right. I can tell you that the table that the applicant has included is from a staff report that one of the predecessors of this position, Andrew Noxon, wrote for an earlier case V-10865-13-UP1, so from 2013. I tried to do some research to figure out how they were approved by right, as suggested by Andrew, and I was unable to find the permits for them. I did find a plat for one of the ones that you asked about specifically that made it appear that the addition was done in 1978. So I spent some time in the old versions of the ordinance trying to see if the specific portions of what are now 1625 existed back then. And for the most part, they did. There was one very minor difference, and it is possible that that difference allowed some additions to be done by right. It is a very minor modification. The difference is literally, the way it is stated now is that only one family are eligible. Before, it was only single family. And that leads to a discussion of whether one half of a semi-detached dwelling could be considered a single family residence. So it is possible at the time there was an interpretation that it was conforming and allowed an addition to be built without the need for a variance.
Is it also possible that some of these were built before 1950, in between 1939 and 1950?
So I actually looked at some of the old fire insurance record maps, which is our best way to try and see if some of them were built before 1950, and I didn't see a lot of evidence for that. So I can't say that none of them were, certainly, but it does appear that many of them were not.
Are there any by right addition options for this parcel, the one that the applicant has?
No.
Okay.
And that's because of coverage?
No, it's because of the location of the structure on the property is non-conforming in regards to the side setback required.
Okay. When you said that you couldn't find permits,
Yes.
investigating, does that mean that our records are inadequate or that they possibly were built without permits?
We're only required to keep building permits for 3 years.
3 years.
So if it was built by right, that those would have been destroyed a long time. You know, depending on when it was done, if they didn't need to get relief from anywhere.
But how come when I look at my land record, I can see every addition that was ever done to the house over time?
We don't have to keep building permit files. Because first of all, zoning doesn't keep those records. Those are kept by inspection services. We keep applications and any requests for zoning relief. But not all building permit records are kept.
There's
by
another
zoning.
way to ask the question, which is what if the neighbor said they've added too much onto the back of their house? I want you to inspect and see if there's a violation. How would you determine whether there's a violation if you don't have any paperwork to show how it was allowed to be built?
We would have to look and see what we have in the file and then ask them to produce something. So a lot of times, frankly, people's records are more can be illuminating to us. So if the homeowner has record of it with county approval on it, then they've demonstrated that they got approval to do it.
And if they don't?
Then we probably have to take action.
Why? I mean, how do you know that they're in the wrong?
There's all sorts of things that could happen. It's hard for me to say what or when, but some sort of documentation should be shown.
I guess based on this explanation, I am skeptical about the conclusion that that was by right. So I'm just saying that. I'm just skeptical. And you're not the ones who are asserting it, right? It's being borrowed by the applicant based on previous staff work that you guys didn't.
I think the assumption that's by right is that we don't have anything in our records that shows it got a variance.
Right.
So
But one thing is it could be totally illegal and have no paperwork, and the other is it could be totally legal and have no paperwork, and those are the two ways you can have no paperwork.
I just have one. I wonder if this is really a little bit confused because the use permit for the property requires a 25-foot setback in the back and a 10-foot setback on the side. So if you look at the setback for these two by right, it says 25 feet in the rear, 13.8 feet in the side, and 32 feet in the rear and 10 feet by side. So maybe this is really a use permit versus a variance thing, and it was somehow put in the wrong place in their report from my...
Well, yeah, another reason why that is unlikely is because use permits are relatively recent.
Oh.
They didn't exist until recently.
Okay.
But that was a good guess. Okay, thank you. So first of all, let me just say, thank you for being so patient to come so late. You're not even the last item, but here you are so late, and I'm sure it must have
Thank you.
all too.
It's a lot of trouble, and I think that we're all very sympathetic to the trouble you've gone through, and irrespective of how we vote, I think we all appreciate your good faith in approaching all this and the frustration that comes from feeling whipsawed by the process. So just want to say that.
Where are we?
Well, Madam Chair,
Ready for
without
more?
any more questions, I'd be willing to float a motion.
Please.
In the case of V-11337-17-UP1, I move that the Board of Zoning Appeals adopt the attached resolution approving the subject variance.
VA1.
I'm sorry.
VA1.
I was looking at the use permit. Let me restate that. 11337-17-VA-1. I move that the board adopt the attached resolution approving the variance request in this case with the conditions listed in the staff report.
I'll second. Moved by Mr. Smith, seconded by Ms. Freshman for approval.
So could I have a discussion?
Certainly.
And I too, definitely understand the effort and cost that's gone into this, but I'm not sure, in good faith, having voted down the quirks on their variance request and their use permit, because their lot was actually smaller than if it was less wide. So, the same rationale that we voted down the quirks, I do feel like I need to do that just to be consistent and, just how I feel about it. So anyway, that's, just for the sake of consistency and rationale. So I just wanted to bring that up.
Thank you. Okay, it's moved by Mr. Smith, seconded by Ms. Freshman. All those in favor of approval? Aye. Nay?
No.
It fails.
Madam Chair, I move, is there an alternate resolution? No. Madam Chair, in the case of V-11337-17-VA-1, I move that the Board of Zoning Appeals deny the variance.
I thought we just did that.
Use permit.
We did deny it.
No, the motion failed.
The motion to approve failed.
We have to have a motion to deny.
I thought it was 2-3.
Well, you don't need one to deny it. It's already.
But
it's
3
gone.
people voted against it.
It's gone. She applied.
That's not how we usually do it. We usually come out with a resolution that is approved.
Okay. Go ahead.
I move denial.
And I'll second.
Moved by Mr. Owen, seconded by Mr. Melnick for denial of the variance request. All those in favor?
Aye.
Opposed? No. Next.
Case number V-11337-17-UP1 is a use permit request by Eva Hochman, owner, to permit a left side setback of 7.3 feet to the wall of an addition, same as existing, instead of 10 feet as required, regarding a new one-story rear addition to a non-conforming semi-detached dwelling in the R2 zoning district, premise known as 3717 6th Road North. Staff recommends that the board adopt the attached proposed resolution approving the use permit request.
Question for staff?
Yes.
Am I correct in understanding that unlike the property at Route 50, that there's no possible value to this use permit if there's no variance? There's no version of events where a use permit's still useful, is that right?
Correct.
There's a speaker. Lauren Trocchio. Lauren?
My guess would be that may be the adjacent neighbor that had to leave earlier that the property owner told you about in the last case.
Okay.
Madam Chair, I move that in case V-11337-17-UP-1, that the Board of Zoning Appeals deny the request.
Moved by Mr. Owen, seconded by Mr. Melnick to deny the use permit. All those in favor?
Aye.
Opposed?
And once again,
No.
and again, just to be perfectly clear, I think your request was totally reasonable and that the zoning ordinance should be changed to accommodate it.
Next case, please.
Our final case of the evening is case number V-11338-17-UP1, which is a use permit request by Haja Zahid and Zahid Yusuf, owners, to permit a rear setback of 0.5 feet to the eaves of an accessory building for an existing garage instead of 10 feet as required, and to permit a rear setback of 3 feet to the eaves of an addition, a carport, to an existing garage instead of 10 feet as required, and to permit a setback of 3.5 feet to the eaves of an addition, garden shed, to an existing garage instead of 10 feet as required, in the R6 zoning district, premise known as 3140 17th Street North. Staff recommends that the board adopt the attached proposed resolution approving the subject use permit. And please note that there is supplemental material for this case. There's a packet put together by a neighbor in opposition.
Questions of staff? Applicant, please.
Hi. Madam Chairman, members of the board, thank you for the opportunity. Hajra, my wife, and I, we have called this property home since 2004. Both our kids were born during this time. Both started walking in this house. What attracted us to this back then was the architectural appeal, and they enjoy the sunset from the sunroom. It's one of the smallest houses in the neighborhood, if not the smallest. A few years ago, we did a renovation for the sunroom. We paid a lot of meticulous attention to keeping the architectural appeal, which was endorsed by dozens of neighbors after that we actually have enhanced the appeal. We have put in the same level of care and effort. This house is set back almost 40 feet from the front, which really limits our options on the back side. And what we are proposing with the help of our architect, unfortunately, I apologize, he had to leave because of kids. This is the most optimal solution. By combining the shed with the garage, we're making it more conforming and at the same time reducing the footprint. And the carport we really need for our new car. At the same time, we absolutely love the tree we have. It's a mature maple. We will hate to lose it, but otherwise it's causing a lot of damage to the vehicle. By doing so, as we are proposing, we are not impinging on anyone's privacy or air or light or any other use. We respectfully request you to approve our request. Thank you.
Thank you. Questions of the applicant? I have a speaker, James Solomon. Is there such a person?
I apologize. He had to leave because of kids.
I totally understand that. Meredith Williams?
Hi, I'm here today to provide you with 5 objective reasons why I believe you should deny this proposal and to demonstrate how the applicant's proposal to build a 45-foot wide carport is not compatible with the development of the surrounding neighborhood. My first point on why it's not compatible with the surrounding area is because it creates a 45-foot wide structure across the rear property line that is wider than the primary residence on the lot. It effectively creates a 12-foot high fence along the shared property line. Second, it is not compatible with the surrounding area because the structure is not in scale with the primary residence. It actually exceeds the entire width of the front of the house. No garage in the staff sample report exceeds the width of the primary residence. My third objective reason why you should deny this proposal is because the placement of the structure is not compatible with how other garages in the surrounding area are placed. For example, 3 garages in the sample are not adjacent to another home. They're adjacent to a broad alley that that's separating the property lines. This is very different from the applicant's plan to put a 45-foot wide structure along a shared property line. Fourth, the proposal is not compatible because it has one long, uninterrupted roof line with no articulation. It lacks architectural elevations that relate to the primary residence, unlike the samples from the staff report. And fifth, the structure's not compatible because it would create a carport. No property in the surrounding area has a carport. The staff report information you're given was out of date.
Thank you. Questions for the speaker?
Madam Chair,
Mr. Owen?
did you only get up to 4 of your 5
No,
points?
she said 5.
All right.
Yeah, I got it.
Thanks.
Thank you.
Thank you. Thank you. Comments, questions?
What was her address?
She's right behind.
We have objections at 3136, and are you 31?
I have a question for staff. Is there a by right option to do something similar that the applicant would have available if this use permit were denied?
They do have a by right option to do a detached structure on the property. It would need to be 10 feet off the rear property line. I can't say for sure whether that may or may not.
Probably 8 feet from the house, too.
It needs to be 8 feet from the house. I can't say for sure whether that would become problematic.
Right. Okay.
Madam Chairman?
Mr. Smith?
5 feet from the right of way.
A question of staff. So your records show a garage that was 4.2 feet from the rear property line, but there is now a garage there that's a half a foot from the property line.
That is correct.
And do we know how that came to be?
We do not have record of it, is all I can say.
Let me ask the applicant, Mr. Zahay, you say you lived there since 2004?
Yes, sir.
So did you build a new garage?
No, sir, it's the same garage that we bought it. We have done repairs on it. We changed the roof, changed the windows, but no, it's the same.
This staff report?
Yes, sir, I have.
You see where it says in that existing conditions, in the last recorded plat staff has on file, the detached garage was located 4.2 feet from the rear property line, 9.3 feet from the side property line, and the small freestanding shed is not represented. The applicants claim that prior to his purchase, 2014 or 4?
4.
2004. Okay. So the staff report says 14, but the garage, prior to your purchase in 2004, the garage was expanded to its current configuration with the wall back. So you haven't torn down and built a new garage?
No, sir.
You say you did roofing?
The section of this is closer, the rest is still there. I had these discussions.
Wait.
Sorry.
So you moved a wall back?
No, sir.
What did you do to the garage?
We changed the roof to match it with the original house has slate roof. This one has,
Just the slate roof. What else?
and we changed the windows.
And the windows?
That's all we did to in the door.
So that was done, okay, that's fine.
There
Madam
was
Chair.
an additional discussion which might be helpful with staff, that they saw some evidence of a permission granted in 2003, but those records could not be located. That is before we purchased the house.
My observation when I looked at the property this last weekend was that there's the roof line, and for the outbuilding, there's a main roof, and there's like a sliding glass door on one side, and so that's sort of the white painted part, and then there was another smaller sort of add-on to that, it looked like.
That is the plastic shed, pre-manufactured. We put that there right after purchasing the property. What was there was a very dilapidated structure.
Okay.
And we had that removed. We had flooding problems and other issues.
Yeah.
So that was removed, and that portable plastic structure was put in there either end of 2004 or early 2005. We are proposing to remove that now and blend it with the garage, which our architect also felt will blend in much better with the architecture of the house.
So my question to staff is that plastic shed considered a structure? Is that part of what's measured as part of the existing condition?
That detached structure is not shown on, again, the most recent certified plat that we have for the property. It is shown on what the applicant is showing as the existing condition for the property, but again, not on that most recent certified plat that we have for our records.
So, as I look on this document that's labeled existing site plan.
Yes.
Where this outbuilding is located, what I see is something that's very roughly shaped like a plus sign.
Yes.
It's not shaped like a rectangle.
Correct.
And so what I think I saw was the bump out nearest the property line of that plus sign.
Okay, that's different than I think the applicant was speaking to.
Do we have a slide that shows?
We have some slides that show the property. Okay, stay right there. I think this shows that separate, very square, 8.2 by 8.2 shown on that drawing, in the left picture above. But it's not what you're talking about, which is a bump out to the rear.
Right, and so on the right-hand drawing,
yes,
it looks like that's where the bump out is.
Correct.
And so that does look like it's depicted in this plat.
Yes, both of those are depicted in the existing site plan drawing.
I see. But there's not a permit for something closer than about 4 feet from the property line.
Correct.
Okay.
Other questions?
But I'm looking, and Madam Chair, I'm looking at these plats. They're from 2001, so they do predate the applicant's ownership, but they show two different positions for the garage. And one shows the little structure and the plastic shed, but the other doesn't. 20. So you submitted both of these, didn't you? These two plats that are shown here. One says existing site plan on the bottom, and the other is a land survey. You submitted both of these, right?
The first one is from the county records, from the time from before we purchased it. This one, the very first one.
With the George Quinn's license stamp on the bottom. County records?
Exactly. That is what we obtained from the county records. We had it redrawn to show what is actually there.
Okay.
But the date on that is 2001?
Yeah. How did that happen?
Which one?
Okay, you see down at you have the report in front of you?
Yes, I do, sir.
When you look down at the bottom, where the kind of the titling, it says plat showing house location on lot 625, section 3, Line Village, data scale 1 to 20, and then it says November 6, 2001. Then you go to the one that you got from the county. And
you're saying they have the same date?
It's exactly the same typeface and print, it's just a little bit larger on yours, like it's been blown up slightly, but it also says November 6, 2001. So,
Guys, if that is an oversight, I guess they changed it to show what is actually there, and maybe didn't work on the date, so when it was updated.
well, there's some other changes too. I mean, because when you look at the house, the drawing of the house is different.
That is our, we had that 4 years ago.
It's a side plan, it's not a new survey. So they took the old survey
And drew over it.
Yeah,
Oh,
I mean,
and
it
that-
has
and
no
they-
seal, it has no,
Right. No, that's right.
so, right.
So this was recently done?
Yes, ma'am.
Okay, when was, okay, this is,
It's not a survey, it's just a site plan that used the survey as a base, I presume, and drew some things on top of it.
okay, so
To
that's
reflect the current-
existing, but
That's
it's
what- okay.
not the, okay,
That's fair
those
enough.
dates. And then the next one has the same date on it, it just shows.
They just copied and it probably whited out or erased or someone did, and
Right.
then drew what, maybe your architect or your builder
Right,
or
sir.
someone like
Yes, sir.
Okay. It's nothing nefarious.
Okay, can we move along?
Madam Chair, I got a problem with the size of it, though. The carport part, I have a problem with. I'm just going to say. And I too have not, I'm thinking of all the plans I've seen over the years, and I can't recall one that, first, I can't recall one isolated, a carport attached to a garage that's like not attached to the house. That's kind of odd to me, but I just think it's unusual. I don't, but that's my view.
Other comments?
Well, I think that the applicant is disserved by the hour. I think that if we had more energy, we would be engaging with their relationship with their neighbor and what the possibilities for compromise are, and the architect would still be here, because it wouldn't be so late. And I feel like the applicant isn't getting their money's worth out of our hearing tonight because we don't have the energy to engage the way
Perhaps
that we
we
normally
should
would.
defer it. Unless you prefer to approve it.
Well, I mean, I think we're in the position that we're in a lot of the time, not so much on this meeting. I mean, this meeting had a lot of other issues going on, so the audience didn't see what typically happens in these kinds of situations, but we send a signal sometimes saying what you're looking for is pretty far from what we're going to approve, but that doesn't mean that you can't make any changes, and we'd encourage you to talk to your neighbors about something that you could come forward with that has their support, that's more modest or impinges on them less in some way. As is clear from the record, many homes in your neighborhood have these detached buildings, and you have one already. You just don't have exactly what you would like, but what you're proposing, it appears, the view of the board appears perhaps likely to be that your neighbor has a point, which is that there's too much damage to your neighbor's enjoyment of their property because of how big this would be in their vision. So the question would be, and it would be easier to answer if your architect was here, what are the alternatives? Are there smaller versions? Are there versions that are turned in a different direction, that are placed in a different part of the parcel? Usually those kinds of questions are best addressed in consultation with neighbors. Sometimes the neighbor relations are such that it's broken down so much that asking you to talk to your neighbors more and get their support actually is counterproductive because it just makes everyone angrier. And that's a tough question to ask at 5 minutes of 1 a.m. Because we're all angry because it's 5 minutes of 1 a.m.
I'm not angry.
Well,
I'm
I
not
don't.
angry,
Right, but you get my point, right? We're all not in our best right now. So that's sort of where we often land in these situations. And so the question is, if we're moving in that direction, how do we best serve you and your neighbors under the circumstances?
Because, just to follow up on that, because the flip side is, we'd like a better understanding of what where your neighbor's tolerance is. You know, you've expanded the garage in both directions. You know, you've replaced a low shed with a tall structure, and you're also expanding to the other side. It would be good to know if one side or the other is less objectionable. You know, where exactly, right now your neighbors just don't support it at all. And what we're looking for is there some specifics as to what would be less objectionable versus, you know, or what's a deal breaker versus not a deal breaker. I'm not sure, you know, that Mr. Smith has said that he feels it's too much. You know, we could go the other way, and so I think the neighbors also need to hear that we're undecided. So if they have a view that seems reasonable, that you could work with, we might go there. If the neighbors had a very unreasonable view, you know, nothing changes, nothing goes, then we might go in a different direction. So it's not a statement of that we would take one side or the other, but we would like to see if between the two of you, the three of you, I guess there's another neighbor involved, you could at least identify what the issue, if you can't come to an agreement, at least identify what are the really strong points that you have in terms of what you need versus what are the strong points that the neighbors object to.
The neighbors don't have a veto. They don't control the outcome. That's up to the board for us to decide in our judgment. But we usually learn from the neighbors key information about how their property is affected, and we are required to consider how their property is affected. And so they're usually pretty expert on how their property is affected. So they have an important role, even though they don't have a veto. The one downside to postponing is that we might send you guys to all talk to each other, and then it turns out you spent a lot of time doing that, and there's really no solution that's workable, right? And that you come back to us and you've made changes. You already have staff support for what you already had, so they don't have a lot of suggestions for you. And so you come back and you've made another offer, and then we still say no, and then you feel like you wasted even more time, right? So that's a potential risk. So part of the question is, what do you want? There was somebody you saw earlier where we said, do you want to talk to your neighbor? And he said, forget it. I don't even want to. I'm done. You know, maybe he's going to sell his property. I don't know what. But, you know, but he said, I just don't want to bother to do that. So in a way, it's kind of up to you about whether or not you would like the opportunity to have further discussions and explore that, recognizing that there's a possibility that you might come back even without neighbor support and we might say yes to something different. Or you might come back with a different configuration with different statements from your neighbor. Maybe one neighbor supports now, but the other one still opposes, you know, who knows? And we might still say no. So it's uncertain what the outcome would be. So given that uncertainty, would you prefer to get an answer tonight and just be done with it? Or would you prefer to have a delay to discuss those options?
What do you think?
I think, thanks very much. One thing I would like to add is that one of the arguments that our neighbor made, in my mind, is not quite valid because their house is quite elevated. Their main floor is actually at the same height as our first floor. So as my husband said, ours is the smallest, one of the smallest properties in the neighborhood. And so I don't know, even if we speak to them, you know, whether it'll resolve any point.
Do you feel like you don't want this matter to be deferred? You want us to decide it now?
Let's defer. If I may, we are more than happy to hear suggestions. I actually went twice personally to talk. As you are aware, 6 neighbors have endorsed it, which are all other houses around. At least one of the objections about water is probably can be discussed and alleviated because we have a separate drainage system which takes our water to the front as well. We have the same issue. None of our water goes towards that house. In fact, we had no water coming in from this property in the past. The county approved some 4 feet elevation of the grade, which is not in the records, which is why the windows of this house now start above the 8-foot high fence. This fence is 8 feet high on our side, and our garage gets flooded. So this is a new problem, and our front yard gets eroded because it's now taking water from this neighbor, which was not coming to us before, it was going on the other side. We had discussed other options with staff as well. We started with a separate carport, which we really need. One that wasn't going well with the architectural setup. It's one thing to say it's 45 feet, but when we look at the diagrams and the pictures, it's the most compatible option. And even the staff had suggested that it was done in direct and prolonged discussions on options, what could be done about it. If we do a detached one, we will be less than 25 feet from the street. So there will be another use permit or whatever the right terminology is needed for that. To 10 feet, we'll have to cut the tree. And we will no longer be 8 feet or 10 feet from the house because we have 40 feet in the front. So the options are really limited, and we spent a lot of effort with the architect to see how best it blends. And when, at least when I looked at it and several other neighbors looked at it, they actually liked what it would be going forward than it is today.
The neighbors...
Happy to look at those concerns, but if we can detach it, we'll be requesting a different leeway because then it will go less than 25 feet on the main road, and it will still be over there. We're happy to consider options, but I think we have already done that. We're happy to spend more time on that.
So would you prefer we decide it tonight?
The decision is affirmative, yes. I apologize if I'm digressing, but we can do everything on our part. It's already pretty much hidden behind the fence and the trees in that area. And the projection, one of the last pictures that we attached, shows that there's very little visibility of this garage from the street, which is probably why 6 other neighbors have supported who have all those houses around it.
I believe the neighbors that do not support it are the ones that are immediately affected. Is that correct? The ones right next door?
Which is this one, which is highly imposing on us. I don't know how, because the county documents don't even say that they are raising the grade, at least the ones that were shared with us. So as you can see, the windows are above the 8-foot high fence.
About what year was that house built?
Sorry?
About what year was that? In the last 2 years.
Built.
So it does seem very unfair, doesn't it, right? That a new house is built and it's got these tall windows and it looks directly into your house and it's big and imposing and it changed the neighborhood. And then you're doing something that you think seems more modest, and yet, there's interference coming from that. And that's a very understandable feeling of unfairness. Unfortunately, the way that we are required by law to view this, we have to take each individual piece that comes to us and evaluate it, according to the legal requirements. And so we are required, even if a property is itself built in an unreasonable way, we're required to view how it perceives the property. So that's what we're required to do, and we don't have a choice about that. So I don't mean to say that your feeling of unfairness is unreasonable. I think it's, as you describe it, sounds perfectly natural that other people who lived where you lived would have the same reaction that you're having. But that's not something we can take into consideration based on the legal requirements on us.
I think I'd like to give a positive spin to it because we have many passerbys who enjoy walking on our side of the road. We have genuinely tried to preserve the look and feel of not just the house but the neighborhood. So I'm sure that's what we intend to do in the future as well.
I've made a lot of motions tonight, so I'm not making one on this one.
I don't know
Anybody else?
what the sense of the group is. I sense that you don't want to have a deferral.
At the same time, in denial will probably be worse. So we are more than happy to discuss and work as well. I actually went twice. We wish we could have had more feedback then than at this stage, because we did consult others and modified and changed to the degree possible what could be done given the location of the tree, the house, and the overall sense of it.
Well, in the absence of, Madam Chair, in the absence of any other noise, I will move that in the case of V-11338-17-UP1, that the Board of Zoning Appeals adopt the alternative, I presume, resolution denying the...
There is no alternative.
Yeah, sir.
Well, I move that the Board of Zoning Appeals deny the requested use permit.
May I, sir?
We're moving
if
forward
deferral
now.
is an option, we would prefer the deferral, because we can certainly reshape the roof to bring it lower.
Withdraw my motion. I move to defer V-11338-17-UP1 to the March meeting of the Board of Zoning Appeals.
Second.
Moved by Mr. Smith, seconded by Ms. Morales for deferral to the March 2018 BZA meeting. All those in favor?
Aye.
Madam Chair, before, I would like to see you meet with your neighbors, sit down with them, and ask them, what changes can I make that might be acceptable? And listen to them.
Certainly.
And not worry about how tall their house is, which was probably built by right, which means they didn't ask for any special permission. They did probably, because I don't remember that case. Was that house built by right? So they didn't ask anybody for anything special, unlike yourselves. So you complain about their height, but they didn't come to anybody saying, please, will you give us a break? So you're seeking a break. So I'd ask them what might be acceptable to them, because what you're asking for, from my point of view, is unusual.
And the other side, too. The other neighbor, too.
Yeah, the thing to remind the neighbor is that this came with staff approval. Staff was already recommending approval for this. And so when that's the case, there's usually a high chance that something's approvable. And so it's in your neighbor's interests to try to work something out with you, because otherwise there's a risk that something could be approved that they didn't have a part in. I have to say, the way that this meeting has gone, the fact that it took us half an hour to get to this point makes me concerned that this might be one of those where we regret deferring it because there isn't progress and there isn't good communication. Other people you've seen tonight have misunderstood what we mean when we're deferring, that we're giving instructions to people. We're not giving instructions, we're giving opportunities to people. And there's no telling how it's going to turn out. So I don't want to create, on anybody's part, expectations about what will come, or that anybody has to talk to anybody. Nobody has to talk to anybody. It's only if you or your neighbors feel that you both have something potentially to gain from talking. Also your neighbors, it's good for neighborly relations to be talking. But
And if it
nervous.
falls apart, you can withdraw it, too.
Yeah.
That's right. You can also withdraw. You don't have to come back.
You don't have to come back if it just is a lost cause. You can just let the staff know that you're not doing that. But it's in your interest probably to give it a shot for the two adjacent property owners who have objected. See if you can work something out.
Okay.
Okay.
Try to make the best of it. Thank you for the advice.
Architect involved with them.
Did we vote? I think we did.
Someone who's doing plans, who can talk about the plans.
Madam Chair, why don't you just call for just for clarity, call for the vote again.
Let's vote on this, just because I don't remember. I'm too tired to remember whether or not we voted 3 minutes ago.
I hope the tape is working.
There has not been a.
Oh, God.
I move to defer.
Okay, it was moved.
Ms. Malice seconded.
Ms. Malice seconded. All those in favor of deferral to March?
Yep.
Thank you. Okay, that's official.
Good luck.
Thank you. We have November minutes. Ms. Young.
My only question on the minutes is on page 3 of the unnumbered pages. At the top of the page, V-11307-17-UP1 carryover, use permit request by Jeff and Larissa Powell. There's strikeouts in the caption, and I'm just not sure why there would be strikeouts in the caption. Usually strikeouts signify something the board did that the staff hadn't recommended.
I didn't have a better way to show that the applicants changed what they submitted and those portions of the request were no longer necessary.
I mean, I would.
It was advertised that way initially.
Exactly.
So you're sure.
If you have a recommendation for a better way to show that.
I would just say so explicitly.
Okay.
Just write into the minutes, the applicant did whatever they did to their application. And that way it's clear.
Okay.
And I would suggest that we defer these. I know you don't like that because we did it 4 times before and you don't trust us now. But I do move that we defer the minutes to the.
Let me try a motion to approve.
Well, so my reason.
But we don't have them on the agenda.
Well, but my reason for making the motion to defer is because I think we might do that a lot in the future and it would be worthwhile to get the wording exactly right.
Well, but I guess my view is that I think what the secretary did was perfectly appropriate.
All right, you're senior to me, so I'll defer to let you make your motion. We'll see if you have the votes.
I move the adoption of the minutes.
Second. Too slow. All those in favor? Aye.
No.
Okay.
Question before everybody goes.
Can we adjourn? Oh,
Do we do an annual report
no.
that
I don't
shows how
think
many cases we heard and compare it from year to year?
Staff might, but we don't.
Do you guys do an annual report of how many appeals we heard, how many? Do you do it? Will you do it? I mean, I'd like to know what's happening to the workload. Is it going up or down or,
Deferrals are adding to it, for sure.
I'll just note that tonight we got a lot of paperwork where we only got 1 copy. And what happened was it was given to staff. It was passed all the way down to Ms. Malice, and I don't know where it all went.
I retained as much as I could.
So there was a lot where they gave us, where they gave us 5 handouts. We all have it. But there was also some where it just went down the line. You have most of those.
The poster board, and there was one that was handwritten.
There were at least 5 different things that there was only 1 copy of.
Can we have a motion to, a motion to adjourn and you all can chat amongst yourselves?
Adjourn.
Thank you. Bye.
5, thank you.
practically Christmas now?